Veuillez vous lever. Président, veuillez vous asseoir. Aujourd'hui, nous en sommes à la deuxième journée que la Chambre de la Cour suprême des CETC se réunit à l'occasion de l'audience hier. Nous avons entendu les arguments Monsieur le greffier, merci de bien vouloir faire rapport de la présence de toutes les parties. Le greffier, Excellence, Président, Mesdames et Messieurs les juges. Aujourd'hui, toutes les parties sont présentes. Parmi nous, nous avons les co-procureurs nationaux, les co-procureurs internationaux sont également parmi nous pour l'accusé, pour l'équipe de la défense. Nous avons parmi nous Maître Kongson Hom et Maître Antaguissé. Et l'accusé Khieu Samphan est également présent. Pour les parties civiles, nous avons Maître Pik Hong et Madame Megan Hurst, et 5 parties civiles supplémentaires sont également parmi nous. Madame Yassarom, Madame Hang Hun, Madame Aokali, Monsieur Sumprati et Madame Yamsawan sont avec nous. Merci, Monsieur le Président. Le Président. Aujourd'hui, nous allons continuer sur le thème de la compétence de la Chambre de première instance. Hier après-midi, nous avons entendu les arguments des co-procureurs et ce matin, j'aimerais inviter les co-avocats principaux des parties civiles à présenter leurs arguments. Vous avez la parole. Bonjour, Monsieur le Président, Mesdames et Messieurs les juges, partis. Je suis obligé de passer une partie de mon temps ce matin d'entrée de jeu pour traiter des arguments pour le moins surprenants qui ont été faits par la défense hier. Les parties civiles ne peuvent pas faire des arguments donc pour porter la compétence de la Chambre. C'est très surprenant, tout d'abord, parce que je pense qu'il est difficile de concevoir des éléments encore plus liés avec les intérêts des parties civiles que la compétence de la Chambre. Pour les parties civiles, la portée, c'est ce qui détermine si les crimes que vous avez subis vont être le sujet d'une décision juridique. qu'il y ait une reconnaissance officielle de ce que vous avez subi et de voir s'il y a une possibilité de redevabilité pour les crimes que vous avez subis. Chaque fois que la portée se trouve réduite, eh bien, les parties civiles s'en trouvent lésées. Et bien évidemment, les arguments devant nous aujourd'hui sont tout à fait pertinents pour les intérêts des parties civiles concernant la certitude juridique dont j'ai parlé hier. Deux au paragraphe 80. La situation couverte par ce paragraphe est tout à fait différente de ce que nous avons sous les yeux aujourd'hui. Là, on voit des dépositions des parties civiles et des références ont été faites uniquement à une phrase. F 60/1/1 chươngដំពល់លេខ10យើងបានដាក់នៅសារ1ដែលយើងបាននិយាយអំពីវិសាលភាពហើយខ្ញុំក៏មានការដកស្រង់នៅក្នុងសារ de l'irrecevabilité. Donc il n'y a pas eu de changement de notre part. Alors, je vais donc m'interrompre maintenant, sauf si vous avez des questions. Nous avons fait part de nos arguments, donc F66.1.1, et également dans notre mémoire de réponse au paragraphe 43 à 47 et 115 à 117, 115 à 117. Concernant la question de la portée du dossier lui-même. Notre position reste que la plupart des arguments de la défense ont été soulevés bien trop tard. Des années après que la défense ait pris connaissance des questions et des années après que la première opportunité s'est présentée de chercher une décision judiciaire. Je vais commencer en répondant à certains des points qui ont été faits, mentionnés hier. Tout d'abord, vous avez demandé pourquoi que Samphan n'avait pas soulevé ces questions devant les co-juges d'instruction lors de la phase préliminaire, donc le paragraphe 14 du rapport. Hier, la défense a reconnu ouvertement que ces questions n'avaient pas été soulevées lors de la chambre préliminaire.
53និង54បានលើកឡើងអំពីបញ្ហាទាំងអស់នោះហើយនៅក្នុងមូលដ្ឋានទាំងអស់នោះមេធាវីការពារក្តីបាននិយាយថាដីកាសន្តានជួនរឿងឲ្យស៊ើបសួរមិនបានលើកអំពីបញ្ហាទាំងអស់នោះទេមិនបាននិយាយអំពីការធ្វើទរណកម្មឬក៏ការធ្វើបាបនោះឡើយយើងគិតថា
But more relevantly today, the defence could have raised arguments about this many years ago. It should have been obvious to them as early as 2008 that those matters were being treated as within the scope of the case. The documents notified to the parties during the judicial investigation included the following. Document E3/8350 is a rogatory report filed on the 15th of February 2008. It describes several witnesses who spoke about Krang Tachan. It refers to detention, interrogation, and systematic execution. It describes witness evidence which repeatedly refers to torture, interrogation, and starvation. And it speaks of illness and persons being buried alive. A further rogatory report, E3/8356, was filed around a month later on the 3rd of March 2008, also concerning Krang Tachan. It gave details of interviews with 4 witnesses. All of them speak about interrogation in Krang Tachan. All of them speak about inhuman conditions of detention in Krang Tachan, lack of sanitation, lack of food, shackling, disease, dehydration. All of them talk about conduct which could obviously be described as torture, including beatings during interrogations using clubs and rattan whips, and prisoners beaten to death during interrogation. In addition to these rogatory reports, of course, there were the written records of interview of the witnesses discussed in those rogatory reports, and we've been able to identify 9 of those which have material on torture, interrogation, or prison conditions. A site report, E3/5828, filed in September 2009, also mentions torture, interrogation, disease, and starvation. So, Your Honours, it should have been very clear from 2008 or 2009, when the defence received these documents, that the co-investigating judges were investigating torture and ill treatment of prisoners at Krang Tachan. If the defence believed that that exceeded the scope of the introductory submission, it was clearly open to the defence to request annulment under Rule 76(2). And if there was any doubt remaining that these matters were being treated as within the scope of the case, that must have been removed by the closing order, which clearly mentioned conditions of detention, interrogations, and torture in paragraphs 501-2 and 506-9. That, of course, brings us back to the arguments we heard yesterday about why the defence did not challenge the closing order. Yesterday, the focus was very much on Rule 74(3) and whether it was possible to appeal the closing order, and I will come back to that momentarily. But we also note that in addition to appealing the closing order in regard to other issues, on the very same day, the 18th of October 2010, Samphan lodged an application for a permanent stay of proceedings based on abusive process regarding the investigation stage. Now, unfortunately, these documents don't appear to be in Xylab. I've been in touch with the administration, but I haven't yet had clarification about how we can find those documents in Xylab. But the decision is available online, so I'll give the full reference. It's called Decision on Samphan's Interlocutory Application for an Immediate and Final Stay of Proceedings for Abuse of Process, and it's given document number 2, dated 12 January 2011. Now, in the motion which led to that decision, Samphan argued about a range of procedural issues relating to the pretrial stage. That document is not filed pursuant to Rule 74.3, and it wasn't limited to the subjects which are listed in Rule 74.3. And yet again, there is no mention of saisine being exceeded. And we've had no explanation for the defence of why that was the case. But I'll turn back now to the question of Rule 74.3 itself. The defence position on this seems to be that in 2010, the defence looked at the internal rules and discovered that it was definitively not possible to appeal the closing order in respect of the question of saisine. And that having identified this in the rules, they simply didn't try. Listening to the defence yesterday, an observer might have thought that Rule 74.3 expressly prohibits the defence from appealing the closing order on questions of saisine. It does not do that at all. Rule 74.3a says that the defence can appeal on matters of jurisdiction. The question, and we say it remains an open question, is what is meant by jurisdiction? Ironically, we are having this debate today in a session which is titled Jurisdiction. And the defence even argued yesterday that their objections constitute absolute jurisdictional questions in line with paragraph 31 of the Case 1 Appeals Judgment F28. So the question of what can be appealed from the closing order under Article 74.3a is a matter of interpretation. What does the word jurisdiction mean? It is true that the pre-trial chamber jurisprudence on this question is problematic. And it's true that the pre-trial chamber has generally spoken of Internal Rule 74.3a as allowing challenges to the court's personal, material, temporal, or geographical jurisdiction. And in some early decisions, the pre-trial chamber did find appeals regarding saisine to be inadmissible, although we say without giving clear reasons for that. But we also know that the pre-trial chamber has expanded its appellate powers beyond Rule 74.3, where that is necessary to prevent serious fair trial violations. That power has even previously been used to hear a challenge concerning investigations beyond the scope of the introductory submissions. That's the JCE decision D97/14/15, in particular paragraphs 32 to 34. And most significantly, we have a number of strong statements from the pre-trial chamber that it has exclusive power to review procedures undertaken at the investigation stage. At paragraph 134 of our brief, we've quoted a statement from the pre-trial chamber in the case for 2 considerations on appeals from the closing order. In case 3, the international judges made even stronger statements to this effect. That's in D66/27 of case 3 at paragraphs 123 to 129 and 267 to 268. Those statements take the position that questions about procedural defects in the investigation are not permitted to be ruled on by the trial chamber or the Supreme Court chamber, and therefore they must be dealt with by the pre-trial chamber. Indeed, that is the clear meaning of Rule 76(7). It says, in the English version, subject to any appeal, the closing order shall cure any procedural defects in the judicial investigation. No issue concerning such procedural defects may be raised before the trial chamber or the Supreme Court chamber. To the extent that the pre-trial chamber jurisprudence is somewhat unclear or contradictory, that is in part because very few defence teams have attempted to raise issues about Samphan in their closing order appeals. And as far as we've been able to find, the pre-trial chamber has never explicitly addressed the question of whether Rule 74(3)(a) should be interpreted in the light of Rule 76(7). We can't help but wonder, why did the defence not attempt to raise that very question and argue for a wide interpretation of Rule 74(3)(a)? How could they have known what the pre-trial chamber would rule without even attempting to persuade it? Your Honours, we say that Rule 74(3)(a) must be interpreted as allowing appeals on these issues. The internal rules need to be given an interpretation which puts those rules and understands them in light of each other so that they fit together. Rule 76(7) says that after the closing order, defects in the indictment are cured and cannot be raised before the trial chamber or the Supreme Court chamber. If Rule 74(3)(a) is read in light of that provision, then it is clear that procedural failings at pre-trial, such as allegations of exceeding the scope of the introductory submission, they must be appealable to the pre-trial chamber, because thereafter they are barred. Your Honours, the correct approach is a purposive interpretation, an approach which makes sense of the court's structure and its procedural framework, so that they hold together and advance the objectives which they seek. There are 2 points on this, really. The first is that the procedural framework strives for certainty and clarity before the end of the pre-trial stage. And the second is that the pre-trial chamber is the chamber given responsibility to oversee the judicial investigation. If there was a question about whether the co-investigating judges followed correct procedure in reaching the closing order, why would the rules intend for those matters to be left beyond the pre-trial phase? Why would the rules intend for those questions to go to the trial chamber rather than the chamber which is specifically empowered to oversee the investigative process? Why would jurisdiction, that term when it's used in Rule 74(3)(a), be intended to exclude jurisdictional questions arising out of investigative procedure? It would make no sense to prevent the defence from raising issues of Samphan to the chamber which is most appropriate to deal with those matters, and at the point in the proceedings where certainty could be achieved before the transfer of the case file to the trial chamber. So we believe that these sorts of appeals from the closing order are permissible. But in any event, even if we are wrong on that, wherever the pre-trial chamber has ruled that an appeal against a closing order was inadmissible, it has gone on to make the point that the issue should instead be put as a preliminary objection to the trial chamber. So it has to be one or the other. If the defence say that these matters could not be raised at pre-trial, that means they must have been able to be raised as preliminary objections, and they should have been raised as soon as they were known. The ultimate point is that in this instance, the defence did neither of those things. It didn't raise the questions before the pre-trial chamber, it didn't raise them before the trial chamber. If I understood Khieu Samphan's submissions correctly yesterday, then his position is this: that when an accused notices that the scope of the case is being exceeded, the internal rules require him to wait until the end of the trial to raise that matter. This would mean that we would hold the trial first and then decide subsequently which matters fall within the scope of the trial. It's hard to imagine any legal system that would be designed that way. It would be difficult to reconcile with the principle of legal certainty in Rule 21.1 or with Your Honour's ruling in paragraph 237 of the Case 2.1 appeal. Your Honours, I see that I'm at the limits of my time. I did have one short additional point which I had hoped to cover prior to having heard the defence's submissions yesterday, which I needed to respond to. I'd like to ask Your Honour's indulgence for a further 4 minutes or so, if I may.
You may continue.
I'm grateful, Mr. President. My final point concerns the prejudice which would arise if the defence were permitted to challenge the scope of the case for the first time at its conclusion. And as an example of this, I'd like to look at ground 39 concerning the geographical scope of charges concerning Tramcock Cooperative. Although the closing order speaks generally about Tramcock District, paragraph 302 mentions only 8 of the 15 communes of Tramcock. And the same issue arises in paragraph 43 of the introductory submission. The defence now says that charges relating to Tramcock District were limited to those 8 communes. But the defence was silent on this issue through trial, and the consequence was this. A significant amount of evidence was heard during the Tramcock segment which concerned events in Tramcock, but which occurred outside those 8 named communes. In particular, the trial chamber heard evidence concerning events which took place in Les Baux commune, Chiang Tong commune, and Popil commune, all in Tramcock, but none of them named in paragraph 302 of the closing order. Civil party Chu Kum Lan, civil party Sarun both lived in Les Baux and testified about their experiences there. They spoke between them over 3 days. Witness Niang Out, alias Tarsan, was transferred to Tramcock in 1977 and lived in Les Baux. He testified over 3.5 days. Witness Kuom Buen, alias Ye Buen, was commune chief of Chiang Tong commune. Her evidence covered Chiang Tong commune as well as Popel commune, where her husband was commune chief, and she testified over 2 full days. Witness Mia Soka lived in Chiang Tong commune. He testified about being a prisoner in Krang Chan, but additionally about conditions of life in Chiang Tong, and he testified over 3 days. I could continue, but I hope the examples make the point already, which is that the trial chamber heard days and days of evidence focused on events in Tramcock District which occurred outside the 8 named communes. It specifically identified civil parties and witnesses based on their knowledge and experience of those other communes. And throughout all of this, the defence was silent. The difficulty is this, Your Honours. The trial chamber had a limited amount of time, and each hearing day was precious. That precious time was used on these sources of evidence, people who had lived and worked in parts of Tramcock outside the named communes. Now, if the defence had raised its objection at the time, and if the chamber had agreed, other evidence could have been identified and heard about those 8 named communes. I've taken this ground simply as one example, Your Honours, and we make this point in order to demonstrate that our arguments about admissibility are not a mere technicality. There has been a very tangible prejudice if the defence is permitted to raise these objections late. The opportunity was lost for the trial chamber to hear from other civil parties or other witnesses who might have had relevant material in their knowledge. The trial chamber's ability to ascertain the truth, as required by Rule 85, would be harmed. We ask Your Honours to uphold the approach of the trial chamber and to rule that arguments about scope which were not raised at the first opportunity are inadmissible, and they must be dismissed on that basis. Thank you, Your Honours. That concludes my submissions, unless there are any questions.
Next, I would like to invite judge of the bench or judges of the bench to put questions to parties. The floor is opened. President, I'd like to invite judges of the bench to put the questions to parties if you have any.
One query that has been bothering me since the beginning of this appeal. Perhaps there isn't an answer. Is there an equivalent of estoppel by conduct in criminal trials? It's a difficult question, and you may not have the answer, but it seems to me that this is what you're addressing us on, that the equitable principle of estoppel could in some way apply to the conduct of a party in a criminal trial. Do you have any comment on that?
Excusez-moi, Madame la juge Clark, mais apparemment l'interprète a eu quelques problèmes à comprendre votre question et donc nous ne l'avons pas bien eu en français.
Seems there was some issue. Could you please repeat your question?
Ms. Hurst?
Yes, thank you, Judge Clark, for the question. In fact, it's our position that there is something very similar to a doctrine of estoppel on this issue. The question has come up repeatedly at the ad hoc tribunals, and there they don't use the term estoppel as such. The term which is more frequently used is waiver. So the principle as it's put is that if the parties remain silent, they have waived their ability to raise a point on appeal. And I think this is something rather similar to the concept of estoppel, in the sense that what happens is that the other parties rely on the silence of that party who knew of the issue and didn't take the issue at the relevant time, and that therefore they are prevented, because of the reliance of the other participants in the proceedings, from raising it later. So I would say that although the term estoppel is not used in the way that we would use it in our common law legal systems, the principle is actually very similar, and that is a principle which we've referred to in our response brief. I believe it's at paragraph 173 of our response brief, and the footnotes that are cited there. As we were elaborating our brief, we did have, of course, page limitations, so we've only really included one paragraph there, but the jurisprudence of the ad hoc tribunals does go into quite some detail on the principle, and it has been repeated in very many cases. I hope that assists, Your Honour.
I'm very grateful. Thank you.
Good morning, Your Honour. I would just like to add that our position is the same as the civil parties, that essentially estoppel and waiver have been used interchangeably. And in that regard, I would like to draw your attention to your appeal judgment in case 1, where, as has been discussed previously, you worked your way around some of these issues and discussed the difference between absolute jurisdictional challenges and procedural jurisdictional challenges. And in the context of that, at footnote 78, which is appended to paragraph 31, you discussed the issue of waiver, and actually at the bottom in the quote to the Sri Lankan court's jurisprudence, you speak that, or the court there which you cite speaks about acquiescence, waiver, or inaction on the part of a person may stop him from making attempt to establish that the court was lacking in contingent jurisdiction. Their contingent jurisdiction being used in a similar way to procedural jurisdiction in the context of this discussion. So I would say that these issues can be discussed in terms of estoppel or waiver, and indeed have been done so already by this court. Thank you.
Si je peux contribuer aussi, Madame la juge.
Madam, Your Honor, may
Perhaps.
in the paragraph that I quoted yesterday, there is no idea of this waiver idea that I do not understand in English, but in French it's very clear that when there are issues that can put an end to prosecution, they can give rise to objections at any moment, as paragraph states. Thank you.
If there is no more question, we will proceed to the next item of the agenda, and I'd like to invite the co-rapporteur judge regarding the grounds of appeals relating to the crimes for which Khieu Samphan was convicted. Thank you. Thank you, the President. Allow me to read the co-rapporteur report for the session on grounds of appeals relating to the crimes for which Khieu Samphan was convicted. The trial chamber found the accused guilty of several crimes against humanity, grave breaches of the Geneva Conventions, and genocide of the Vietnamese through his participation in the common purpose and sharing the same criminal intent of a joint criminal enterprise. He was convicted of the following crimes that were committed in the course of the implementation of the 5 policies of the Communist Party of Cambodia during the Democratic Cambodia regime. A. The crimes against humanity of murder, extermination, deportation, enslavement, imprisonment, torture, persecution on political, religious, and racial grounds, and other inhuman acts through attacks against human dignity, conduct characterized as enforced disappearances, forced transfer, forced marriage, and rape within the context of forced marriage. B. The crime of genocide by killing members of the Vietnamese ethnic, national, and racial group. C. Grave breaches of the Geneva Conventions of willful killing, torture, inhuman treatment, willfully causing great suffering or serious injury to body or health, willfully depriving a prisoner of war or a civilian the rights of a fair and regular trial, and unlawful confinement of civilians under the Geneva Conventions at S21 Security Center. The trial chamber also found that the accused aided and abetted the crime against humanity of murder with dolus eventualis at the Trump Cooperatives 1st January Dam worksite, Tropang Tmo Dam worksite, Kampong Chnang Airport Construction Site, S21 Security Center, Krang Tachan Security Center, and Phnom Kral Security Center relating to the death of workers and peasants at these cooperatives, worksites, and security centers. The accused now challenges all the convictions of the above recited crimes, raising both legal and factual errors. His arguments may be summarized as follows. Legal errors. The accused submits that the trial chamber violated the principle of legality by failing to apply the correct legal criteria in its examination of whether the crimes were sufficiently accessible and foreseeable to him. In 1975, the trial chamber's reliance on 3 factors in its analysis is disputed. Those factors were the existence of the crime or mode of liability in customary international law at the time of the alleged criminal conduct, the gravity of the crime, and finally the positions occupied by the accused as a member of Cambodia's governing authority. He asserts that the application of these criteria was an error of law which negates all the findings and convictions. This argument relating to the legal error regarding the principle of legality is mentioned in several other places in the accused submissions. The Chamber believes that challenges to the legality of specific crimes properly fall to be argued in this section on crimes. The accused challenges the trial chamber's legal definition of murder with dolus eventualis and submits that no concept of murder with dolus eventualis existed in customary international law in 1975. All findings of murder with this intent must therefore fall. The existence of murder with dolus eventualis in customary international law in 1975 was determined previously in the appeal of case 002/01. The Chamber would welcome some clarification on why this submission should be re-litigated. As an alternative to the many challenges to findings of criminal liability for the death of people resulting from working, living, and detention conditions at various worksites, cooperatives, and security centers, the accused argues that the trial chamber failed to provide a legal definition of culpable omission, which thus led to erroneous findings relating to death at those various crime sites. In addition, the accused argues that there was insufficient evidence for convictions beyond a reasonable doubt for any crimes against humanity of murder committed against the Cham and against the Vietnamese. Several related arguments challenge the sufficiency of evidence to establish either the mens rea and or the actus reus for the crimes of extermination, including the mass killings of the Vietnamese in Svai Rieng, Kampong Chnang, Worksite, Krati, and in Democratic Cambodia territorial waters, and the Cham at O Trokun Pagoda in 1977 at Tree Village. The accused challenges the trial chamber's definition of the constitutive elements of the crime against humanity of persecution on religious grounds, which he submits led the trial chamber to make erroneous legal and factual errors relating to the treatment of Buddhists and of Cham. Specifically, he argues that the trial chamber erred its definition of the mens rea for those crimes. The accused challenges the sufficiency of the evidence for the convictions of crimes against humanity, of political persecution of new people, former Khmer Republic soldiers, real or perceived enemies, or that the Cham were specifically targeted and subjected to discriminatory treatment. The accused challenges the findings of the crime against humanity of persecution on racial grounds of Vietnamese living in Cambodia, as he submits that Vietnamese in Democratic Cambodia were not a discernible racial group. The same arguments are made in relation to convictions for persecution of the Vietnamese through acts of deportation, arrest, and murder on the basis of their race and the requisite level of discriminatory intent. Several arguments relating to legal errors are raised regarding forced transfer, enforced disappearances, attacks against human dignity, rape, and forced marriage as crimes against humanity of other inhumane acts. The primary challenge concerns A. the trial chamber's definition of a law applicable to other inhumane acts, B. its failure to consider whether the facts constituting the crimes were sufficiently foreseeable to the accused by 1975. With regard to guilty verdicts relating to enforced disappearances generally, the accused challenges legal errors and factual findings, in particular whether Vietnamese were victims of enforced disappearances in Trump cooperatives and at Phnom Kran Security Center. It is disputed whether the trial chamber's finding that the Khmer Kram could be victims of enforced disappearances, as the facts relied upon were outside the scope of case 002/02, and whether that evidence of the treatment of the Khmer Kram was unlawfully used to convict the accused of enforced disappearances of the Vietnamese. Other inhumane acts characterized as forced marriage and rape in the context of forced marriages are challenged on the basis that those crimes were not sufficiently foreseeable to the accused, specifically in circumstances where neither act attracted criminal sanctions in Cambodian or international law at the time. He disputes the facts that marriage was absent. Consent was a principle adopted by the Communist Party of Cambodia, and the marriages conducted during democratic Cambodia approximated Khmer traditional arranged marriages. He therefore disputes the legality of his convictions under the title forced marriage. Following on from the convictions of other inhumane acts arising from forced marriages, the accused submits that even if the facts alleged are proved, they do not rise to the requisite level of gravity to qualify as other inhumane acts. Without prejudice to that key submission, he disputes the existence of any Communist Party of Cambodia policy to force people to marry and consummate their marriages to produce children for Angkar. With respect to the crime against humanity of enslavement, the accused challenges the trial chamber's jurisdiction to adjudicate facts in relation to particular sites comprising Phnom Kran Security Center. Further, he submits that the trial chamber erred in law by relying on insufficient and unreliable evidence to find that the crime was established. Similarly, regarding the crime against humanity of torture, he disputes the sufficiency of evidence to make a finding of torture against Cham detainees at the security center of Trier village. The chamber would welcome a focused argument on these challenges. With respect to the charge of the crime against the humanity of deportation of the Vietnamese at Tram Co, the accused raises the same argument presented at trial, that this charge was not contained in the French version of the Severance Annex. The trial chamber and the Supreme Court chamber have already addressed the error of omission, which occurred in the French translation of the annex, but was present in the Khmer and English language versions. The Supreme Court chamber will be assisted by an explanation for why the same matter has been repeated in this appeal. The accused further challenges the sufficiency of evidence to convict for the crime against humanity of deportation of the Vietnamese to Vietnam, and secondly, that the crime was committed with the requisite intent to forcibly displace victims over a national border. He challenges all factual and legal findings relating to the murders of Vietnamese and of genocide. The accused dispute the findings that murders of Vietnamese had been committed in various cooperatives and in territorial waters, and further that the crimes were carried out with the necessary intent to destroy the Vietnamese ethnic group. Lastly, he argues that Vietnamese detainees held in S21 and all consigned security centers or at sea were not members of a protected group solely on the basis that they were Vietnamese nationals. This concludes our report on the grounds of appeal relating to the crimes for which the accused was convicted. Thank you. The Supreme Court chamber would take a break now, and we will resume at 10:25.
on.
មជើងក្រោកឈរ សូមជើងអង្គុយ ជាបន្តសូមអញ្ជើញមេធាវីការពារ
Next, I would like to invite the defense team for Khieu Samphan to make submissions. You have the floor.
Bonjour Monsieur le Président, Mesdames et Messieurs de la Cour suprême. Compte tenu de la loi et de l'impossibilité de répliquer à l'accusation et...
Good morning, Mr. President. I will focus in today's intervention on the question of the genocide of the Vietnamese, the crimes of persecution, crimes against humanity and other inhumane acts and forced marriage, and given what time I have left, I will then respond to the prosecution. I would also like to specify that the reason why I'm concentrating on these three subjects does not mean that we are abandoning the news sources that we communicated in response to the statements of the prosecution and the civil parties. This being said, I will now speak to the question of genocide by murder of Vietnamese, and to deal with this forces us to return to the issue of the saisine and its consequences on the conclusions of the chamber. In paragraph 320 of the appeals procedure, the court says the co-prosecutors acknowledge their own confusion at trial with regard to the killings of Vietnamese outside Pre Vang, Svay Vang, and there's a good reason for that. It is a perfect example to illustrate the grief that we have with regard to the chamber in relation to facts. And in the first part of my intervention, I would like to recall our appeals brief, paragraphs 435, 438, and 520 and 521, where you will find all the references as to fact that I am discussing, and also our final submission in paragraphs 1878 to 1896 and 1932 to 1934, and there are also references to be found in the reply of the co-prosecutors, paragraphs 307, 321, and 342, when dealing with ground 60 and 80, depending on the way in which this was numerated. In the closing order, there is mention made of facts characterized by the investigating judges of murders constitutive of genocide, murder constitutive of crimes against humanity, and extermination constitutive of crimes against humanity. In this part of the closing order dedicated to legal characterization of the facts, there is no geographical indication. However, in the part of the closing order which is dedicated to facts, then we have and I quote, that they were seized of measures aimed against the Vietnamese in the provinces of Pre Veng and Svai Reng and during incursions in Vietnam. Then they developed two subsections, and I quote, massacres of Vietnamese civilians in the provinces of PV and SR, then massacres of Vietnamese civilians outside of the provinces of Pre Veng and Svai Reng. And the second subsection, which deals with events outside of these provinces, begins with the following statement: the massacre of Vietnamese civilians was not limited to the provinces of Pre Veng and Svai Reng, proving in this way that it was organized in the framework of a national policy at first sight. One therefore will understand that the investigating judges had been seized of the facts taking place in Pre Veng and Svai Reng and incursions in Vietnamese territories, and that they then went beyond that to demonstrate the existence of a national policy. And when we checked with the introductory brief, it is very clear that the prosecution seized the investigating judges exclusively for events taking place in Pre Veng and Svai Reng and during incursions in Vietnamese territory. This is all the more clear that before the closing order was handed down, the investigating judges had rejected the request of the prosecution and the civil parties to examine elements of evidence concerning crimes committed in other provinces, recalling, as, and I quote, if we refer to paragraph 69 and 70 of the introductory brief, the investigating judges were seized of the treatment reserved to Vietnamese living in the provinces of Pre Veng and Svai Reng and the Vietnamese during incursions in Vietnam. And the prosecution never offered a supplementary brief. So we can understand clearly here that the chamber was seized exclusively on facts committed against the Vietnamese living in Pre Veng and Svai Reng. And the severance removed the facts which occurred at the time of incursions in Vietnamese territory, at the request of the prosecution, in fact. But in its motivation, the chamber stated that it had been seized of these facts in the entirety of Cambodian territory. It felt that the proof was insufficient in the province of Pre Veng and initiated convictions for events in Svai Reng, but also in territorial waters in the province of Kampong Chang and a pagoda in the province of Siem Reap and Kratie. How did we get there? That is the question. A chronological presentation makes it easier to better understand and see how the process unfolded for those who were not attending from the beginning. I would like to recall that during the preliminary statements, and that was hearing E1 13.1, the prosecution pleads exclusively on Pre Veng and Svai Reng, and they briefly mention massacres in other parts of the country to mention genocidal intention in Pre Veng and Svai Reng. That's the only time they mention that. And in fact, they conclude on that day, 13.1, around 1428, ladies, gentlemen, members of the jury, there is no doubt that the accused shared this intent, and we will supply the proof of this, which will make it possible to establish that the systematic destruction of the Vietnamese population of Pre Veng and Svai Reng represented genocide for which the accused have full criminal responsibility. So this is what was said at the beginning of trial 002 prior to severance. So how did things evolve after that? At the stage of submission of evidence, everyone agreed to say that the elements of evidence outside of Pre Veng and Svai Reng are designed to establish a national policy, and the chamber had initially intended to hear 9 witnesses and 2 civil parties on the subject. But in November 2015, an E319 1/36, paragraph 11, the prosecution asked that new witnesses be heard and motivates it following. The deposition in the hearing of this witness, a former cadre of Division 164, Maritime of Regiment 140, is particularly important with regard to allegations relative to orders aiming to arrest and execute all Vietnamese captured at sea and the general policy of KD against the Vietnamese. We oppose this witness testimony, and here I would like to recall a hearing E1/360.1 between 9:37 and 9:40 in the morning. However, the chamber authorized this testimony and said that these elements had not been available prior to opening of the trial. And this is in E/363.1 around 1338 hours. Now, there's an objection of Nonchea's defense to resuming with depositions. What happened at the time? The international lawyer for the civil parties replied that the deposition of VC in Prac Dong was relevant for the policy of measures taken against the Vietnamese, and then added, around 1507, therefore, we simply ask you to pursue usual practice. What usual practice was he referring to? Well, there is a practice which was that of the chamber throughout the whole trial with regard to the Vietnamese, as well as the entire trial 02, which was to hear witnesses, including when they fell outside the scope of the trial. And it's not fault, of course, for me, for the Vietnamese. And the prosecution on that day confirmed that the purpose was to use this evidence to demonstrate the existence of a national policy. And this is what was said then. And this is E1/361.1 around 3:15 in the afternoon. And the response was somewhat blasé given the record of the chamber in this regard. It is relevant, or is relevant for the policy, but what I would like to say is that we don't have much time, and so I unfortunately am under the impression that, as usual, the chamber will reject the objection of my colleague from the defense team, and this is exactly what happened. Same hearing at 3:16, the chamber decided to reject the objection, stating, indeed, this is important for the policy. There is a policy that existed, and so this is what we said at the time. It was very clear that the point was to judge the accused for facts that occurred in Prey Veng and Svay Reng, and the response was to speak about the national policy. Now, this didn't stop there, of course. We tried unsuccessfully to oppose new testimony and new witnesses, particularly a request by prosecution, E381, which opened Pandora's box, actually, because at the time the co-prosecutors continued to state that this was in order to establish the existence of the national policy. And here I go to their charge E381, paragraph 9, which we placed in our own brief in paragraph 436 in its entirety. So we pleaded our opposition to these elements. We opposed the depositions of these three new witnesses, stating that all persons who had already made depositions had been heard on the issue of national policy, and that therefore the new witness was justified by the fact that the prosecution did not have sufficient evidence for Prey Veng and Svay Reng. And at the time, the prosecution reiterated that indeed it was Prey Veng and Svay Reng which were concerned on the issue of the charges against Khieu, Samphan and other accused at the time, but that the basic and fundamental line was to discuss national policy. And here I refer you to our footnote in page 376. And we had mentioned that the brief did not mention this. Unfortunately, once again, the chamber allowed the prosecution's request and heard the witnesses stating, and that is memo E380-1 and decision E380-2, that these depositions had relevance in regard of the policy against the Vietnamese. So, until that point, we continue for Preveng and Sveng Ray. We're not dealing with that in particular, we're dealing with national policy. And then came the pleadings. Our position was to recall
for the counsel for the defense, please slow down. Interpreter cannot catch up with you.
De la saisine
So the challenge to the saisine, which we stated in our final submission, were not linked to simple evidence. And we reminded the prosecution about the scope of the saisine, and we also said that the co-investigating judges were authorized to investigate only that which was characterized in the order. During final pleadings, we were told that they had focused in their brief on Preveng and Sveng with one exception. This was statement around 3:43 in the afternoon. At the time of the final pleadings, everything was mentioned except Preveng and Sveng, and this is what we said in our rejoinder in E1/526.1 from 921 to 929, pages 11 to 16. How did this slip-up occur? How did we drift? Well, because there wasn't enough evidence for Preveng and Sveng, something had to be added, and this was verified because in the motivation of the judgment, the chamber did not retain events occurring in Preveng and Sveng, except that upon reading this motivation, we find that the chamber felt that it had been seized with facts covering the entire Cambodian territory, far from PV and SR, on the basis of implementation of a national policy. And this chronology was important in order to understand the grounds for our appeal. The prosecution never replied on the issue of the initial saisine of the investigating judges, even though we are in a Roman or Germanic type of framework of law. And so since the prosecutors make an introductory submission, they say where they're going to go. They stated that they would focus on Preveng and Sveng. And I would like to remind you that in fact the prosecution finally couldn't prevent acquitting the accused on Preveng. Now, in 351, 3451, we're said there is no proof of genocide in Preveng. In paragraph 3455 and 3492, the chamber concludes that in Sveng there existed a suicide which it would not characterize because it was not included in the closing order, and then considered genocide in Sveng as being established on the basis of a single testimony, that of witnessing chair, concerning 4 Vietnamese families. So, Mr. President, ladies and gentlemen, members of the Supreme Court, this is the evidence that was submitted on genocide by murder, of which our client was convicted. So, hearsay about 4 Vietnamese families with no corroboration, no direct witness of the events, stated that she was informed of these events by people whose names she forgot. And contrary to the conclusion of the chamber in 3515, she never said that some Vietnamese had been arrested and detained prior to disappearing, because in hearing E1 361.1 around 327, she stated, and I quote, that the maltreatment which she witnessed was committed by Khmer against Khmer. She also stated that though she did see human remains, she was not a witness to executions and was not able to say who they may have been. This is during the same hearing, sometime later. So this is the proof and evidence on which the chamber relied in order to convict our client of the crime of genocide by murder. And this is why in our appeals brief we concluded that acquittal was necessary for lack of evidence. Lack of evidence because we didn't know who were the perpetrators. We did not know who had seen those families, who had executed the families. We also have uncorroborated hearsay, and so we could not conclude to genocide by murder. And the chamber should have been all the more aware of this fact that in paragraph 3486 of the judgment, it did not follow the same reasoning where there was again a hearsay witness without elements, and the court considered that it could not conclude.
It needed to use the witness testimony of Sin Shem, but it was not sufficient in terms of evidence, and it was not sufficient also in law. And now I need to look at the issue of persecution and genocide. I shall treat both aspects together because there are similarities, and I shall seek to respond as I move along to what was said by our colleagues of the prosecution. Now, the definition of persecution given by the chamber was an erroneous one because it did away with the objective to exclude, which is an essential element. To respond to our argument, the prosecution says, oh, look to the Duik judgment, which is quoted, and in a footnote of the Duik judgment, which says, in a general fashion, that the tribunals after the Second World War did not require that this condition be established for each one of the accused in respect of specific persecution acts for which they are declared guilty. The problem here is that no jurisprudence to support this conclusion is quoted. And this is a problem. So we need to look into the detail of the jurisprudence. And we need to look at the supplementary sources that we have supplied. And of course, the intention to exclude the Jews was fundamental to the declarations of guilt at the at the Nuremberg tribunal. And this is not the same as what our prosecutors are saying. We refer consequently not only to what we said in our appeal brief, but also to the sources that I've referred to, including the judgment of the International Military Tribunal and Eichmann, and we refer also to the doctrine that we've supplied that explains that the lesser forms of persecution become crimes against humanity when there is a will to exclude. And there is an article by Jérôme Meltil which is referenced in our sources. So where genocide seeks to destroy, persecution is all about exclusion. And the genocide aspect is the will to exclude to the extreme degree. I would also like to refer you to the analysis of the military tribunal, which were very clear in terms of the intention to exclude. So the exclusion of the Jews as a discrimination also appears in the declarations of guilt, and you can look at the judgment of Cicinta, of Frank, page 194, of Streicher, page 198. It's very clear here that the constitution of a crime against humanity in the form of persecution requires a discriminatory intention in the form of excluding the Jewish population of Europe, and that was the policy of the Nazis. And you can look at the paragraph 643 and following in that text. So there has been an error in law in the chamber. And you also have another source in paragraph 636, which says that genocide is the worst form of persecution via ultimate exclusion in the form of the exclusion of the group. And there is the doctrine appearing in Jurovic on this issue. The definition of persecution retained by the trial chamber is close to a de facto discrimination, as we said in our paragraph 254-256 of our appeals brief. Now, the issue of indirect discrimination is not a concept in international criminal law. Indirect discrimination does not require an intent of discrimination. It is incompatible with persecution, as we have described. I shall try to speak more slowly. The civil parties speak a lot about indirect discrimination. I should say, and I should recall, that the customary international law provision is not relevant because it is not international criminal law. The Jurovic judgment refers to the question of the choice of victims to be persecuted. And in any case, it would be necessary to demonstrate a discriminatory intent, and this has not been proven. I come now to the issue of the crime of genocide. Our argumentation appears in paragraphs 1059 and following. The Chamber has made a serious mistake in having an essential part of the crime of genocide seen in terms of its specificity and massive character, but in the file, no substantial part of the group has been targeted. Hence, I refer you back to what I've just said regarding Sve-Rieng, where, with just one testimony, the Chamber has found one murder the murder of 4 Vietnamese families and 1 suicide, for which we do not know who the authors are, and that we have a witness that was not a direct witness who spoke only on the basis of hearsay. We are told that there is no minimum threshold. I shall answer by referring back to the Judy Ditch judgment, paragraph 82, that quotes a major number of sources regarding the need to establish the massive character of the crime. And that judgment also quotes sources, many sources, including, importantly, the draft article of the International Commission with its commentary, and you have all that in our sources, in our brief. Another point that it would have been very important to prove, to prove an intention of genocide, it was not proven that the people killed were not chosen in terms of their impact regarding the survival of the group. This has not been proven. I refer you to the final report of the expert panel of the Security Council, and that appears in our sources too. In that report, there is a study on the question of preventing the crime of genocide, and it is said here, the expression in part seems to indicate a large percentage in relation to the group or a major fraction of the group, such as its leadership. So it's important to consider both the relative scale and the overall numbers. This was not demonstrated in the case at hand, particularly in respect of Sve Rieng. At any rate, the discriminatory intent of Khieu Samphan has not been demonstrated for persecution nor for genocide, and this is fundamental because there is an incompatibility between the dolus eventualis mentioned in the decisions of the Chamber that we shall look at later on, but also in recalling that the Chamber did recognize in paragraph 5715 of its judgment that it was essential to establish the responsibility in terms of persecution as a crime against humanity, that the accused had that intention specifically. Furthermore, and similarly in terms of genocide, the accused must also have to share the intention with the direct plan, and this must also be demonstrated as intentionality. This is mentioned in paragraph 693 of the judgment. Once again, the special intention required for the crime of genocide and the crime of persecution is incompatible with dolus eventualis, and we shall revisit this when we talk about the common criminal enterprise. I shall now speak to the issue of other inhumane acts. And refer to the fact that at the time of the facts, between 1975 and 79, forced marriages and rape within such marriages was not considered to be a crime against humanity, among other inhumane acts. The Chamber made a mistake in law by not applying the correct legal categories, and I refer you to our brief in paragraphs 1117 to 1155, where the elements of crimes against humanity must involve elements that are illicit, illegal under customary international law, and that there must be a moral element of the intention to inflict serious suffering. I shall concentrate on the first point of that's to say, the material element. So, first, how were other inhumane acts analyzed by the Supreme Court? The F36 in paragraph 1576, the Supreme Court first of all declared that at the time other inhumane acts were considered to be a supplementary category of crimes against humanity, and in this respect we agree. There has never been any misunderstanding on our part. The Supreme Court then recalled the natural tension in that concept, saying that to be in conformity with the principle of legality, this notion needed to be interpreted and applied in such a way as to limit the scope of this supplementary category, since etude imbenilis offers an essential guarantee in this respect. Then the elements of the crime were mentioned, the material element being the existence of an act or an omission of the same seriousness as other crimes against humanity. Hence, we're not only examining the legality of the category or of the crime of other inhumane acts in a generic fashion, as was done at the trial chamber, and as is insinuated by the other parties, but looking at the impartiality of the interpretation and application of the definition. And, by the way, the Supreme Court illustrates this point in paragraph 585, where it refers to examples of these instruments from the Conventions of Geneva and the Universal Declaration of Human Rights, and illustrates this articulation by saying, and I quote, "In practice, habitually, an inhumane act with a degree of seriousness reaches the same level as of other inhumane acts, with also violate fundamental aspects of human rights in connection with the relevant portions of the Geneva Conventions. The prosecution and civil parties neglect the essential counterpart, which is the need to identify the prohibition of the particular act. We are dealing with two very different things. And the civil parties and the prosecution are confusing things here. Now, what the Supreme Court recalled and called formal conditions of lawfulness or unlawfulness, the idea being to be clear about what is the nature of an inhumane act, while maintaining the balance with the principle of legality in respect of other inhumane acts. And there is an element of balance here that is neglected by the other parties. Contrary to what the other parties say, what the Supreme Court has caused formal conditions of unlawfulness, that is only the denomination of the grid for analysis of other inhumane acts which are based on international jurisprudence and on logic. Furthermore, interestingly, this analysis framework is also apparent in the analysis of the international investigating judge that we refer to in our appeals brief, and I refer you to paragraph 670. to 1104, 1110, and 1115 of our brief. And this analysis framework was comfortably ignored by the other parties. It's interesting to note that this decision, that the co-investigating judges and the Supreme Court do not necessarily use the same terms, but it's exactly the same reasoning. And I shall pick up again this reasoning of the international co-investigating judge to draw the parallel with what the Supreme Court has said. The international judge had a finding regarding the fact that underlying behavior was not necessarily constitutive of a crime in those years, 1975-79. Then he recalls the elements that constitute the crime. The nature and gravity must be similar to those of other acts. And in para 49, he says that international criminal jurisprudence shows that tribunals have sought to identify legal parameters that make it possible to identify the necessary behavior and then to be able to position this in terms of international law instruments in existence in order to determine whether the necessary threshold was achieved to qualify as another inhumane act. He also added in para 50 that the minutiae of the examination clearly showed the very prudent approach of international tribunals to maintain the principle of legality and the need to interpret very strictly criminal law and to work in favor, to find in favor of prosecuted persons. Furthermore, specific parameters needed to be identified to be able to find the underlying behavior, and this is also necessary to determine whether the fundamental exigencies of foreseeability were fulfilled. In the same decision, paragraph 52 to 62, there is a lengthy analysis that in paragraph 64 provides the conclusion that there must be a rule in customary law linked to the relevant human rights that is relevant.
Therefore, the investigating judge took on the approach which was adopted by the above-mentioned jurisdictions in order to verify whether there existed between 75 and 79 a broadly accepted definition as well as a customary rule of international law relative to forced pregnancies, and therefore that the facts of forced pregnancy could receive the qualification of AI. So the qualification or characterization of this approach enabled him to conclude that this crime did not exist in 75 to 79. He then looked at the international instruments that existed at the time. He also looked at the history of criminalization of this act. He also examined national law and current evolution and concluded in paragraph 76 that there was no criminalization in Cambodia and no general consensus. He noted that a forced pregnancy was not punished by law, and said that there was no fundamental legislation or acceptation of this practice in law to affirm that international law saw in the violation of this autonomy, gross violation of human rights between 75 and 79. So this this is the approach following the careful examination of the issue that he made, which is totally in line with what the Supreme Court had indicated as a means to consider these questions. And one can understand that as far as other inhumane acts are concerned, they must be circumscribed. There is a need to find an international customary law that condemned this at the time to find ground for convicting at this time. Therefore, establishing the breach of a human right is not sufficient, contrary to what the prosecution and civil parties stated. And so other inhumane acts is a general category, but it does not contain all inhumane acts, and therefore it is necessary to enter into a careful examination of this in international courts. And I would like to recall jurisprudence in our sources, the Popovich judgment, the closing order for Inchem, an opinion of the international judges of the pretrial chamber 0042D257/1/8, and all this is in our submission. And thus it is important to apply this grid of analysis for the period of 75 to 79 concerning behaviors relative to forced marriage and rape, stating that they could not be qualified as inhumane acts. At the time, between 75 and 79, the formal unlawfulness of this condition could not be proven in the absence of a rule of customary international law. And a reply of the prosecution and the parties to this focused on international human rights instruments and a few humanitarian law instruments protecting the rights of the family. The prosecution and the civil parties also raised a few elements of international humanitarian law. If we put them back in their context, the simple mention of the respect of the rights of the family will not demonstrate that forced marriage could be constitutive of a crime in 1975, and as a matter of between 75 and 79. And as a matter of fact, this is something which we put in our news sources. There is a statement by the General Assembly of the United Nations in 74 which states the opposite. It states, in fact, that it establishes a distinction between the respect of rights and those rights the breach of which was prohibited at the time. So chronology is important at the time. What does that statement say? That statement by the United Nations General Assembly. It lists what will be rigorously condemned or considered to be criminal in paragraphs 1, 2, 4, and 5. And what are we talking about there? We are talking about attacks and bombings of civilian population, use of chemical and bacteriological weapons, all forms of repression and cruel and inhumane treatment, imprisonment, torture, firing squads, mass arrests, collective punishment, destruction of homes, and forced displacement. Rights of family and forced marriage are not included. It must also be recalled that a national practice cannot be used to establish the existence of a rule of international customary law. That is found in Judgment 2.1 paragraph 805. And even if domestic law can, in fact, give reasonable information to an accused, but here I send you back to, or I refer you to paragraph 96. The prosecution is, in fact, showing a practice of penalization which is not widespread as opposed to its demonstration. There is no demonstration of international customary law on this issue at the time. Cambodian law in particular does not provide in the Criminal Code of 1956 in any way on the issue of forced marriage, but it is true, and here it's important for us to say that we were wrong. We didn't look at the Civil Code of 1920, which does indeed validate and requires consent. So the civil parties were perfectly justified in pointing out this defect in our presentations. However, this is not sufficient to indicate that we might be working with a provision requiring enforcement against forced marriage. And here, even though I know that this is an argument that we don't like to hear, the cultural context of arranged marriage is particularly important and must come to the fore. As of today, at the time when I speak to you now, forced marriage is not prohibited in Cambodian law, and in fact it is considered a crime against humanity in international law, in spite of the evolution of human rights. Today, in 2021, this is not the case. So if we apply the analytical grid which was set by the Supreme Court, and which is the same as the one that I have described in detail, we cannot conclude that there existed other inhumane acts, including forced marriage. And since forced marriage in 75 to 79 could not constitute a crime against humanity in this residual category, sexual violence perpetrated in the framework of such marriage could not either be prosecuted. So let's be clear. Let's be clear here, because this is something which was thrown at us in the replies. We never said, and I think the transcriptions are clear about this in our pleadings and different positions that we took. We never said that forced marriage or the fact that they have been consumed were not a violation of human rights, whatever prosecution or other or civil parties may say. But what we do say is that when these acts occurred, they were not considered to be of the same nature and severity as crimes against humanity, and that therefore they could not be characterized as other inhumane acts. It must be clear also that the sexual abuse in case was contextual, because the conservation of marriage is part of the institution of marriage, and it's also important. What the position of the closing order was, stating that, and how the Khmer Rouge and the Communist Party of Kampuchea considered rape, and stated the official policy of the CPK in the case of rape was to prevent a crime and punish perpetrators, even if obviously this policy did not manage to prevent a rape, and it cannot be considered that rape was one of the crimes used by the CPK leadership to implement its common project. It's different, of course, in the framework of forced marriage. And if we had managed to obtain the testimony of Yasmaru at the time, the fact that you cannot dissociate sexual violence from the crime of forced marriage as alleged, was recognized by the prosecution in E1 13.1, as well as in preliminary at 11:46 or later at 11:50 on the same day, or in the initial hearing of 0221/240.1, where it is stated that rape cannot be dissociated from forced marriage, and therefore, if forced marriage was not a crime against humanity in the category of inhumane acts, then the consummation of such marriage could not fall into that category either. So, this does not in any way represent a denial of the suffering of witnesses and victims as they testified during trial. It has to do with whether or not the chamber could, in fact, rule on these matters, and it could not. And it should also be recalled that the cultural context is important. And during the hearings, we heard that a vast majority of the persons who were married during that period were still with their partners or spouses. And I would like to recall that around 9:10, they said it's after the word force became an item in the agenda to be assessed in the ECCC that people began to get the impression that they were ashamed of speaking to their children about the circumstances of their marriage. They felt that marriage was not so much authentic, but they were worried about the degree to which they could discuss it publicly, given the manner in which their marriage had been depicted in the media. So it is important to recall this. And this is all the more important that the argument in our appeal brief takes on its full meaning in two other constitutive elements, which we won't be able to elaborate on right now, but which I would like to refer you to. One, facts with the same degree of gravity as the enumerated crimes against humanity, and the intent to inflict grave suffering, which I'm sure we will come back to when dealing with the personal responsibility of Khieu Samphan. But for the time being, I would like to refer you to paragraphs 1156 and following of our appeals brief. These are the points I wanted to discuss, and very quickly, since I see that I'm practically out of time, I would like to respond to the question raised by the Chamber in paragraph 32 of its report, to state that we have not stated that there was a translation problem in the grounds for appeal on the question of the deportation of Vietnamese. Oh, sorry, wrong question. Sorry, on the deportation of Vietnamese in Trong Quoc, that we had raised an issue only in regard of the fairness of the procedure, paragraph 115 of our appeals brief. This was not in the assessment of the crimes. What we indicated was that when a problem of translation had been raised during the debate, and that we did indeed observe that in the other two languages of the tribunal there was a mention which was not found in the French version of the text. We stated that in the hearing and recognized it, and in its judgment the Chamber did not even acknowledge the fact that we recognize this point. Once again, this is not at all a ground raised amongst our other grounds for appeal, but a way to show that even when there was a difficulty which we had not identified at the beginning, and that we were now identifying in the face of reality, and recognize that we had made a mistake which was caused by an error in translation, this was not even acknowledged by the Chamber. That was the sole purpose of our mention of this point. Also, on the question of slavery and the torture of Shramatri, paragraph 35 of your report, I would like to refer you to paragraph 1372 to 1379 of our appeals brief, where we clearly stated that there was an issue of saisine and that the chamber wrongly considered that prosecutions extended to control, and that we quote the closing order, which clearly stated that the crime of imposing slavery was to be raised only for case 11, and that there was an erroneous analysis of the evidence by the chamber because it indicated that there was confirmation of well, it stated that the written statement of a certain Omnol confirmed the deposition at the hearing of Kunnem, a civil party, and here I refer you to our appeals brief, 82 to 83, and we stated on this occasion that there could not be any corroboration because there were two different situations. And it's important to say that because it's important for us to recognize errors that we have made. We stated that we could not question or cross-examine the civil party because they mentioned Kromkrol only in their statement on suffering, which we said in our appeals brief, paragraph 682. This is a mistake on our part, and the civil parties were right to point this out, but what we do say, however, is that the chamber distorted the statement of the civil party, stating that it had been detained, paragraph 1373. And here I read what the chamber stated, even though the civil party was questioned on the conditions of work. The chamber concludes from the fact that this transfer to control was a form of punishment, that it was indeed detained. And so this was a partial use of the Kunnem deposition, and more specifically a distortion of what she said, because she never said that she had been detained, or he never said that he had been detained in Karum. He said that he had been transferred there and appointed there. And so I send you back to statement 788.1, a little bit before 1139, where he stated between 1438 and 1439, I was posted in counts. I was told to pick rice, and he says that this is the type of mission that he had, and that this is where his...
Que c'est incidemment que on a des éléments.
So it is only incidentally that we have this information on Kromkrol because this testimony is put in connection with the forced marriage category. And this fed into the civil party's work on all the various incriminated issues. So if Kunnem is referring to difficult working conditions, he's not talking about detention. And he's not speaking as a prisoner. Unlike the witness testimony of Onmol. And once again, I refer you to our elaborations in our brief as regards torture against the Cham in Tree. We simply state that the evidence is insufficient, and we refer you to our final text in paragraph 925 in our appeals brief, where it is explained that to make a judgment on torture in Tri based on a single witness statement is insufficient. That brings me to the conclusion of my statements, Mr. President. Thank you.
Now it is time for lunch. And I would like to inform all parties that we will resume at 1:30 p.m. I would like to instruct the security guards to bring the accused back to the detention facility and return him to the courtroom at 1:20 p.m. The court is now in recess.
ប្រជាជនយ៉ាងហោចណាស់1លាន7សែននាក់ត្រូវបានជឿជាក់ថាត្រូវបានស្លាប់ដោយសារការធ្វើការងារហួសកម្លាំងការបង្អត់អាហារការធ្វើទារុណកម្មសម្លាប់និងលក្ខខណ្ឌរស់នៅដ៏អមនុស្សធម៌ដទៃទៀតសំណុំរឿង002វគ្គ2គឺជាការជំនុំជម្រះដីទី2ប្រឆាំងទៅនឹងអតីតប្រមុខរដ្ឋខៀវសំផននិងអតីតអនុលេខាបកកុម្មុយនីសកម្ពុជាលោកនួនជាជនជាប់ចោទទាំងពីរត្រូវបានបញ្ជូនទៅជំនុំជម្រះក្តីកាលពីខែកញ្ញាឆ្នាំ2010ដោយសារទំហំនិងភាពស្មុគស្មាញនៃបទចោទនាពេលរស់រានមានជីវិតរបស់ជនជាប់ចោទឬក្នុងពេលដែលជនជាប់ចោទនៅអាចជំនុំជម្រះក្តីបានដែលការបញ្ជូនរឿងទៅជំនុំជម្រះត្រូវបានបែងចែកជាការជំនុំជម្រះក្តីចំនួន2ដែលហៅថាសំណុំរឿង002វគ្គទី1និងសំណុំរឿង002វគ្គទី2ការជំនុំជម្រះក្តីដំណាក់កាលទី1ផ្ដោតសំខាន់ទៅលើបទចោទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិដែលតាក់ទងទៅនឹងការជំនះដោយបង្ខំពីទីក្រុងភ្នំពេញកាលពីខែមេសាឆ្នាំ1975និងក្រោយមកគឺមានការជំនះពីតំបន់ដទៃទៀតក៏មានបទចោទតាក់ទងទៅនឹងការសម្លាប់អតីតទាហានសាធារណរដ្ឋខ្មែរនៅទួលពោធិ៍ជ្រៃនៅក្នុងស្រុកកណ្ដៀងខេត្តពោធិ៍សាត់អង្គជំនុំជម្រះសាលាដំបូងនៃអង្គជំនុំជម្រះវិស្សម័យក្នុងតុលាការកម្ពុជាហៅកាត់ថាអវតកបានរកឃើញនួនជានិងខៀវសំផនមានពិរុទ្ធពីបទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងបានសម្រេចផ្តន្ទាទោសពួកគាត់ដាក់ពន្ធនាគារអស់មួយជីវិតកាលពីថ្ងៃទី7ខែសីហាឆ្នាំ2014ទាំងការធ្វើមុខទៀតការធ្វើទុកបុកម្នេញសហព្រះរាជអាជ្ញាជនជាប់ចោទទាំងពីរបានប្តឹងសារទុកទៅកាន់អង្គជំនុំជម្រះតុលាការកំពូលហើយតុលាការកំពូលបានធ្វើសវនាការរួចហើយតាក់ទងទៅនឹងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង002/01ព្រមទាំងបានស្ដាប់សក្ខីកម្មរបស់សាក្សី3រូបកាលពីថ្ងៃទី2ទី3និងទី6ខែកក្កដាឆ្នាំ2015នៅថ្ងៃទី16 17 18ខែកក្កដាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលបានធ្វើសវនាការស្ដាប់សារណាផ្ទាល់មាត់លើបញ្ហានានាដែលបានលើកឡើងនៅក្នុងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង02វគ្គ01នៅថ្ងៃទី23ខែវិច្ឆិកាឆ្នាំ2016 អង្គជំនុំជម្រះតុលាការកំពូលនៃអង្គជំនុំជម្រះរាជសម្បត្តិក្នុងតុលាការកម្ពុជាបានប្រកាសសាលដីការបស់ខ្លួនលើបណ្ដឹងសារទុកប្រឆាំងនឹងសាលក្រមនៅក្នុងសំណុំរឿង002 វគ្គ 1 ដោយបានតម្កល់សាលក្រមរបស់អង្គជំនុំជម្រះសាលាដំបងផ្ដន្ទាទោសនួនជានិងខៀវសំផនដាក់ពន្ធនាគារអស់មួយជីវិតសំណុំរឿង002 វគ្គ 2 ដែលជាសំណុំរឿងបន្តពីសំណុំរឿង002 វគ្គ 1 មានបទចោទជារួមគឺឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងការរំលោភបំពានយ៉ាងធ្ងន់ធ្ងរទៅលើអនុសញ្ញាទីក្រុងហ្សឺណែវឆ្នាំ 1949 ព្រមទាំងឧក្រិដ្ឋកម្មប្រល័យពូជសាសន៍អង្គជំនុំជម្រះសាលាដំបងបានសម្រេចថាទីតាំងឧក្រិដ្ឋកម្មនិងបទចោទសំខាន់ដទៃទៀតខាងក្រោមនេះគឺជាមូលដ្ឋាននៃការជំនុំជម្រះក្តីសំណុំរឿង002 វគ្គ 2 អំពើប្រល័យពូជសាសន៍ទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមការរៀបការដោយបង្ខំនិងការរំលោភសេពសន្តិវៈនៅទូទាំងប្រទេសការបោះសម្អាតផ្ទៃក្នុងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅមន្ទីរសន្តិសុខចំនួន 4 គឺមន្ទីរសន្តិសុខស21 ក្រាំងតាច័ន្ទ អូកន្សែងនិងភ្នំក្រោលឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅការដ្ឋានចំនួន 3 គឺទំនប់1 មករាទំនប់ត្រពាំងថ្មនិងការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅសហករណ៍ត្រាំកក់ការធ្វើទុកបុកម្នេញខាងព្រះពុទ្ធសាសនាការធ្វើទុកបុកម្នេញមន្ត្រីសាធារណរដ្ឋខ្មែរកម្រិតត្រឹមសហករណ៍ត្រាំកក់ការដ្ឋានទំនប់1 មករាមន្ទីរសន្តិសុខស21និងមន្ទីរសន្តិសុខក្រាំងតាច័ន្ទសវនកម្មលើសំណុំរឿង002 វគ្គ 2 បានចាប់ផ្ដើមដោយសេចក្តីថ្លែងបើករបស់សហភាពអាជ្ញាកាលពីថ្ងៃទី 17 ខែតុលា ឆ្នាំ 2014
អំពើឃោរឃៅមកលើប្រជាជនកម្ពុជាមិនចេះចាប់មិនចេះហើយនឹងបានមានទ្រង់ទ្រាយកាន់តែធំទៅមិនធ្លាប់មានពីមុនដែលបានបណ្ដាលឲ្យទឹកដីកម្ពុជាពោពេញទៅដោយរដូវសាកសពនិងការបាត់បង់ជីវិតបាត់បង់បងប្អូនសាច់ញាតិនេះគឺជាកេរដំណែលដ៏សាហាវពិតដែលបានសល់ទុកដោយមេដឹកនាំបកកុម្មុយនីសកម្ពុជាដែលកំពុងអង្គុយនៅចំពោះមុខយើងទាំងអស់គ្នានៅថ្ងៃនេះដូច្នេះយើងសម្រាប់អ្នករាល់គ្នាដែលបានសួរថាតើហេតុអ្វីបានជាពួកយើងត្រូវការសាវនាការមួយទៀតនៅពេលដែលជនជាប់ចោទដែលមានវ័យចាស់ជរាបានទទួលការផ្ដន្ទាទោសអស់មួយជីវិតទៅហើយនោះចម្លើយគឺសាមញ្ញពួកយើងធ្វើនេះដោយសារប្រជាជនកម្ពុជារាប់លាននាក់ដែលបានស្លាប់ដោយសាររបបមួយនេះក្នុងកំឡុងពេល3ឆ្នាំ8ខែនិង20ថ្ងៃក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យមានតែពួកជ្រាំមានតែសេចក្តីវិនាសនិងទុក្ខព្រួយមានតែការឈឺចាប់និងសេចក្តីស្លាប់
ខ្ញុំបានទទួលស្គាល់ថាមានជនរួមជាតិជាច្រើនមានការឈឺចាប់នៅក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យដែលបង្កឡើងដោយពួកបំផ្លាញស៊ីរួមទីក្នុងខ្ញុំសោកស្ដាយចំពោះទុក្ខលំបាកនោះហើយខ្ញុំសូមទទួលខុសត្រូវនៃសិលធម៌ចំពោះអំពើនេះដោយសារខ្ញុំជាមេដឹកនាំជនខ្ពស់ម្នាក់នៃបកកុម្មុយនីសកម្ពុជា
នួនជាបានជម្រាបទៅចៅក្រមថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ធ្វើពហិការមិនចូលរួមជំនុំជម្រះក្តីរហូតដល់ពេលវេលាសំណើប្តឹងដិតចិត្តរបស់គាត់ទៅលើចៅក្រមសាលាដំបងពាក់ព័ន្ធទៅនឹងកំហុសឆ្គងមួយចំនួនត្រូវបានសម្រេចជាមុនសិននៅពេលក្រោយមកក្រុមចៅក្រមពិសេសមួយត្រូវបានបង្កើតឡើងនិងបានច្រានចោលសំណើប្តឹងដិតចិត្តរបស់នួនជាហើយមេធាវីការពារក្តីរបស់គាត់ក៏បានចូលរួមនៅក្នុងការកាត់ក្តីវិញគឺរៀងវងចោតតែនៅចំពោះមុខអង្គជំរះនេះជនជាប់ចោតទី2គឺខៀវសំផនបានជម្រាបអង្គជំនុំជម្រះសាលាដំបងថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ចង់អារម្មណ៍តែទៅលើបណ្ដឹងសារទុកជាមុនសិនមុននឹងគាត់និងមេធាវីរបស់គាត់ចូលរួមនៅក្នុងការជំនុំជម្រះក្តីនៃសំណុំរឿង002 វគ្គ 2
កាត់ក្តីសំណុំរឿង002 លើ 01 អស់លោកបានកាត់ទុកខ្ញុំដោយផ្អែកលើទម្រង់ផតានិងការស្មាននានាដែលខ្ញុំជំទាស់ហើយដោយប្រើមធ្យោបាយដែលខ្ញុំយល់ឃើញថាជាការរំលោភលើសិទ្ធិរបស់ខ្ញុំដែលខ្ញុំត្រូវមាន ត្រូវបានទទួលការកាក្តីដោយយុត្តិធម៌ហេតុនេះហើយបានជាខ្ញុំបានជម្រាបមេធាវីខ្ញុំឲ្យប្រឹងឧទ្ធរដែលនៅក្នុងតុលាការនេះគេហៅថាបណ្ដឹងសាទុកសេចក្តីសំអាងហេតុនិងសេចក្តីសន្និដ្ឋានរបស់អស់លោកនៅក្នុងការកាត់ក្តីនេះបង្ហាញច្បាស់ជាមុនស្រេចទៅហើយអស់លោកនឹងសម្រេចយ៉ាងណានៅក្នុងការកាត់ក្តីសំណុំរឿង002លើ02ខាងមុខនេះគ្មានអ្វីគួរឲ្យខ្ញុំស្រពេចស្រពិលទេបើអស់លោកនៅតែប្រើរបៀបគិតគូរដែលខ្ញុំជំទាស់ទៅចំពោះមុខតុលាការកំពូលតាក់ទងនឹងការចោទប្រកាន់ថាខ្ញុំបានចូលរួមប្រព្រឹត្តសហអក្រិតកម្មរួមខ្ញុំដឹងជាមុនស្រេចទៅហើយថាអស់លោកប្រកាសជានឹងផ្ដន្ទាទោសខ្ញុំទៀតក្នុងការកាត់ក្តីដែលអស់លោកកំពុងតែបើកនៅថ្ងៃនេះ
នៅអំឡុងពេលនៃសវនាការអង្គជំនុំជម្រះសាលាដំបងបានស្ដាប់ការបង្ហាញខុសតាងលើប្រធានបទស្ដីពីសហគមន៍ត្រាំកក់រួមទាំងមន្ទីរសន្តិសុខក្រាំងកាចាន់និងការប្រព្រឹត្តលើពុទ្ធសាសនិកការដ្ឋានទំនប់1មករាការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងការដ្ឋានទំនប់ត្រពាំងថ្មការប្រព្រឹត្តទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមមន្ទីរសន្តិសុខអូកន្សែងមន្ទីរសន្តិសុខភ្នំក្រោលនិងមន្ទីរសន្តិសុខស21និងការបោសសម្អាតផ្ទៃក្នុងការចេញបទបញ្ជាអំពីការរៀបអាពាហ៍ពិពាហ៍លក្ខណៈនៃចំនួនប្រដាប់អាវុធនិងជាចុងក្រោយអំពីទូនាទីរបស់ជនជាប់ចោទនៅថ្ងៃទី11ខែមករាឆ្នាំ2017អង្គជំនុំជម្រះសាលាដំបងបានបិទបញ្ចប់សវនាការលើកផុសតាងនៅក្នុងសំណុំរឿង002វគ្គ2ពាក់ព័ន្ធទៅនឹងបទចោទប្រកាន់ស្ដីអំពីឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិអំពើប្រល័យពូជសាសន៍និងការបំពានបំពានយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាក្រុងហ្សឺណែវប្រឆាំងទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផន
ប្រជាជនកម្ពុជាទូទាំងរបប
អង្គជំនុំជម្រះសាលាដំបងបានបើកសវនាការធ្វើសេចក្តីសន្និដ្ឋានផ្ទាល់មាត់បិទបញ្ចប់កិច្ចពិភាក្សាដេញដោលនៅខែមិថុនាឆ្នាំ2017
រដ្ឋវិញ្ញាម្នាក់បានផ្ដល់សេចក្តីកម្មអំពីវិជាសនកម្មដោយ
សូមជម្រាបថាអង្គជំនុំជម្រះបានធ្វើសវនាការរយៈពេល274ថ្ងៃនៅក្នុងសំណុំរឿង002វគ្គ2និងបានស្ដាប់សក្ខីកម្មសាក្សីចំនួន114នាក់ដើមបណ្ដឹងរដ្ឋប្រវេណីចំនួន63នាក់និងអ្នកជំនាញចំនួន8នាក់លើសពីនេះទៀតអង្គជំនុំជម្រះបានផ្ដល់ឱកាសឲ្យភាគីបង្ហាញភស្តុតាងជាឯកសារសំខាន់ពាក់ព័ន្ធទៅនឹងប្រធានបទសវនាការនីមួយៗនិងបានស្ដាប់ការបញ្ជាក់បន្ថែមរបស់សហមេធាវីនាំមុខតំណាងដើមបណ្ដឹងរដ្ឋប្រវេណីស្ដីពីការទាមទារសំណងនៅក្នុងអំឡុងពេលសវនាការនៅក្នុងសំណុំរឿង002វគ្គ2នេះមានសាធារណជនសរុបចំនួន776,604នាក់បានចូលរួមស្ដាប់ដោយផ្ទាល់នៅក្នុងសារសវនាការរបស់អង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាអង្គជំនុំជម្រះសាលាដំបងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានប្រកាសសេចក្តីសម្អាងហេតុនិងផ្នែកនៃសេចក្តីសម្រេចនៃសាលក្រមនៅក្នុងសំណុំរឿង002/02ពាក់ព័ន្ធទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផនកាលពីថ្ងៃទី16ខែវិច្ឆិកាឆ្នាំ2018នៅក្នុងសារសវនាការធំនៃអវតក
អង្គជំរះសាលាដំបងរកឃើញថាជនជាប់ចោទនួនជាមានបរិបទដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាចន្លោះថ្ងៃទី17ខែមេសាឆ្នាំ1975ដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើនេះនិងដោយលម្អិតនៅក្នុងសារក្រមជាលិលាអក្សរតាមរយៈអំពើសកម្មនិងអកម្មពីពួកអកតកម្មទាំងឡាយដូចខាងក្រោមអកតកម្មប្រឆាំងនឹងមនុស្សជាតិតាមរយៈការធ្វើនុភាពការសម្លាប់រង្គាលការនិរទេសការធ្វើឲ្យទៅជាសេដ្ឋករការដាក់ក្នុងមន្ទីរឃុំឃាំងការធ្វើទុកបុកម្នេញដោយមូលហេតុនយោបាយការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសនានិងការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសន៍និងអំពើអនុប្រព័ន្ធផ្សេងៗទៀតក្រុមទម្រង់ជាការប៉ះពាល់ដល់សេចក្តីថ្លៃថ្នូររបស់មនុស្សអំពើអមនុស្សធម៌ផ្សេងៗទៀតក្រុមទម្រង់ជាការបាត់ខ្លួនដោយបង្ខំអំពើអមនុស្សធម៌ផ្សេងៗទៀតក្រុមទម្រង់ ជាការជំនះដោយបង្ខំនិងអំពើអមនុស្សធម៌ផ្សេងៗទៀតក្រោមទម្រង់ជាការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំនិងការរំលោភផ្លូវភេទនៅក្នុងបទបទនៃការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំអនុលោមតាមបទបញ្ញត្តិនៃវិធានមាត្រា5មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់ស្តីពីការបង្កើតអវតកការបំពេញយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវតាមរយៈការធ្វើមនុស្សភាពដោយចេតនាការធ្វើទរណកម្មការធ្វើបាបដោយអវិធម៌ការបង្កដោយចេតនាឲ្យមានរបួសធ្ងន់ឬឲ្យមានការឈឺចាប់ដល់រាងកាយឬសុខភាពការដកហូតដោយចេតនាពីជ្រុយសិទ្ធិឬជនស៊ីវិលនៅសិទ្ធិទទួលបានការកាត់ទោសដោយយុត្តិធម៌និងទៀងទាត់និងការឃុំខ្លួនជនស៊ីវិលដែលខុសច្បាប់អនុលោមតាមមាត្រា6មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់ស្តីពីការបង្កើតអវតកឧក្រិដ្ឋកម្មបល័យពិសាសតាមរយៈការធ្វើមនុស្សភាពលើសមាជិកនៃក្រមជនជាតិវៀតណាមនិងជនជាតិចាមអង្គជំរះសាលាដំបងរកឃើញថាជនជាប់ចោទគឺសំផនមានពិរុទ្ធដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាដោយចន្លោះពីថ្ងៃ17ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើអង្គជំរះបានពិចារណាទៅលើភាពធ្ងន់ធ្ងរនៃអកតកម្មរួមទាំងទំហំនិងភាពសាហាវព្រៃផ្សៃក៏ដូចជាចំនួននិងភាពទន់ខ្សោយរបស់ជនរងគ្រោះដែលជនជាប់ចោទត្រូវបានរកឃើញមានប្រតិភិបរួមទាំងស្ថានទម្ងន់និងស្ថានបម្រើទោសនានាដែលពាក់ព័ន្ធអង្គជំរះសម្រាប់ផ្តន្ទាទោសជនជាប់ចោទនួនជាដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាលើការផ្តន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង002/01អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្តន្ទាទោសទាំងពីរទៅជាការផ្តន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយអង្គជំរះសម្រាប់ផ្តន្ទាទោសជនជាប់ចោទគឺសំផនដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាទៅលើការផ្តន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង002/01អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្តន្ទាទោសទាំងពីរទៅជាការផ្តន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយ
សាធារណជនប្រមាណជាជាង700នាក់រួមមានតំណាងរាជរដ្ឋាភិបាលកម្ពុជាតំណាងអង្គការសហប្រជាជាតិនិងមន្ត្រីអង្គទូតអង្គការសង្គមស៊ីវិលនានារួមនឹងសាធារណជននិងអ្នកសារព័ត៌មានជាតិនិងអន្តរជាតិបានចូលរួមស្ដាប់ការប្រកាសសារក្រមជាប្រវត្តិសាស្ត្រនេះយើងខ្ញុំសូមរំលឹកសាធារណជនថានៅក្នុងដំណាក់កាលនេះបាត់ចោតប្រឆាំងទៅនឹងនួនជានិងឃ្យូសំផននៅក្នុងសំណុំរឿង002/2គ្រាន់តែជាការចោទប្រកាន់តែប៉ុណ្ណោះមិនទាន់មានការសម្រេចជាស្ថាពរនៅឡើយទេថាតើជនជាប់ចោទទាំងពីរមានទោសឬក៏គ្មានទោសជនជាប់ចោទទាំងពីរត្រូវបានសន្មតទុកជាមុនថាគ្មានទោសដរាបណាសាលដីកាស្ថាពរមិនទាន់ចូលជាធរមាននៅឡើយជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាដែលគេស្គាល់ថាសាលាដីខ្មែរក្រហមត្រូវបានបង្កើតឡើងដើម្បីឆ្លើយតបទៅនឹងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅចន្លោះថ្ងៃទី17ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ជារយៈពេលដែលប៉ុល ពតកាន់កាប់អំណាចប្រជាជនយ៉ាងហោចណាស់1,700,000 នាក់ត្រូវបានជឿជាក់ថាត្រូវបានស្លាប់ដោយសារការធ្វើការងារហួសកម្លាំងការបង្អត់អាហារការធ្វើទារុណកម្មសម្លាប់និងលក្ខខណ្ឌរស់នៅដ៏អមនុស្សធម៌ដទៃទៀតសំណុំរឿង002/2គឺជាការជំនុំជម្រះដីទី2ប្រឆាំងទៅនឹងអតីតប្រមុខរដ្ឋខៀវសំផននិងអតីតអនុលេខាបកកុម្មុយនីសកម្ពុជាលោកនួនជាជនជាប់ចោទទាំងពីរត្រូវបានបញ្ជូនទៅជំនុំជម្រះដីកាលពីខែកញ្ញាឆ្នាំ2010 ដោយសារទំហំនិងភាពស្មុគស្មាញនៃបទចោទនាពេលរស់រានមានជីវិតរបស់ជនជាប់ចោទឬក្នុងពេលដែលជនជាប់ចោទនៅអាចជំនុំជម្រះក្តីបានដែលការបញ្ជូនរឿងទៅជំនុំជម្រះត្រូវបានបែងចែកជាការជំនុំជម្រះក្តីចំនួន2ដែលហៅថាសំណុំរឿង002វគ្គទី1និងសំណុំរឿង002វគ្គទី2ការជំនុំជម្រះក្តីដំណាក់កាលទី1ផ្ដោតសំខាន់ទៅលើបទចោទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិដែលតាក់ទងទៅនឹងការជំនះដោយបង្ខំពីទីក្រុងភ្នំពេញកាលពីខែមេសាឆ្នាំ1975និងក្រោយមកគឺមានការជំនះពីតំបន់ដទៃទៀតក៏មានបទចោទតាក់ទងទៅនឹងការសម្លាប់អតីតទាហានសាធារណរដ្ឋខ្មែរនៅទួលគោជ្រៃនៅក្នុងស្រុកកណ្ដៀងខេត្តពោធិ៍សាត់អង្គជំនុំជម្រះសាលាដំបងនៃអង្គជំនុំជម្រះវិស្ម័យក្នុងតុលាការកម្ពុជាហៅកាត់ថាអវតកបានរកឃើញនួនជានិងខៀវសំផតមានពិរុទ្ធពីបទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងបានសម្រេចផ្តន្ទាទោសពួកគាត់ដាក់ពន្ធនាគារអស់មួយជីវិតកាលពីថ្ងៃទី7ខែសីហាឆ្នាំ2014
ទាំងការធ្វើមុខភាពការធ្វើទុកបុកម្នេញ
សហព្រះរាជអាជ្ញាជនជាប់ចោទទាំងពីរបានប្តឹងសារទុកទៅកាន់អង្គជំនុំជម្រះតុលាការកំពូលហើយតុលាការកំពូលបានធ្វើសវនាការរួចហើយតាក់ទងទៅនឹងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង002/01ព្រមទាំងបានស្ដាប់សក្ខីកម្មរបស់សាក្សី3រូបកាលពីថ្ងៃទី2ទី3និងទី6ខែកក្កដាឆ្នាំ2015នៅថ្ងៃទី16 17 18ខែកក្កដាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលបានធ្វើសវនាការស្ដាប់សារណាផ្ទាល់មាត់លើបញ្ហានានាដែលបានលើកឡើងនៅក្នុងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង02វគ្គ01នៅថ្ងៃទី23ខែវិច្ឆិកាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលនៃអង្គជំនុំជម្រះវិស្ម័យក្នុងតុលាការកម្ពុជាបានប្រកាសសាលដីការបស់ខ្លួនលើបណ្ដឹងសារទុកប្រឆាំងនឹងសាលក្រមនៅក្នុងសំណុំរឿង002វគ្គ1ដោយបានតម្កល់សាលក្រមរបស់អង្គជំនុំជម្រះសាលាដំបងផ្តន្ទាទោសនួនជានិងខៀវសំផនដាក់ពន្ធនាគារអស់មួយជីវិតសំណុំរឿង002វគ្គ2ដែលជាសំណុំរឿងបន្តពីសំណុំរឿង002វគ្គ1មានបទចោទជារួមគឺឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងការរំលោភបំពានយ៉ាងធ្ងន់ធ្ងរទៅលើអនុសញ្ញាទីក្រុងហ្សឺណែវឆ្នាំ1949ព្រមទាំងឧក្រិដ្ឋកម្មប្រល័យពូជសាសន៍អង្គជំនុំជម្រះសាលាដំបងបានសម្រេចថាទីតាំងឧក្រិដ្ឋកម្មនិងបទចោទសំខាន់ដទៃទៀតខាងក្រោមនេះគឺជាមូលដ្ឋាននៃការជំនុំជម្រះក្តីសំណុំរឿង002វគ្គ2អំពើប្រល័យពូជសាសន៍ទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមការរៀបការដោយបង្ខំនិងការរំលោភសេពសន្តិវៈនៅទូទាំងប្រទេសការបោសសម្អាតផ្ទៃក្នុងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅមន្ទីរសន្តិសុខចំនួន4គឺមន្ទីរសន្តិសុខស21ក្រាំងតាចាន់អូកន្សែងនិងភ្នំក្រោយឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅការដ្ឋានចំនួន3គឺទំនប់1មករាទំនប់ត្រពាំងថ្មនិងការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅសហគមន៍ត្រាំកក់ការធ្វើទុកបុកម្នេញខាងព្រះពុទ្ធសាសនាការធ្វើទុកបុកម្នេញមន្ត្រីសាធារណរដ្ឋខ្មែរកម្រិតត្រឹមសហគមន៍ត្រាំកក់ការដ្ឋានទំនប់1មករាមន្ទីរសន្តិសុខស21និងមន្ទីរសន្តិសុខក្រាំងតាចាន់សវនកម្មលើសំណុំរឿង002វគ្គ2បានចាប់ផ្ដើមដោយសេចក្តីថ្លែងបើករបស់សហព្រះអាជ្ញាកាលពីថ្ងៃទី17ខែតុលាឆ្នាំ2014
អំពើឃោរឃៅមកលើប្រជាជនកម្ពុជាមិនចេះចប់មិនចេះហើយនឹងបានមានទ្រង់ទ្រាយកាន់តែធំទៅមិនធ្លាប់មានពីមុនដែលបានបណ្ដាលឲ្យទឹកដីកម្ពុជាពោពេញទៅដោយរដូវសាកសពនិងការបាត់បង់ជីវិតបាត់បង់បងប្អូនសាច់ញាតិនេះគឺជាគេដំណើរដ៏សាហាវពិតដែលបានសល់ទុកឲ្យមេដឹកនាំបកកុម្មុយនីសកម្ពុជាដែលកំពុងអង្គុយនៅចំពោះមុខយើងទាំងអស់គ្នានៅថ្ងៃនេះដូច្នេះយើងសម្រាប់អ្នករាល់គ្នាដែលបានសួរថាតើហេតុអ្វីបានជាពួកយើងត្រូវការសវនាការមួយទៀតនៅពេលដែលជនជាប់ចោទដែលមានវ័យចាស់ជរាបានទទួលការផ្តន្ទាទោសអស់មួយជីវិតទៅហើយនោះចម្លើយគឺសាមញ្ញពួកយើងធ្វើនេះដោយសារប្រជាជនកម្ពុជារាប់លាននាក់ដែលបានស្លាប់ដោយសាររបបមួយនេះក្នុងកំឡុងពេល3ឆ្នាំ8ខែនិង20ថ្ងៃក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យមានតែពួកជ្រាំមានតែសក្តិវិនាសនិងទុកព្រួយមានតែការឈឺចាប់និងសក្តិស្លាប់
ខ្ញុំបានទទួលស្គាល់ថាមានជនរួមជាតិជាច្រើនមានការឈឺចាប់ នៅក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យដែលបង្កឡើងដោយពួកបំផ្លាញស៊ីរួមទីក្នុងខ្ញុំសោកស្ដាយចំពោះទុក្ខលំបាកនោះហើយខ្ញុំសូមទទួលខុសត្រូវនៃសិលធម៌ចំពោះអំពើនេះដោយសារខ្ញុំជាមេដឹកនាំជនពលម្នាក់នៃបកកុម្មុយនីសកម្ពុជា
នួនជាបានជម្រាបទៅចៅក្រមថាគាត់បានបង្កប់ឲ្យមេធាវីរបស់គាត់ធ្វើពហិការមិនចូលរួមជំនុំជម្រះក្តីរហូតដល់ពេលវេលាសំណើប្តឹងដិតចិត្តរបស់គាត់ទៅលើចៅក្រមសាលាដំបូងពាក់ព័ន្ធទៅនឹងកំហុសឆ្គងមួយចំនួនត្រូវបានសម្រេចជាមុនសិននៅពេលក្រោយមកក្រុមចៅក្រមពិសេសមួយត្រូវបានបង្កើតឡើងនិងបានច្រានចោលសំណើប្តឹងដិតចិត្តរបស់នួនជាហើយមេធាវីការពារក្តីរបស់គាត់ក៏បានចូលរួមនៅក្នុងការកាត់ក្តីវិញ
ធ្វើរៀងវងកញ្ចក់តែនៅចំពោះមុខអង្គជំរះនេះ
ជនជាប់ចោតទី 2 គឺខៀវសំផតបានជម្រាបអង្គជំនុំជម្រះសាលាដំបូងថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ចង់អារម្មណ៍តែទៅលើបណ្ដឹងសារទុកជាមុនសិនមុននឹងគាត់និងមេធាវីរបស់គាត់ចូលរួមនៅក្នុងការជំនុំជម្រះក្តីនៃសំណុំរឿង 002 វគ្គ 2
អាកាក្តីសំណុំរឿង 002 លើ 01 អស់លោកបានកាត់ទុកខ្ញុំដោយផ្អែកលើទម្រង់ផតានិងការស្មាននានាដែលខ្ញុំជំទាស់ហើយដោយប្រើមធ្យោបាយដែលខ្ញុំយល់ឃើញថាជាការរំលោភលើសិទ្ធិរបស់ខ្ញុំដែលខ្ញុំត្រូវមានត្រូវបានទទួលការកាត់ក្តីដោយយុត្តិធម៌ ហើយនេះហើយបានជាខ្ញុំបានជម្រាបមេធាវីខ្ញុំឲ្យប្តឹងឧទ្ធរណ៍ដែលនៅក្នុងតុលាការនេះគេហៅថាបណ្ដឹងសារទុកសេចក្តីសំអាងហេតុនិងសេចក្តីសន្និដ្ឋានរបស់អស់លោកនៅក្នុងការកាត់ក្តីនេះបង្ហាញច្បាស់ជាមុនស្រេចទៅហើយអស់លោក នឹងសម្រាប់យ៉ាងណានៅក្នុងការកាត់ក្តីសំណុំរឿង 002 លើ 02 ខាងមុខនេះគ្មានអ្វីគួរឲ្យខ្ញុំស្រពេចស្រពិលទេបើអស់លោកនៅតែប្រើរបៀបគិតគូរដែលខ្ញុំជំទាស់នៅចំពោះមុខតុលាការកំពូល តាក់ទងនឹងការចោទប្រកាន់ថាខ្ញុំបានចូលរួមប្រព្រឹត្តសហអក្រិតកម្មរួមខ្ញុំដឹងជាមុនស្រេចទៅហើយថាអស់លោកប្រកាសជានឹងផ្ដន្ទាទោសខ្ញុំទៀតក្នុងការកាត់ក្តីដែលអស់លោកកំពុងតែបើកនៅថ្ងៃនេះ
នៅអំឡុងពេលនៃសវនាការអង្គជំនុំជម្រះសាលាដំបូងបានស្ដាប់ការបង្ហាញខុសតាងលើប្រធានបទស្ដីពីសហគមន៍ត្រាំកក់រួមទាំងមន្ទីរសន្តិសុខក្រាំងតាច័ន្ទនិងការប្រព្រឹត្តលើពុទ្ធសាសនិកការដ្ឋានទំនុក1មករាការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងការដ្ឋានទំនុកត្រពាំងថ្មការប្រព្រឹត្តទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមមន្ទីរសន្តិសុខអូកន្សែងមន្ទីរសន្តិសុខភ្នំក្រោលនិងមន្ទីរសន្តិសុខស21និងការបោះសម្អាតផ្ទៃក្នុងការចេញបទបញ្ជាអំពីការរៀបអាពាហ៍ពិពាហ៍ លក្ខណៈនៃចំនួនប្រដាប់អាវុធនិងជាចុងក្រោយអំពីទូនាទីរបស់ជនជាប់ចោទនៅថ្ងៃទី 11 ខែមករាឆ្នាំ 2017 អង្គជំនុំជម្រះសាលាដំបូងបានបិទបញ្ចប់សវនាការលើកផុសតាងនៅក្នុងសំណុំរឿង 002 វគ្គ 2 ពាក់ព័ន្ធទៅនឹងបទចោទប្រកាន់ស្ដីអំពីឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិអំពើប្រល័យពូជសាសន៍និងការបំពានបំពានយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាក្រុងហ្សឺណែវប្រឆាំងទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផត
ប្រជាជនកម្ពុជាទូទាំងរបប
អង្គជំនុំជម្រះសាលាដំបូងបានបើកសវនាការធ្វើសេចក្តីសន្និដ្ឋានផ្ទាល់មាត់បិទបញ្ចប់កិច្ចពិភាក្សាដេញដោលនៅខែមិថុនាឆ្នាំ 2017
រដ្ឋវិញ្ញាម្នាក់បានផ្ដល់សេចក្តីកម្មអំពីវិជាសនកម្មដោយ
សូមជម្រាបថាអង្គជំនុំជម្រះបានធ្វើសវនាការរយៈពេល 274 ថ្ងៃនៅក្នុងសំណុំរឿង 002 វគ្គ 2 និងបានស្ដាប់សេចក្តីកម្មសាក្សីចំនួន 114 នាក់ ដើមបណ្ដឹងរដ្ឋប្រវេណីចំនួន 63 នាក់ និងអ្នកជំនាញចំនួន 8 នាក់
ប
លើសពីនេះទៀតអង្គជំនុំជម្រះបានផ្ដល់ឱកាសឲ្យភាគីបង្ហាញផុសតាងជាឯកសារសំខាន់ៗពាក់ព័ន្ធទៅនឹងប្រធានបទសវនាការនីមួយៗនិងបានស្ដាប់ការបញ្ជាក់បន្ថែមរបស់សហមេធាវីនាំមុខតំណាងដើមបណ្ដឹងរដ្ឋបវេនីស្ដីពីការទាមទារសំណងនៅក្នុងអំឡុងពេលសវនាការនៅក្នុងសំណុំរឿង002វគ្គ2នេះមានសាធារណជនសរុបចំនួន 776,604 នាក់បានចូលរួមស្ដាប់ដោយផ្ទាល់នៅក្នុងសារសវនាការរបស់អង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាអង្គជំនុំជម្រះសាលាដំបូងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានប្រកាសសេចក្តីសម្អាងហេតុនិងផ្នែកនៃសេចក្តីសម្រេចនៃសារក្រមនៅក្នុងសំណុំរឿង 002/02 ពាក់ព័ន្ធទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផនកាលពីថ្ងៃទី16ខែវិច្ឆិកាឆ្នាំ2018នៅក្នុងសារសវនាការធំនៃអវតក
អង្គជំរះសាលាដំបងរកឃើញថាជនជាប់ចោទនួនជាមានបរិបទដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាចន្លោះថ្ងៃទី17ខែមេសាឆ្នាំ1975ដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើនេះនិងដោយលម្អិតនៅក្នុងសារក្រមជាលិលាអក្សរតាមរយៈអង្គើសកម្មនិងអកម្មចំពោះអកតកម្មទាំងឡាយដូចខាងក្រោមអកតកម្មប្រឆាំងនឹងមនុស្សជាតិតាមរយៈការធ្វើមនុស្សជាតិការសម្លាប់រង្គាលការនិរទេសការធ្វើឲ្យទៅជាសតកការដាក់ក្នុងមន្ទីរឃុំឃាំងការធ្វើទុកបុកម្នេញដោយមូលហេតុនយោបាយការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសនានិងការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសន៍និងអំពើអនុធម៌ផ្សេងៗទៀតក្រមទម្រង់ជាការប៉ះពាល់ដល់សេចក្តីថ្លៃថ្នូររបស់មនុស្សអំពើអនុធម៌ផ្សេងៗទៀតក្រមទម្រង់ជាការបាត់ខ្លួនដោយបង្ខំអំពើអនុធម៌ផ្សេងៗទៀតក្រមទម្រង់ជាការជំនះដោយបង្ខំនិងអំពើអនុធម៌ផ្សេងៗទៀតក្រមទម្រង់ជាការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំនិងការរំលោភផ្លូវភេទនៅក្នុងបទបទនៃការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំអនុលោមតាមបទបញ្ញត្តិនៃវិធានមាត្រា5មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់នៃពីការបង្កើតអវតកការបំពេញបំពេញយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវតាមរយៈការធ្វើមនុស្សភាពដោយចេតនាការធ្វើទរណកម្មការធ្វើបាបដោយអវិធម៌ការបង្កដោយចេតនាឲ្យមានរបួសធ្ងន់ឬឲ្យមានការឈឺចាប់ដល់រាងកាយឬសុខភាពការដកហូតដោយចេតនាពីជ្រើយសឹកឬជនស៊ីវិលនៅសិទ្ធិទទួលបានការកាត់ទោសដោយយុត្តិធម៌និងទៀងទាត់និងការឃុំខ្លួនជនស៊ីវិលដែលខុសច្បាប់អនុលោមតាមមាត្រា6មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់ស្តីពីការបង្កើតអវតកឧក្រិដ្ឋកម្មបលាយពិសាសតាមរយៈការធ្វើមនុស្សឃាតលើសមាជិកនៃក្រមជនជាតិវៀតណាមនិងជនជាតិចាមអង្គជំនះសាលាដំបងរកឃើញថាជនជាប់ចោទគឺសម្ផនមានវិរុទ្ធដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាដោយចន្លោះពីថ្ងៃ17ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើអង្គជំរះបានពិចារណាទៅលើភាពធ្ងន់ធ្ងរនៃអកតកម្មរួមទាំងទំហំនិងភាពសាហាវព្រៃផ្សៃក៏ដូចជាចំនួននិងភាពទន់ខ្សោយរបស់ជនរងគ្រោះដែលជនជាប់ចោទត្រូវបានរកឃើញមានប្រសិទ្ធភាពរួមទាំងស្ថានទម្ងន់និងស្ថានបម្រើទោសនានាដែលពាក់ព័ន្ធអង្គជំរះសម្រាប់ផ្ដន្ទាទោសជនជាប់ចោទនួនជាដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាលើការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង 002/01 អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្ដន្ទាទោសទាំងពីរទៅជាការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយអង្គជំរះសម្រាប់ផ្ដន្ទាទោសជនជាប់ចោទគឺសម្ផនដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាទៅលើការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង 002/01 អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នាលើការផ្ដន្ទាទោសទាំងពីរទៅជាការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយ
សាធារណជនប្រមាណជាជាង700នាក់រួមមានតំណាងរាជរដ្ឋាភិបាលកម្ពុជាតំណាងអង្គការសហប្រជាជាតិនិងមន្ត្រីអង្គទូតអង្គការសង្គមស៊ីវិលនានារួមនឹងសាធារណជននិងអ្នកសារព័ត៌មានជាតិនិងអន្តរជាតិបានចូលរួមស្ដាប់ការប្រកាសសារក្រមជាប្រវត្តិសាស្ត្រនេះយើងខ្ញុំសូមរំលឹកសាធារណជនថា នៅក្នុងដំណាក់កាលនេះបទចោទប្រឆាំងទៅនឹងនួនជានិងឃ្យូសំផននៅក្នុងសំណុំរឿង002 វគ្គ 2 គ្រាន់តែជាការចោទប្រកាន់តែប៉ុណ្ណោះមិនទាន់មានការសម្រេចជាស្ថាពរនៅឡើយទេថាតើជនជាប់ចោទទាំងពីរមានទោសឬក៏គ្មានទោសជនជាប់ចោទទាំងពីរត្រូវបានសន្មតទុកជាមុនថាគ្មានទោសដរាបណាសាលដីកាស្ថាពរមិនទាន់ចូលជាធរមាននៅឡើយអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាដែលគេស្គាល់ថាសាលាដីខ្មែរក្រហមត្រូវបានបង្កើតឡើងដើម្បីឆ្លើយតបទៅនឹងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅចន្លោះថ្ងៃទី17 ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6 ខែមករាឆ្នាំ1979ជារយៈពេលដែលពលពតកាន់កាប់អំណាចប្រជាជនយ៉ាងហោចណាស់1,700,000 នាក់ត្រូវបានជឿជាក់ថាត្រូវបានស្លាប់ដោយសារការធ្វើការងារហួសកម្លាំងការបង្អត់អាហារការធ្វើទារុណកម្មសម្លាប់និងលក្ខខណ្ឌរស់នៅដ៏អមនុស្សធម៌ដទៃទៀតសំណុំរឿង002 វគ្គ 2 គឺជាការជំនុំជម្រះដីទី2ប្រឆាំងទៅនឹងអតីតប្រមុខរដ្ឋខៀវសំផននិងអតីតអនុលេខាបកកុម្មុយនីសកម្ពុជាលោកនួនជាជនជាប់ចោទទាំងពីរត្រូវបានបញ្ជូនទៅជំនុំជម្រះដីកាលពីខែកញ្ញាឆ្នាំ2010ដោយសារទំហំនិងភាពស្មុគស្មាញនៃបទចោទនាពេលរស់រានមានជីវិតរបស់ជនជាប់ចោទឬក្នុងពេលដែលជនជាប់ចោទនៅអាចជំនុំជម្រះដីបានដែលការបញ្ជូនរឿងទៅជំនុំជម្រះត្រូវបានបែងចែកជាការជំនុំជម្រះដីចំនួន2ដែលហៅថាសំណុំរឿង002 វគ្គទី1និងសំណុំរឿង002 វគ្គទី2ការជំនុំជម្រះក្តីដំណាក់កាលទី1ផ្ដោតសំខាន់ទៅលើបទចោទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិដែលតាក់ទងទៅនឹងការជំនះដោយបង្ខំពីទីក្រុងភ្នំពេញកាលពីខែមេសាឆ្នាំ1975និងក្រោយមកគឺមានការជំនះពីតំបន់ដទៃទៀតក៏មានបទចោទតាក់ទងទៅនឹងការសម្លាប់អតីតទាហានសាធារណរដ្ឋខ្មែរនៅទួលពោធិ៍ជ្រៃនៅក្នុងស្រុកកណ្ដៀងខេត្តពោធិ៍សាត់អង្គជំនុំជម្រះសាលាដំបងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាហៅកាត់ថាអវតកបានរកឃើញនួនជានិងឃ្យូសំផនមានពិរុទ្ធពីបទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងបានសម្រេចផ្តន្ទាទោសពួកគាត់ដាក់ពន្ធនាគារអស់មួយជីវិតកាលពីថ្ងៃទី7 ខែសីហាឆ្នាំ2014ទាំងការធ្វើមុខភាពការធ្វើទុកបុកម្នេញសហព្រះរាជអាជ្ញាជនជាប់ចោទទាំងពីរបានប្តឹងសារទុកទៅកាន់អង្គជំនុំជម្រះតុលាការកំពូលហើយតុលាការកំពូលបានធ្វើសវនាការរួចហើយតាក់ទងទៅនឹងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង002/01ព្រមទាំងបានស្ដាប់សក្ខីកម្មរបស់សាក្សី3រូបកាលពីថ្ងៃទី2 ទី3និងទី6 ខែកក្កដាឆ្នាំ2015នៅថ្ងៃទី16 17 18 ខែកក្កដាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលបានធ្វើសវនាការស្ដាប់សារណាផ្ទាល់មាត់លើបញ្ហានានាដែលបានលើកឡើងនៅក្នុងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង002 វគ្គ 01នៅថ្ងៃទី23 ខែវិច្ឆិកាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានប្រកាសសាលដីការបស់ខ្លួនលើបណ្ដឹងសារទុកប្រឆាំងនឹងសាលក្រមនៅក្នុងសំណុំរឿង002 វគ្គ 1ដោយបានតម្កល់សាលក្រមរបស់អង្គជំនុំជម្រះសាលាដំបងផ្តន្ទាទោសនួនជានិងឃ្យូសំផនដាក់ពន្ធនាគារអស់មួយជីវិតសំណុំរឿង002 វគ្គ 2ដែលជាសំណុំរឿងបន្តពីសំណុំរឿង002 វគ្គ 1មានបទចោទជារួមគឺឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងការរំលោភបំពានយ៉ាងធ្ងន់ធ្ងរទៅលើអនុសញ្ញាទីក្រុងហ្សឺណែវឆ្នាំ1949ព្រមទាំងឧក្រិដ្ឋកម្មប្រល័យពូជសាសន៍អង្គជំនុំជម្រះសាលាដំបងបានសម្រេចថាទីតាំងឧក្រិដ្ឋកម្មនិងបទចោទសំខាន់ដទៃទៀតខាងក្រោមនេះគឺជាមូលដ្ឋាននៃការជំនុំជម្រះក្តីសំណុំរឿង002 វគ្គ 2អំពើប្រល័យពូជសាសន៍ទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមការរៀបការដោយបង្ខំនិងការរំលោភសេពសន្តិវៈនៅទូទាំងប្រទេសការបោះសម្អាតផ្ទៃក្នុងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅមន្ទីរសន្តិសុខចំនួន4គឺមន្ទីរសន្តិសុខស21ក្រាំងតាច័ន្ទអូកន្សែងនិងភ្នំក្រោលឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅការដ្ឋានចំនួន3គឺទំនប់1 មករាទ ទំនប់ទពាំងថ្មនិងការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅសហគមន៍5កក់ការធ្វើទុកបុកម្នេញខាងព្រះពុទ្ធសាសនាការធ្វើទុកបុកម្នេញមន្ត្រីសាធារណរដ្ឋខ្មែរកម្រិតត្រឹមសហគមន៍5កក់ការដ្ឋានទំនប់1មករាមន្ទីរសន្តិសុខស21និងមន្ទីរសន្តិសុខក្រាំងតាចាន់សវនកម្មលើសំណុំរឿង002វគ្គ2បានចាប់ផ្ដើមដោយសេចក្តីថ្លែងបើករបស់សហភាពអាជ្ញាកាលពីថ្ងៃទី17ខែតុលាឆ្នាំ2014
អំពើឃោរឃៅមកលើប្រជាជនកម្ពុជាមិនចេះចប់មិនចេះហើយនឹងបានមានទ្រង់ទ្រាយកាន់តែធំទៅមិនធ្លាប់មានពីមុនដែលបានបណ្ដាលឲ្យទឹកដីកម្ពុជាពោពេញទៅដោយរដូវសាក់សពនិងការបាត់បង់ជីវិតបាត់បង់បងប្អូនសាច់ញាតិនេះគឺជាគេដំណើរដល់សហពិតដែលបានសល់ទុកឲ្យមេដឹកនាំបកកុម្មុយនីសកម្ពុជាដែលកំពុងអង្គុយនៅចំពោះមុខយើងទាំងអស់គ្នានៅថ្ងៃនេះដូច្នេះយើងសម្រាប់អ្នករាល់គ្នាដែលបានសួរថាតើហេតុអ្វីបានជាពួកយើងត្រូវការសាវនាការមួយទៀតនៅពេលដែលជនជាប់ចោទដែលមានវ័យចាស់ជរាបានទទួលការផ្ដន្ទាទោសអស់មួយជីវិតទៅហើយនោះចម្លើយគឺសាមញ្ញពួកយើងធ្វើនេះដោយសារប្រជាជនកម្ពុជារាប់លាននាក់តែបានស្លាប់ដោយសាររបបមួយនេះក្នុងកំឡុងពេល3ឆ្នាំ8ខែនិង20ថ្ងៃក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យមានតែពួកជ្រាំមានតែសក្តិវិនាសនិងទុកព្រួយមានតែការឈឺចាប់និងសក្តិស្លាប់
ខ្ញុំបានទទួលស្គាល់ថាមានជនរួមជាតិជាច្រើនមានការឈឺចាប់នៅក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យដែលបង្កឡើងដោយពួកបំផ្លាញស៊ីរួមទីក្នុងខ្ញុំសោកស្ដាយចំពោះទុក្ខលំបាកនោះហើយខ្ញុំសូមទទួលខុសត្រូវនៃសិលធម៌ចំពោះអំពើនេះដោយសារខ្ញុំជាមេដឹកនាំជាន់ខ្ពស់ម្នាក់នៃបកកុម្មុយនីសកម្ពុជា
នួនជាបានជម្រាបទៅចៅក្រមថាគាត់បានបង្កប់ឲ្យមេធាវីរបស់គាត់ធ្វើពហិការមិនចូលរួមជំនុំជម្រះក្តីរហូតដល់ពេលវេលាសំណើប្តឹងដិតចិត្តរបស់គាត់ទៅលើចៅក្រមសាលាដំបូងពាក់ព័ន្ធទៅនឹងកំហុសឆ្គងមួយចំនួនត្រូវបានសម្រេចជាមុនសិននៅពេលក្រោយមកក្រុមចៅក្រមពិសេសមួយត្រូវបានបង្កើតឡើងនិងបានច្រានចោលសំណើប្តឹងដិតចិត្តរបស់នួនជាហើយមេធាវីការពារក្តីរបស់គាត់ក៏បានចូលរួមនៅក្នុងការកាត់ក្តីវិញ
គឺរៀងមុខចកតែនៅចំពោះមុខអង្គជំរះនេះ
ជនជាប់ចោទទី2គឺ Khieu សំផតបានជម្រាបអង្គជំនុំជម្រះសាលាដំបូងថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ចង់អារម្មណ៍តែទៅលើបណ្ដឹងសារទុកជាមុនសិនមុននឹងគាត់និងមេធាវីរបស់គាត់ចូលរួមនៅក្នុងការជំនុំជម្រះក្តីនៃសំណុំរឿង002វគ្គ2
អាការក្តីសំណុំរឿង002លើ01អស់លោកបានកាត់ទុកខ្ញុំដោយផ្អែកលើទម្រង់ផតានិងការស្មាននានាដែលខ្ញុំជំទាស់ហើយដោយប្រើមធ្យោបាយដែលខ្ញុំយល់ឃើញថាជាការរំលោភលើសិទ្ធិរបស់ខ្ញុំដែលខ្ញុំត្រូវបានទទួលការកាត់ក្តីដោយយុត្តិធម៌ហេតុនេះហើយបានជាខ្ញុំបានជម្រាបមេធាវីខ្ញុំឲ្យប្តឹងឧទ្ធរណ៍ដែលនៅក្នុងតុលាការនេះគេហៅថាបណ្ដឹងសារទុកសេចក្តីសំអាងហេតុនិងសេចក្តីសន្និដ្ឋានរបស់អស់លោកនៅក្នុងការកាត់ក្តីនេះបង្ហាញច្បាស់ជាមុនស្រេចទៅហើយអស់លោកនឹងសម្រេចយ៉ាងណានៅក្នុងការកាត់ក្តីសំណុំរឿង002លើ02ខាងមុខនេះគ្មានអ្វីគួរឲ្យខ្ញុំស្រពេចស្រពិលទេបើអស់លោកនៅតែប្រើរបៀបគិតគូរដែលខ្ញុំជំទាស់ទៅចំពោះមុខតុលាការកំពូលតាក់ទងនឹងការចោទប្រកាន់ថាខ្ញុំបានចូលរួមប្រព្រឹត្តសហឧក្រិដ្ឋកម្មរួមខ្ញុំដឹងជាមុន ស្រេចទៅហើយថាអស់លោកប្រកាសជានឹងផ្ដល់ទីទុកខ្ញុំទៀតក្នុងការកាត់ក្តីដែលអស់លោកកំពុងតែបើកនៅថ្ងៃនេះ
នៅអំឡុងពេលនៃសវនាការអង្គជំនុំជម្រះសាលាដំបងបានស្ដាប់ការបង្ហាញផុសតាងលើប្រធានបទស្ដីពីសហគមន៍ត្រាំកក់រួមទាំងមន្ទីរសន្តិសុខក្រាំងត្រច័ន្ទនិងការប្រព្រឹត្តលើពុទ្ធសាសនិកការដ្ឋានទំនប់1មករាការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងការដ្ឋានទំនប់ត្រពាំងថ្មការប្រព្រឹត្តទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមមន្ទីរសន្តិសុខអូកន្សែងមន្ទីរសន្តិសុខក្នុងក្រោលនិងមន្ទីរសន្តិសុខស21និងការបោសសម្អាតផ្ទៃក្នុងការចេញបទបញ្ជាអំពីការរៀបអាពាហ៍ពិពាហ៍លក្ខណៈនៃចំនួនប្រដាប់អាវុធនិងជាចុងក្រោយអំពីទូនាទីរបស់ជនជាប់ចោទនៅថ្ងៃទី11ខែមករាឆ្នាំ2017អង្គជំនុំជម្រះសាលាដំបងបានបិទបញ្ចប់សវនាការលើកផុសតាងនៅក្នុងសំណុំរឿង002វគ្គ2ពាក់ព័ន្ធទៅនឹងបទចោទប្រកាន់ស្ដីអំពីឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិអំពើប្រល័យពូជសាសន៍និងការបំពានបំពានយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវប្រឆាំងទៅនឹងជនជាប់ចោទនួនជានិងខៀវសុផត
ប្រជាជនកម្ពុជាទូទាំងរបប
អង្គជំនុំជម្រះសាលាដំបងបានបើកសវនាការធ្វើសេចក្តីសន្និដ្ឋានផ្ទាល់មាត់បិទបញ្ចប់កិច្ចពិភាក្សាដេញដោលនៅខែមិថុនាឆ្នាំ2017
រដ្ឋវិនិម្នាក់បានផ្ដល់សេចក្តីកម្មអំពីជាសនកម្មដោយ
សូមជម្រាបថាអង្គជំនុំជម្រះបានធ្វើសវនាការរយៈពេល274ថ្ងៃនៅក្នុងសំណុំរឿង002វគ្គ2និងបានស្ដាប់សេចក្តីកម្មសាក្សីចំនួន114នាក់ដើមបណ្ដឹងរដ្ឋប្រវេណីចំនួន63នាក់និងអ្នកជំនាញចំនួន8នាក់លើសពីនេះទៀតអង្គជំនុំជម្រះបានផ្ដល់ឱកាសឲ្យភាគីបង្ហាញផុសតាងជាឯកសារសំខាន់ពាក់ព័ន្ធទៅនឹងប្រធានបទសវនាការនីមួយៗនិងបានស្ដាប់ការបញ្ជាក់បន្ថែមរបស់សហមេធាវីនាំមុខតំណាងដើមបណ្ដឹងរដ្ឋប្រវេណីស្ដីពីការទាមទារសំណងនៅក្នុងអំឡុងពេលសវនាការនៅក្នុងសំណុំរឿង002វគ្គ2នេះមានសាធារណជនសរុបចំនួន776,604នាក់បានចូលរួមស្ដាប់ដោយផ្ទាល់នៅក្នុងសាលសវនាការរបស់អង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាអង្គជំនុំជម្រះសាលាដំបងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានប្រកាសសេចក្តីសម្អាងហេតុនិងផ្នែកនៃសេចក្តីសម្រេចនៃសាលក្រមនៅក្នុងសំណុំរឿង002/02ពាក់ព័ន្ធទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផនកាលពីថ្ងៃទី16ខែវិច្ឆិកាឆ្នាំ2018នៅក្នុងសាលសវនាការធំនៃអវតក
អង្គជំរះសាលាដំបងរកឃើញថាជនជាប់ចោទនួនជាមានប្រវត្តិដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាចន្លោះថ្ងៃទី17ខែមេសាឆ្នាំ1975ដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើនេះនិងដោយលម្អិតនៅក្នុងសាលក្រមជាលិលាអក្សរតាមរយៈអំពើសកម្មនិងអកម្មចំពោះអកតកម្មទាំងឡាយដូចខាងក្រោមអកតកម្មប្រឆាំងនឹងមនុស្សជាតិតាមរយៈការធ្វើនុភាពការសម្លាប់រង្គាលការនិរទេសការធ្វើឲ្យទៅជាសតកការដាក់ក្នុងមន្ទីរឃុំឃាំងការធ្វើទុកបុកម្នេញដោយមូលហេតុនយោបាយការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសនានិងការធ្វើទុកបុកម្នេញដោយមូលហេតុភូមិសាស្ត្រនិងអំពើអនុធម៌ផ្សេងៗទៀតក្រុមទម្រង់ជាការប៉ះពាល់ដល់សេចក្តីថ្លៃថ្នូររបស់មនុស្សអំពើអនុធម៌ផ្សេងៗទៀតក្រុមទម្រង់ជាការបាត់ខ្លួនដោយបង្ខំអំពើអនុធម៌ផ្សេងៗទៀតក្រុមទម្រង់ជាការជំលះដោយបង្ខំនិងអំពើអនុធម៌ផ្សេងៗទៀតក្រុមទម្រង់ជាការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំនិងការរំលោភផ្លូវភេទនៅក្នុងបទបទនៃការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំអនុលោមតាមបទបញ្ញត្តិនៃវិធានមាត្រា5មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់ស្តីពីការបង្កើតអវតកការបំពេញយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវតាមរយៈការធ្វើមនុស្សភាពដោយចេតនាការធ្វើទរណកម្មការធ្វើបាបដោយអវិធម៌ការបង្កដោយចេតនាឲ្យមានរបួសធ្ងន់ឬឲ្យមានការឈឺចាប់ដល់រាងកាយឬសុខភាពការដកហូតដោយចេតនាពីជ្រុយសឹកឬជនស៊ីវិលនៅសិទ្ធិទទួលបានការកាត់ទោសដោយយុត្តិធម៌និងទៀងទាត់និងការឃុំខ្លួនជនស៊ីវិលដែលខុសច្បាប់អនុលោមតាមមាត្រា6មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់ស្តីពីការបង្កើតអវតកឧក្រិដ្ឋកម្មបល័យពិសាសតាមរយៈការធ្វើមនុស្សឃាតលើសមាជិកនៃក្រុមជនជាតិវៀតណាមនិងជនជាតិចាមអង្គជំរះសាលាដំបងរកឃើញថា ជនជាប់ចោទគឺសម្ផនមានវិរុទ្ធដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាដោយចន្លោះពីថ្ងៃ17ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើអង្គជំរះបានពិចារណាទៅលើភាពធ្ងន់ធ្ងរនៃអកតកម្មរួមទាំងទំហំនិងភាពសាហាវព្រៃផ្សៃក៏ដូចជាចំនួននិងភាពទន់ខ្សោយរបស់ជនរងគ្រោះដែលជនជាប់ចោទត្រូវបានរកឃើញមានប្រសិទ្ធភាពរួមទាំងស្ថានទម្ងន់និងស្ថានដំណើរទោសនានាដែលពាក់ព័ន្ធអង្គជំរះសម្រាប់ផ្ដន្ទាទោសជនជាប់ចោទនួនជាដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាលើការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង002/01អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្ដន្ទាទោសទាំងពីរទៅជាការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយអង្គជំរះសម្រាប់ផ្ដន្ទាទោសជនជាប់ចោទគឺសម្ផនដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាទៅលើការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង002/01អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នាលើការផ្ដន្ទាទោសទាំងពីរទៅជាការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយ
សាធារណជនប្រមាណជាជាង700នាក់រួមមានតំណាងរាជរដ្ឋាភិបាលកម្ពុជាតំណាងអង្គការសហប្រជាជាតិនិងមន្ត្រីអង្គទូតអង្គការសង្គមស៊ីវិលនានារួមនឹងសាធារណជននិងអ្នកសារព័ត៌មានជាតិនិងអន្តរជាតិបានចូលរួមស្ដាប់ការប្រកាសសារក្រមជាប្រវត្តិសាស្ត្រនេះយើងខ្ញុំសូមរំលឹកសាធារណជនថានៅក្នុងដំណាក់កាលនេះបទចោទប្រឆាំងទៅនឹងនួនជានិងឃ្យូសំផននៅក្នុងសំណុំរឿង002/2គ្រាន់តែជាការចោទប្រកាន់តែប៉ុណ្ណោះមិនទាន់មានការសម្រេចជាស្ថាពរនៅឡើយទេថាតើជនជាប់ចោទទាំងពីរមានទោសឬក៏គ្មានទោសជនជាប់ចោទទាំងពីរត្រូវបានសន្មត់ទុកជាមុនថាគ្មានទោសដរាបណាសាលដីកាស្ថាពរមិនទាន់ចូលជាធរមាននៅឡើយជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាដែលគេស្គាល់ថាសាលាដីខ្មែរក្រហមត្រូវបានបង្កើតឡើងដើម្បីឆ្លើយតបទៅនឹងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅចន្លោះថ្ងៃទី17ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ជារយៈពេលដែលប៉ុល ពតកាន់កាប់អំណាចប្រជាជនយ៉ាងហោចណាស់1,700,000 នាក់ត្រូវបានជឿជាក់ថាត្រូវបានស្លាប់ដោយសារការធ្វើការងារហួសកម្លាំងការបង្អត់អាហារការធ្វើទារុណកម្មសម្លាប់និងលក្ខខណ្ឌរស់នៅដ៏អមនុស្សធម៌ដទៃទៀតសំណុំរឿង002/2គឺជាការជំនុំជម្រះដីទី2ប្រឆាំងទៅនឹងអតីតប្រមុខរដ្ឋខៀវសំផននិងអតីតអនុលេខាបកកុម្មុយនីសកម្ពុជាលោកនួនជាជនជាប់ចោទទាំងពីរត្រូវបានបញ្ជូនទៅជំនុំជម្រះក្តីកាលពីខែកញ្ញាឆ្នាំ2010ដោយសារទំហំនិងភាពស្មុគស្មាញនៃបទចោទនាពេលរស់រានមានជីវិតរបស់ជនជាប់ចោទឬក្នុងពេលដែលជនជាប់ចោទនៅអាចជំនុំជម្រះក្តីបានដែលការបញ្ជូនរឿងទៅជំនុំជម្រះត្រូវបានបែងចែកជាការជំនុំជម្រះក្តីចំនួន2ដែលហៅថាសំណុំរឿង002/1និងសំណុំរឿង002/2ការជំនុំជម្រះក្តីដំណាក់កាលទី1ផ្ដោតសំខាន់ទៅលើបទចោទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិដែលតាក់ទងទៅនឹងការជំនះដោយបង្ខំពីទីក្រុងភ្នំពេញកាលពីខែមេសាឆ្នាំ1975និងក្រោយមកគឺមានការជំនះពីតំបន់ដទៃទៀតក៏មានបទចោទតាក់ទងទៅនឹងការសម្លាប់អតីតវិហារសាធារណរដ្ឋខ្មែរនៅទួលពលជ្រៃនៅក្នុងស្រុកកណ្ដៀងខេត្តពោធិ៍សាត់អង្គជំនុំជម្រះសាលាដំបូងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាហៅកាត់ថាអវតកបានរកឃើញនួនជានិងឃ្យូសំផនមានពិរុទ្ធពីបទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងបានសម្រេចផ្តន្ទាទោសពួកគាត់ដាក់ពន្ធនាគារអស់មួយជីវិតកាលពីថ្ងៃទី7ខែសីហាឆ្នាំ2014រួមទាំងការធ្វើមុខភាព
ការធ្វើទុកបុកម្នេញ
សហព្រះរាជអាជ្ញាជនជាប់ចោទទាំងពីរបានប្តឹងសារទុកទៅកាន់អង្គជំនុំជម្រះតុលាការកំពូលហើយតុលាការកំពូលបានធ្វើសវនាការរួចហើយតាក់ទងទៅនឹងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង002/01ព្រមទាំងបានស្ដាប់សក្ខីកម្មរបស់សាក្សី3រូបកាលពីថ្ងៃទី2 ទី3និងទី6ខែកក្កដាឆ្នាំ2015នៅថ្ងៃទី16 17 18ខែកក្កដាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលបានធ្វើសវនាការស្ដាប់សារណាផ្ទាល់មាត់លើបញ្ហានានាដែលបានលើកឡើងនៅក្នុងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង02/01នៅថ្ងៃទី23ខែវិច្ឆិកាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលនៃអង្គជំនុំជម្រះរាជសម្បត្តិក្នុងតុលាការកម្ពុជាបានប្រកាសសាលដីការបស់ខ្លួនលើបណ្ដឹងសារទុកប្រឆាំងនឹងសាលក្រមនៅក្នុងសំណុំរឿង002/1ដោយបានតម្កល់សាលក្រមរបស់អង្គជំនុំជម្រះសាលាដំបងផ្ដន្ទាទោសនួនជានិងខៀវសំផនដាក់ពន្ធនាគារអស់មួយជីវិតសំណុំរឿង002/2ដែលជាសំណុំរឿងបន្តពីសំណុំរឿង002/1មានបទចោទជារួមគឺឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងការរំលោភបំពានយ៉ាងធ្ងន់ធ្ងរទៅលើអនុសញ្ញាទីក្រុងហ្សឺណែវឆ្នាំ1949ព្រមទាំងឧក្រិដ្ឋកម្មប្រល័យពូជសាសន៍អង្គជំនុំជម្រះសាលាដំបងបានសម្រេចថាទីតាំងឧក្រិដ្ឋកម្មនិងបទចោទសំខាន់ដទៃទៀតខាងក្រោមនេះគឺជាមូលដ្ឋាននៃការជំនុំជម្រះក្តីសំណុំរឿង002/2អំពើប្រល័យពូជសាសន៍ទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមការរៀបការដោយបង្ខំនិងការរំលោភសេពសន្តិវៈនៅទូទាំងប្រទេសការបោះសម្អាតផ្ទៃក្នុងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅមន្ទីរសន្តិសុខចំនួន4គឺមន្ទីរសន្តិសុខស21ក្រាំងតាចាន់អូកន្សែងនិងភ្នំក្រោលឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅការដ្ឋានចំនួន3គឺទំនប់1មករាទំនប់ត្រពាំងថ្មនិងការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅសហករណ៍ត្រាំកក់ការធ្វើទុកបុកម្នេញខាងព្រះពុទ្ធសាសនាការធ្វើទុកបុកម្នេញមន្ត្រីសាធារណរដ្ឋខ្មែរកម្រិតត្រឹមសហករណ៍ត្រាំកក់ការដ្ឋានទំនប់1មករាមន្ទីរសន្តិសុខស21និងមន្ទីរសន្តិសុខក្រាំងតាចាន់សវនកម្មលើសំណុំរឿង002/2បានចាប់ផ្ដើមដោយសេចក្តីថ្លែងបើករបស់សហព្រះអាជ្ញាកាលពីថ្ងៃទី17ខែតុលាឆ្នាំ2014
អំពើឃោរឃៅមកលើប្រជាជនកម្ពុជាមិនចេះចាប់មិនចេះហើយនឹងបានមានទ្រង់ទ្រាយកាន់តែធំទៅមិនធ្លាប់មានពីមុនដែលបានបណ្ដាលឲ្យទឹកដីកម្ពុជាពោពេញទៅដោយរដូវសាកសពនិងការបាត់បង់ជីវិតបាត់បង់បងប្អូនសាច់ញាតិនេះគឺជាគេដំណើរដ៏សាហាវពិតដែលបានសល់ទុកឲ្យមេដឹកនាំបកកុម្មុយនីសកម្ពុជាដែលកំពុងអង្គុយនៅចំពោះមុខយើងទាំងអស់គ្នានៅថ្ងៃនេះដូច្នេះយើងសម្រាប់អ្នករាល់គ្នាដែលបានសួរថាតើហេតុអ្វីបានជាពួកយើងត្រូវការសវនាការមួយទៀតនៅពេលដែលជនជាប់ចោទដែលមានវ័យចាស់ជរាបានទទួលការផ្ដន្ទាទោសអស់មួយជីវិតទៅហើយនោះចម្លើយគឺសាមញ្ញពួកយើងធ្វើនេះដោយសារប្រជាជនកម្ពុជារាប់លាននាក់ដែលបានស្លាប់ដោយសាររបបមួយនេះក្នុងកំឡុងពេល3ឆ្នាំ8ខែនិង20ថ្ងៃក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យមានតែពួកច្រំមានតែសេចក្តីវិនាសនិងទុកព្រួយមានតែការឈឺចាប់និងសេចក្តីស្លាប់
ខ្ញុំបានទទួលស្គាល់ថាមានជនរួមជាតិជាច្រើនមានការឈឺចាប់នៅក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យដែលបន្តឡើងដោយពួកបំផ្លាញស៊ីរួមទីក្នុងខ្ញុំសោកស្ដាយចំពោះទុក្ខលំបាកនោះហើយខ្ញុំសូមទទួលខុសត្រូវនៃសិលធម៌ចំពោះអំពើនេះដោយសារខ្ញុំជាមេដឹកនាំជនគោះម្នាក់នៃបកកុម្មុយនីសកម្ពុជា
នួនជាបានជម្រាបទៅចៅក្រមថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ធ្វើពហិការមិនចូលរួមជំនុំជម្រះក្តីរហូតដល់ពេលវេលាសំណើប្តឹងដិតចិត្តរបស់គាត់ទៅលើចៅក្រមសាលាដំបងពាក់ព័ន្ធទៅនឹងកំហុសឆ្គងមួយចំនួនត្រូវបានសម្រេចជាមុនសិននៅពេលក្រោយមកក្រុមចៅក្រមពិសេសមួយត្រូវបានបង្កើតឡើងនិងបានច្រានចោលសំណើប្តឹងដិតចិត្តរបស់នួនជាហើយមេធាវីការពារក្តីរបស់គាត់ក៏បានចូលរួមនៅក្នុងការកាត់ក្តីវិញ
គឺរៀបវងចោតតែនៅចំពោះមុខអង្គជំរះនេះ
ជនជាប់ចោទទី2គឺខៀវសំផនបានជម្រាបអង្គជំនុំជម្រះសាលាដំបងថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ចង់អារម្មណ៍តែទៅលើបណ្ដឹងសារទុកជាមុនសិនមុននឹងគាត់និងមេធាវីរបស់គាត់ ចូលរួមនៅក្នុងការជំនុំជម្រះក្តីនៃសំណុំរឿង002 វគ្គ 2
អាកាសក្តីសំណុំរឿង002 លើ 01 អស់លោកបានកាត់ទុកខ្ញុំដោយផ្អែកលើទម្រង់ផតានិងការស្មាននានាដែលខ្ញុំជំទាស់ហើយដោយប្រើមធ្យោបាយដែលខ្ញុំយល់ឃើញថាជាការរំលោភលើសិទ្ធិរបស់ខ្ញុំដែលខ្ញុំត្រូវមានត្រូវបានទទួលការកាត់ក្តីដោយយុត្តិធម៌ហេតុនេះហើយបានជាខ្ញុំបានជម្រាបមេធាវីខ្ញុំឲ្យប្រឹងឧស្សរដែលនៅក្នុងតុលាការនេះគេហៅថាបណ្ដឹងសាទុកសេចក្តីសំអាងហេតុនិងសេចក្តីសន្និដ្ឋានរបស់អស់លោកនៅក្នុងការកាត់ក្តីនេះបង្ហាញច្បាស់ជាបុណ្យស្រេចទៅហើយអស់លោកនឹងសម្រេចយ៉ាងណានៅក្នុងការកាត់ក្តីសំណុំរឿង002 លើ 02 ខាងមុខនេះគ្មានអ្វីគួរឲ្យខ្ញុំស្រពេចស្រពិលទេបើអស់លោកនៅតែប្រើរបៀបគិតគូរដែលខ្ញុំជំទាស់ដោយចំពោះមុខតុលាការកំពូលតាក់ទងនឹងការចោទប្រកាន់ថាខ្ញុំបានចូលរួមប្រព្រឹត្តសហអក្រិតកម្មរួមខ្ញុំដឹងជាមុនស្រេចទៅហើយថាអស់លោកប្រកាសជានឹងផ្ដន្ទាទោសខ្ញុំទៀតក្នុងការកាត់ក្តីដែលអស់លោកកំពុងតែបើកនៅថ្ងៃនេះ
នៅអំឡុងពេលនៃសវនាការអង្គជំនុំជម្រះសាលាដំបងបានស្ដាប់ការបង្ហាញផុសតាងលើប្រធានបទស្ដីពីសហគមន៍ត្រាំកក់រួមទាំងមន្ទីរសន្តិសុខក្រាំងតាច័ន្ទនិងការប្រព្រឹត្តលើពុទ្ធសាសនិកការដ្ឋានទំនប់1មករាការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងការដ្ឋានទំនប់ត្រពាំងថ្មការប្រព្រឹត្តទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមមន្ទីរសន្តិសុខអូកន្សែងមន្ទីរសន្តិសុខក្នុងក្រោលនិងមន្ទីរសន្តិសុខស21និងការបោះសម្អាតផ្ទៃក្នុងការចេញបទបញ្ជាអំពីការរៀបអាពាហ៍ពិពាហ៍លក្ខណៈនៃចំនួនប្រដាប់អាវុធនិងជាចុងក្រោយអំពីទូនាទីរបស់ជនជាប់ចោទនៅថ្ងៃទី11ខែមករាឆ្នាំ2017អង្គជំនុំជម្រះសាលាដំបងបានបិទបញ្ចប់សវនាការលើកផុសតាងនៅក្នុងសំណុំរឿង002 វគ្គ 2ពាក់ព័ន្ធទៅនឹងបទចោទប្រកាន់ស្ដីអំពីឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិអំពើប្រល័យពូជសាសន៍និងការបំពានបំពានយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវប្រឆាំងទៅនឹងជនជាប់ចោទនួនជាតិនិងខៀវសំផន
ប្រជាជនកម្ពុជាទូទាំងរបប
អង្គជំនុំជម្រះសាលាដំបងបានបើកសវនាការធ្វើសេចក្តីសន្និដ្ឋានផ្ទាល់មាត់បិទបញ្ចប់កិច្ចពិភាក្សាដេញដោលនៅខែមិថុនាឆ្នាំ2017
រដ្ឋវិនិម្នាក់បានផ្ដល់សេចក្តីកម្មអំពីជាសនកម្មដែល
សូមជម្រាបថាអង្គជំនុំជម្រះបានធ្វើសវនាការរយៈពេល274ថ្ងៃនៅក្នុងសំណុំរឿង002 វគ្គ 2និងបានស្ដាប់សក្ខីកម្មសាក្សីចំនួន114នាក់ដើមបណ្ដឹងរដ្ឋប្រវេណីចំនួន63នាក់និងអ្នកជំនាញចំនួន8នាក់លើសពីនេះទៀតអង្គជំនុំជម្រះបានផ្ដល់ឱកាសឲ្យភាគីបង្ហាញផុសតាងជាឯកសារសំខាន់ពាក់ព័ន្ធទៅនឹងប្រធានបទសវនាការនីមួយៗនិងបានស្ដាប់ការបញ្ជាក់បន្ថែមរបស់សហមេធាវីនាំមុខតំណាងដើមបណ្ដឹងរដ្ឋប្រវេណីស្ដីពីការទាមទារសំណងនៅក្នុងអំឡុងពេលសវនាការនៅក្នុងសំណុំរឿង002 វគ្គ 2នេះមានសាធារណជនសរុបចំនួន 776,604 នាក់បានចូលរួមស្ដាប់ដោយផ្ទាល់នៅក្នុងសារសវនាការរបស់អង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាអង្គជំនុំជម្រះសាលាដំបងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានប្រកាសសេចក្តីសម្អាងហេតុនិងផ្នែកនៃសេចក្តីសម្រេចនៃសាលក្រមនៅក្នុងសំណុំរឿង002/02ពាក់ព័ន្ធទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផនកាលពីថ្ងៃទី16ខែវិច្ឆិកាឆ្នាំ2018នៅក្នុងសារសវនាការធំនៃអវតក
អង្គជំរះសាលាដំបងរកឃើញថាជនជាប់ចោទនួនជាមានបរិបទដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាចន្លោះថ្ងៃទី17ខែមេសាឆ្នាំ1975 ដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ដោយបានរៀបរាប់ ដោយសង្ខេបខាងលើនេះនិងដោយលម្អិតនៅក្នុងសាក្រមជាលិលាអក្សរតាមរយៈអំពើសកម្មនិងអកម្មចំពោះអកតកម្មទាំងឡាយដូចខាងក្រោមអកតកម្មប្រឆាំងនឹងមនុស្សជាតិតាមរយៈការធ្វើមនុស្សជាតិការសម្លាប់រង្គាលការនិរទេសការធ្វើឲ្យទៅជាសេដ្ឋករការដាក់ក្នុងមន្ទីរឃុំឃាំងការធ្វើទុកបុកម្នេញដោយមូលហេតុនយោបាយការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសនានិងការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសន៍និងអំពើអនុប្រព័ន្ធផ្សេងៗទៀតក្រុមទម្រង់ជាការប៉ះពាល់ដល់សេចក្តីថ្លៃថ្នូររបស់មនុស្សអំពើអនុប្រព័ន្ធផ្សេងៗទៀតក្រុមទម្រង់ជាការបាត់ខ្លួនដោយបង្ខំអំពើអនុប្រព័ន្ធផ្សេងៗទៀតក្រុមទម្រង់ជាការជំនះដោយបង្ខំនិងអំពើអនុប្រព័ន្ធផ្សេងៗទៀតក្រុមទម្រង់ជាការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំនិងការរំលោភផ្លូវភេទនៅក្នុងបទបទនៃការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំអនុលោមតាមបទបញ្ញត្តិនៃវិធានមាត្រា5មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់ដីពីការបង្កើតអវតកការបំពេញបំពេញយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវតាមរយៈការធ្វើមនុស្សភាពដោយចេតនាការធ្វើទរណកម្មការធ្វើបាបដោយអព្យាធម៌ការបង្កដោយចេតនាឲ្យមានរបួសធ្ងន់ឬឲ្យមានការឈឺចាប់ដល់រាងកាយឬសុខភាពការដកហូតដោយចេតនាពីជ្រើសិទ្ធិឬជនស៊ីវិលនៅសិទ្ធិទទួលបានការកាត់ទោសដោយយុត្តិធម៌និងទៀងទាត់និងការឃុំខ្លួនជនស៊ីវិលដែលខុសច្បាប់អនុលោមតាមមាត្រា6មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់ស្តីពីការបង្កើតអវតកឧក្រិដ្ឋកម្មបល័យពិសាសតាមរយៈការធ្វើមនុស្សឃាតលើសមាជិកនៃក្រុមជនជាតិវៀតណាមនិងជនជាតិចាមអង្គជំនះសាលាដំបងរកឃើញថាជនជាប់ចោទគឺសំផនមានវិរុទ្ធដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាដោយចន្លោះពីថ្ងៃ17ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើអង្គជំនះបានពិចារណាទៅលើភាពធ្ងន់ធ្ងរនៃអកតកម្មរួមទាំងទំហំនិងភាពសាហាវព្រៃផ្សៃក៏ដូចជាចំនួននិងភាពទន់ខ្សោយរបស់ជនរងគ្រោះដែលជនជាប់ចោទត្រូវបានរកឃើញមានប្រសិទ្ធភាពរួមទាំងស្ថានទម្ងន់និងស្ថានបម្រើទោសនានាដែលពាក់ព័ន្ធអង្គជំរះសម្រាប់ផ្ដន្ទាទោសជនជាប់ចោទនួនជាដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាលើការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង002/01អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្ដន្ទាទោសទាំងពីរទៅជាការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយអង្គជំរះសម្រាប់ផ្ដន្ទាទោសជនជាប់ចោទគឺសំផនដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាទៅលើការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង002/01អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្ដន្ទាទោសទាំងពីរទៅជាការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយ
សាធារណជនប្រមាណជាជាង700នាក់រួមមានតំណាងរាជរដ្ឋាភិបាលកម្ពុជាតំណាងអង្គការសហប្រជាជាតិនិងមន្ត្រីអង្គទូតអង្គការសង្គមស៊ីវិលនានារួមនឹងសាធារណជននិងអ្នកសារព័ត៌មានជាតិនិងអន្តរជាតិបានចូលរួមស្ដាប់ការប្រកាសសារក្រមជាប្រវត្តិសាស្ត្រនេះយើងខ្ញុំសូមរំលឹកសាធារណជនថានៅក្នុងដំណាក់កាលនេះបទចោទប្រឆាំងទៅនឹងនួនជានិងឃ្យូសំផននៅក្នុងសំណុំរឿង002/2គ្រាន់តែជាការចោទប្រកាន់តែប៉ុណ្ណោះមិនទាន់មានការសម្រេចជាស្ថាពរនៅឡើយទេថាតើជនជាប់ចោទទាំងពីរមានទោសឬក៏គ្មានទោសជនជាប់ចោទទាំងពីរត្រូវបានសន្មតទុកជាមុនថាគ្មានទោសដរាបណាសាលដីកាស្ថាពរមិនទាន់ចូលជាធរមាននៅឡើយជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាដែលគេស្គាល់ថាសាលាដីខ្មែរក្រហមត្រូវបានបង្កើតឡើងដើម្បីឆ្លើយតបទៅនឹងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅចន្លោះថ្ងៃទី17ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ជារយៈពេលដែលប៉ុល ពតកាន់កាប់អំណាច ប្រជាជនយ៉ាងហោចណាស់1.7 លាននាក់ត្រូវបានជឿជាក់ថាត្រូវបានស្លាប់ដោយសារការធ្វើការងារហួសកម្លាំងការបង្អត់អាហារការធ្វើទារុណកម្មសម្លាប់និងលក្ខខណ្ឌរស់នៅដ៏អមនុស្សធម៌ដទៃទៀតសំណុំរឿង002 វគ្គ 2 គឺជាការជំនុំជម្រះដីទី2ប្រឆាំងទៅនឹងអតីតប្រមុខរដ្ឋខៀវសំផននិងអតីតអនុលេខាបកកុម្មុយនីសកម្ពុជាលោកនួនជាជនជាប់ចោទទាំងពីរត្រូវបានបញ្ជូនទៅជំនុំជម្រះដីកាលពីខែកញ្ញាឆ្នាំ2010ដោយសារទំហំនិងភាពស្មុគស្មាញនៃបទចោទនាពេលរស់រានមានជីវិតរបស់ជនជាប់ចោទឬក្នុងពេលដែលជនជាប់ចោទនៅអាចជំនុំជម្រះដីបានដែលការបញ្ជូនរឿងទៅជំនុំជម្រះត្រូវបានបែងចែកជាការជំនុំជម្រះដីចំនួន2ដែលហៅថាសំណុំរឿង002 វគ្គទី1និងសំណុំរឿង002 វគ្គទី2ការជំនុំជម្រះក្តីដំណាក់កាលទី1ផ្ដោតសំខាន់ទៅលើបទចោទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិដែលតាក់ទងទៅនឹងការជំនះដោយបង្ខំពីទីក្រុងភ្នំពេញកាលពីខែមេសាឆ្នាំ1975និងក្រោយមកគឺមានការជំនះពីតំបន់ដទៃទៀតក៏មានបទចោទតាក់ទងទៅនឹងការសម្លាប់អតីតទាហានសាធារណរដ្ឋខ្មែរនៅទួលពោធិ៍ជ្រៃនៅក្នុងស្រុកកណ្ដៀងខេត្តពោធិ៍សាត់អង្គជំនុំជម្រះសាលាដំបូងនៃអង្គជំនុំជម្រះវិស្ម័យក្នុងតុលាការកម្ពុជាហៅកាត់ថាអវតកបានរកឃើញនួនជានិងខៀវសំផនមានពិរុទ្ធពីបទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងបានសម្រេចផ្តន្ទាទោសពួកគាត់ដាក់ពន្ធនាគារអស់មួយជីវិតកាលពីថ្ងៃទី7 ខែសីហាឆ្នាំ2014
ទាំងការធ្វើមុខភាពការធ្វើទុកបុកម្នេញ
សហព្រះរាជអាជ្ញាជនជាប់ចោទទាំងពីរបានប្តឹងសារទុកទៅកាន់អង្គជំនុំជម្រះតុលាការកំពូលហើយតុលាការកំពូលបានធ្វើសវនាការរួចហើយតាក់ទងទៅនឹងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង002/01ព្រមទាំងបានស្ដាប់សក្ខីកម្មរបស់សាក្សី3រូបកាលពីថ្ងៃទី2ទី3និងទី6ខែកក្កដាឆ្នាំ2015នៅថ្ងៃទី16 17 18ខែកក្កដាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលបានធ្វើសវនាការស្ដាប់សារណាផ្ទាល់មាត់លើបញ្ហានានាដែលបានលើកឡើងនៅក្នុងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង002 វគ្គ 01នៅថ្ងៃទី23ខែវិច្ឆិកាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលនៃអង្គជំនុំជម្រះវិស្ម័យក្នុងតុលាការកម្ពុជាបានប្រកាសសាលដីការបស់ខ្លួនលើបណ្ដឹងសារទុកប្រឆាំងនឹងសាលក្រមនៅក្នុងសំណុំរឿង002 វគ្គ 1ដោយបានតម្កល់សាលក្រមរបស់អង្គជំនុំជម្រះសាលាដំបូងផ្ដន្ទាទោសនួនជានិងខៀវសំផនដាក់ពន្ធនាគារអស់មួយជីវិតសំណុំរឿង002 វគ្គ 2ដែលជាសំណុំរឿងបន្តពីសំណុំរឿង002 វគ្គ 1មានបទចោទជារួមគឺឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងការរំលោភបំពានយ៉ាងធ្ងន់ធ្ងរទៅលើអនុសញ្ញាទីក្រុងហ្សឺណែវឆ្នាំ1949ព្រមទាំងឧក្រិដ្ឋកម្មប្រល័យពូជសាសន៍អង្គជំនុំជម្រះសាលាដំបូងបានសម្រេចថាទីតាំងឧក្រិដ្ឋកម្មនិងបទចោទសំខាន់ដទៃទៀតខាងក្រោមនេះគឺជាមូលដ្ឋាននៃការជំនុំជម្រះក្តីសំណុំរឿង002 វគ្គ 2អំពើប្រល័យពូជសាសន៍ទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមការរៀបការដោយបង្ខំនិងការរំលោភសេពសន្តិវៈនៅទូទាំងប្រទេសការបោះសម្អាតផ្ទៃក្នុងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅមន្ទីរសន្តិសុខចំនួន4គឺមន្ទីរសន្តិសុខស21ក្រាំងតាចាន់អូកន្សែងនិងភ្នំក្រោលឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅការដ្ឋានចំនួន3គឺទំនប់1មករាទំនប់ត្រពាំងថ្មនិងការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅសហគមន៍5កក់ការធ្វើទុកបុកម្នេញខាងព្រះពុទ្ធសាសនាការធ្វើទុកបុកម្នេញមន្ត្រីសាធារណរដ្ឋខ្មែរកម្រិតត្រឹមសហគមន៍5កក់ការដ្ឋានទំនប់1មករាមន្ទីរសន្តិសុខស21និងមន្ទីរសន្តិសុខក្រាំងតាចាន់សវនកម្មលើសំណុំរឿង002 វគ្គ 2បានចាប់ផ្ដើមដោយសេចក្តីថ្លែងបើករបស់សហព្រះអាជ្ញាកាលពីថ្ងៃទី17ខែតុលាឆ្នាំ2014
អំពើឃោរឃៅមកលើប្រជាជនកម្ពុជាមិនចេះចប់មិនចេះហើយនឹងបានមានទ្រង់ទ្រាយកាន់តែធំទៅមិនធ្លាប់មានពីមុនដែលបានបណ្ដាលឲ្យទឹកដីកម្ពុជាពោពេញទៅដោយរដូវសាកសពនិងការបាត់បង់ជីវិតបាត់បង់បងប្អូនសាច់ញាតិនេះគឺជាគេដំណើរដ៏សាហាវពិតដែលបានសល់ទុកឲ្យមេដឹកនាំបកកុម្មុយនីសកម្ពុជាដែលកំពុងអង្គុយនៅចំពោះមុខយើងទាំងអស់គ្នានៅថ្ងៃនេះដូច្នេះយើងសម្រាប់អ្នករាល់គ្នាដែលបានសួរថាតើហេតុអ្វីបានជាពួកយើងត្រូវការសវនាការមួយទៀតនៅពេលដែលជនជាប់ចោទដែលមានវ័យចាស់ជរា បានទទួលការផ្ដន្ទាទោសអស់មួយជីវិតទៅហើយនោះចម្លើយគឺសាមញ្ញពួកយើងធ្វើនេះដោយសារប្រជាជនកម្ពុជារាប់លាននាក់តែបានស្លាប់ដោយសាររបបមួយនេះក្នុងកំឡុងពេល3ឆ្នាំ8ខែនិង20ថ្ងៃក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យមានតែពួកជ្រាំមានតែសក្តិវិនាសនិងទុកព្រួយមានតែការឈឺចាប់និងសក្តិស្លាប់
ខ្ញុំបានទទួលស្គាល់ថាមានជនរួមជាតិជាច្រើនមានការឈឺចាប់នៅក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យដែលបង្កឡើងដោយពួកបំផ្លាញស៊ីរួមទីក្នុងខ្ញុំសោកស្ដាយចំពោះទុក្ខលំបាកនោះហើយខ្ញុំសូមទទួលខុសត្រូវនៃសិលធម៌ចំពោះអំពើនេះដោយសារខ្ញុំជាមេដឹកនាំជាន់ខ្ពស់ម្នាក់នៃបកកុម្មុយនីសកម្ពុជា
នួនជាបានជម្រាបទៅចៅក្រមថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ធ្វើពហិការមិនចូលរួមជំនុំជម្រះក្តីរហូតដល់ពេលវេលាសំណើប្តឹងដិតចិត្តរបស់គាត់ទៅលើចៅក្រមសាលាដំបងពាក់ព័ន្ធទៅនឹងកំហុសឆ្គងមួយចំនួនត្រូវបានសម្រេចជាមុនសិននៅពេលក្រោយមកក្រុមចៅក្រមពិសេសមួយត្រូវបានបង្កើតឡើងនិងបានច្រានចោលសំណើប្តឹងដិតចិត្តរបស់នួនជាហើយមេធាវីការពារក្តីរបស់គាត់ក៏បានចូលរួមនៅក្នុងការកាត់ក្តីវិញ
គឺរៀងមុខចោតតែនៅចំពោះមុខអង្គជំរះនេះ
ជនជាប់ចោតទី2គឺខៀវសំផតបានជម្រាបអង្គជំនុំជម្រះសាលាដំបងថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ចង់អារម្មណ៍តែទៅលើបណ្ដឹងសារទុកជាមុនសិនមុននឹងគាត់និងមេធាវីរបស់គាត់ចូលរួមនៅក្នុងការជំនុំជម្រះក្តីនៃសំណុំរឿង002វគ្គ2
អាកាត់ក្តីសំណុំរឿង002លើ01អស់លោកបានកាត់ទុកខ្ញុំដោយផ្អែកលើទម្រង់ផតានិងការស្មាននានាដែលខ្ញុំជំទាស់ហើយដោយប្រើមធ្យោបាយដែលខ្ញុំយល់ឃើញថាជាការរំលោភលើសិទ្ធិរបស់ខ្ញុំដែលខ្ញុំត្រូវបានទទួលការកាត់ក្តីដោយយុត្តិធម៌ហេតុនេះហើយបានជាខ្ញុំបានជម្រាបមេធាវីខ្ញុំឲ្យប្តឹងឧទ្ធរណ៍ដែលនៅក្នុងតុលាការនេះគេហៅថាបណ្ដឹងសារទុកសេចក្តីសំអាងហេតុនិងសេចក្តីសន្និដ្ឋានរបស់អស់លោកនៅក្នុងការកាត់ក្តីនេះបង្ហាញច្បាស់ជាមុនស្រេចទៅហើយអស់លោកនឹងសម្រេចយ៉ាងណានៅក្នុងការកាត់ក្តីសំណុំរឿង002លើ02ខាងមុខនេះគ្មានអ្វីគួរឲ្យខ្ញុំស្រពេចស្រពិលទេបើអស់លោកនៅតែប្រើរបៀបគិតគូរដែលខ្ញុំជំទាស់ដោយចំពោះមុខតុលាការកំពូលតាក់ទងនឹងការចោទប្រកាន់ថាខ្ញុំបានចូលរួមប្រព្រឹត្តសហអក្រិតកម្មរួមខ្ញុំដឹងជាមុនស្រេចទៅហើយថាអស់លោកប្រកាសជានឹងផ្ដន្ទាទោសខ្ញុំទៀតក្នុងការកាត់ក្តីដែលអស់លោកកំពុងតែបើកនៅថ្ងៃនេះ
នៅអំឡុងពេលនៃសវនាការអង្គជំនុំជម្រះសាលាដំបងបានស្ដាប់ការបង្ហាញខុសខាងលើប្រធានបទស្ដីពីសហគមន៍ត្រាំកក់រួមទាំងមន្ទីរសន្តិសុខត្រាំងតាចាន់និងការប្រព្រឹត្តលើពុទ្ធសាសនិកការដ្ឋានទំនប់1មករាការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងការដ្ឋានទំនប់ត្រពាំងថ្មការប្រព្រឹត្តទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមមន្ទីរសន្តិសុខអូកន្សែងមន្ទីរសន្តិសុខភ្នំក្រោលនិងមន្ទីរសន្តិសុខស21និងការបោសសម្អាតផ្ទៃក្នុងការចេញប័ណ្ណបញ្ជាអំពីការរៀបអាពាហ៍ពិពាហ៍លក្ខណៈនៃចំនួនប្រដាប់អាវុធនិងជាចុងក្រោយអំពីទូនាទីរបស់ជនជាប់ចោតនៅថ្ងៃទី11ខែមករាឆ្នាំ2017អង្គជំនុំជម្រះសាលាដំបងបានបិទបញ្ចប់សវនាការលើកផុសតាងនៅក្នុងសំណុំរឿង002វគ្គ2ពាក់ព័ន្ធទៅនឹងបទចោទប្រកាន់ស្ដីអំពីឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិអំពើប្រល័យពូជសាសន៍និងការបំពានបំពានយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាក្រុងហ្សឺណែវប្រឆាំងទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផត
ប្រជាជនកម្ពុជាទូទាំង
អង្គជំនុំជម្រះសាលាដំបងបានបើកសវនាការធ្វើសេចក្តីសន្និដ្ឋានផ្ទាល់មាត់បិទបញ្ចប់កិច្ចពិភាក្សាដេញដោលនៅខែមិថុនាឆ្នាំ 2017
រដ្ឋវិនិច្ឆ័យម្នាក់បានផ្ដល់សក្ខីកម្មអំពីវិជាសនកម្មដោយ
សូមជម្រាបថាអង្គជំនុំជម្រះបានធ្វើសវនាការរយៈពេល 274 ថ្ងៃនៅក្នុងសំណុំរឿង 002 វគ្គ 2 និងបានស្ដាប់សក្ខីកម្មសាក្សីចំនួន 114 នាក់ដើមបណ្ដឹងរ៉ាប់ប្រវេណីចំនួន 63 នាក់និងអ្នកជំនាញចំនួន 8 នាក់លើសពីនេះទៀតអង្គជំនុំជម្រះបានផ្ដល់ឱកាសឲ្យភាគីបង្ហាញភស្តុតាងជាឯកសារសំខាន់ៗពាក់ព័ន្ធទៅនឹងប្រធានបទសវនាការនីមួយៗនិងបានស្ដាប់ការបញ្ជាក់បន្ថែមរបស់សហមេធាវីនាំមុខតំណាងដើមបណ្ដឹងរ៉ាប់ប្រវេណីស្ដីពីការទាមទារសំណង នៅក្នុងអំឡុងពេលសវនាការនៅក្នុងសំណុំរឿង 002 វគ្គ 2 នេះមានសាធារណជនសរុបចំនួន 776,604 នាក់បានចូលរួមស្ដាប់ដោយផ្ទាល់នៅក្នុងសារសវនាការរបស់អង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាអង្គជំនុំជម្រះសាលាដំបងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានប្រកាសសេចក្តីសម្អាងហេតុនិងផ្នែកនៃសេចក្តីសម្រេចនៃសាលក្រមនៅក្នុងសំណុំរឿង 002/02 ពាក់ព័ន្ធទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផនកាលពីថ្ងៃទី 16 ខែវិច្ឆិកាឆ្នាំ 2018 នៅក្នុងសារសវនាការធំនៃអវតក
អង្គជំរះសាលាដំបងរកឃើញថាជនជាប់ចោទនួនជាមានបរិបទដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាចន្លោះថ្ងៃទី 17 ខែមេសាឆ្នាំ 1975 ដល់ថ្ងៃទី 6 ខែមករាឆ្នាំ 1979 ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើនេះនិងដោយលម្អិតនៅក្នុងសារក្រមជាលិលាអក្សរតាមរយៈអំពើសកម្មនិងអកម្មចំពោះអកតកម្មទាំងឡាយដូចខាងក្រោមអកតកម្មប្រឆាំងនឹងមនុស្សជាតិតាមរយៈការធ្វើនុភាពការសម្លាប់រង្គាលការនិរទេសការធ្វើឲ្យទៅជាសេដ្ឋករការដាក់ក្នុងមន្ទីរឃុំឃាំងការធ្វើទុកបុកម្នេញដោយមូលហេតុនយោបាយការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសនានិងការធ្វើទុកបុកម្នេញដោយមូលហេតុភូមិសាស្ត្រនិងអំពើអនុប្រព័ន្ធផ្សេងៗទៀតក្រមទម្រង់ជាការប៉ះពាល់ដល់សេចក្តីថ្លៃថ្នូររបស់មនុស្សអំពើអមនុស្សធម៌ផ្សេងៗទៀតក្រមទម្រង់ជាការបាត់ខ្លួនដោយបង្ខំអំពើអមនុស្សធម៌ផ្សេងៗទៀតក្រមទម្រង់ជាការជំនះដោយបង្ខំនិងអំពើអមនុស្សធម៌ផ្សេងៗទៀតក្រមទម្រង់ជាការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំនិងការរំលោភផ្លូវភេទនៅក្នុងបទបទនៃការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំអនុលោមតាមបទបញ្ញត្តិនៃវិធានមាត្រា 5 មាត្រា 29 ថ្មីនិងមាត្រា 39 ថ្មីនៃច្បាប់ដីពីការបង្កើតអវតកការបំពេញយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវតាមរយៈការធ្វើមនុស្សភាពដោយចេតនាការធ្វើទរណកម្មការធ្វើបាបដោយអព្យាធម៌ការបង្កដោយចេតនាឲ្យមានរបួសធ្ងន់ឬឲ្យមានការឈឺចាប់ដល់រាងកាយឬសុខភាពការដកហូតដោយចេតនាពីជ្រើសសឹកឬជនស៊ីវិលនៅសិទ្ធិទទួលបានការកាត់ទោសដោយយុត្តិធម៌និងទៀងទាត់និងការឃុំខ្លួនជនស៊ីវិលដែលខុសច្បាប់អនុលោមតាមមាត្រា 6 មាត្រា 29 ថ្មីនិងមាត្រា 39 ថ្មីនៃច្បាប់ស្តីពីការបង្កើតអវតកឧក្រិដ្ឋកម្មបល័យពិសាសតាមរយៈការធ្វើមនុស្សឃាតលើសមាជិកនៃក្រុមជនជាតិវៀតណាមនិងជនជាតិចាមអង្គជំរះសាលាដំបងរកឃើញថាជនជាប់ចោទគឺសំផនមានវិរុទ្ធដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាដោយចន្លោះពីថ្ងៃ 17 ខែមេសាឆ្នាំ 1975 រហូតដល់ថ្ងៃទី 6 ខែមករាឆ្នាំ 1979 ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើអង្គជំរះបានពិចារណាទៅលើភាពធ្ងន់ធ្ងរនៃអកតកម្មរួមទាំងទំហំនិងភាពសាហាវព្រៃផ្សៃក៏ដូចជាចំនួននិងភាពទន់ខ្សោយរបស់ជនរងគ្រោះដែលជនជាប់ចោទត្រូវបានរកឃើញមានប្រវត្តិភាពរួមទាំងស្ថានទម្ងន់និងស្ថានបម្រើទោសនានាដែលពាក់ព័ន្ធអង្គជំរះសម្រាប់ផ្តន្ទាទោសជនជាប់ចោទនួនជាដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាលើការផ្តន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង 002/01 អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្តន្ទាទោសទាំងពីរទៅជាការផ្តន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយអង្គជំរះសម្រាប់ផ្តន្ទាទោសជនជាប់ចោទគឺសំផនដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាទៅលើការផ្តន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង 002/01 អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នាលើការផ្តន្ទាទោសទាំងពីរ ទៅជាការប្រន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយ
សាធារណជនប្រមាណជាជាង700នាក់រួមមានតំណាងរាជរដ្ឋាភិបាលកម្ពុជាតំណាងអង្គការសហប្រជាជាតិនិងមន្ត្រីអង្គទូតអង្គការសង្គមស៊ីវិលនានារួមនឹងសាធារណជននិងអ្នកសារព័ត៌មានជាតិនិងអន្តរជាតិបានចូលរួមស្ដាប់ការប្រកាសសារក្រមជាប្រវត្តិសាស្ត្រនេះយើងខ្ញុំសូមរំលឹកសាធារណជនថានៅក្នុងដំណាក់កាលនេះបទចោទប្រឆាំងទៅនឹងនួនជានិងឃ្យូសំផននៅក្នុងសំណុំរឿង002វគ្គ2គ្រាន់តែជាការចោទប្រកាន់តែប៉ុណ្ណោះមិនទាន់មានការសម្រេចជាស្ថាពរនៅឡើយទេថាតើជនជាប់ចោទទាំងពីរមានទោសឬក៏គ្មានទោសជនជាប់ចោទទាំងពីរត្រូវបានសន្មតទុកជាមុនថាគ្មានទោសដរាបណាសាលដីកាស្ថាពរមិនទាន់ចូលជាធរមាននៅឡើយអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាដែលគេស្គាល់ថាសាលាដីខ្មែរក្រហមត្រូវបានបង្កើតឡើងដើម្បីឆ្លើយតបទៅនឹងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅចន្លោះថ្ងៃទី17ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ជារយៈពេលដែលប៉ុល ពតកាន់កាប់អំណាចប្រជាជនយ៉ាងហោចណាស់1,700,000 នាក់ត្រូវបានជឿជាក់ថាត្រូវបានស្លាប់ដោយសារការធ្វើការងារហួសកម្លាំងការបង្អត់អាហារការធ្វើទារុណកម្មសម្លាប់និងលក្ខខណ្ឌរស់នៅដ៏អមនុស្សធម៌ដទៃទៀតសំណុំរឿង002វគ្គ2គឺជាការជំនុំជម្រះដីទី2ប្រឆាំងទៅនឹងអតីតប្រមុខរដ្ឋខៀវសំផននិងអតីតអនុលេខាបកកុម្មុយនីសកម្ពុជាលោកនួនជាជនជាប់ចោទទាំងពីរត្រូវបានបញ្ជូនទៅជំនុំជម្រះដីកាលពីខែកញ្ញាឆ្នាំ2010ដោយសារទំហំនិងភាពស្មុគស្មាញនៃបទចោទនាពេលរស់រានមានជីវិតរបស់ជនជាប់ចោទឬក្នុងពេលដែលជនជាប់ចោទនៅអាចជំនុំជម្រះដីបានដែលការបញ្ជូនរឿងទៅជំនុំជម្រះត្រូវបានបែងចែកជាការជំនុំជម្រះដីចំនួន2ដែលហៅថាសំណុំរឿង002វគ្គទី1និងសំណុំរឿង002វគ្គទី2ការជំនុំជម្រះក្តីដំណាក់កាលទី1ផ្ដោតសំខាន់ទៅលើបទចោទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិដែលតាក់ទងទៅនឹងការជំនះដោយបង្ខំពីទីក្រុងភ្នំពេញកាលពីខែមេសាឆ្នាំ1975និងក្រោយមកគឺមានការជំនះពីតំបន់ដទៃទៀតក៏មានបទចោទតាក់ទងទៅនឹងការសម្លាប់អតីតទាហានសាធារណរដ្ឋខ្មែរនៅទួលពោធិ៍ជ្រៃនៅក្នុងស្រុកកណ្ដៀងខេត្តពោធិ៍សាត់អង្គជំនុំជម្រះសាលាដំបងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាហៅកាត់ថា អវតក បានរកឃើញនួនជានិងឃ្យូសំផនមានពិរុទ្ធពីបទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងបានសម្រេចផ្តន្ទាទោសពួកគាត់ដាក់ពន្ធនាគារអស់មួយជីវិតកាលពីថ្ងៃទី7ខែសីហាឆ្នាំ2014
ទាំងការធ្វើមនុស្សជាតិការធ្វើទុកបុកម្នេញ
សហព្រះរាជអាជ្ញាជនជាប់ចោទទាំងពីរបានប្តឹងសារទុកទៅកាន់អង្គជំនុំជម្រះតុលាការកំពូលហើយតុលាការកំពូលបានធ្វើសវនាការរួចហើយតាក់ទងទៅនឹងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង002/01ព្រមទាំងបានស្ដាប់សក្ខីកម្មរបស់សាក្សី3រូបកាលពីថ្ងៃទី2ទី3និងទី6ខែកក្កដាឆ្នាំ2015នៅថ្ងៃទី16 17 18ខែកក្កដាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលបានធ្វើសវនាការស្ដាប់សារណាផ្ទាល់មាត់លើបញ្ហានានាដែលបានលើកឡើងនៅក្នុងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង002វគ្គ01នៅថ្ងៃទី23ខែវិច្ឆិកាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានប្រកាសសាលដីការបស់ខ្លួនលើបណ្ដឹងសារទុកប្រឆាំងនឹងសាលក្រមនៅក្នុងសំណុំរឿង002វគ្គ1ដោយបានតម្កល់សាលក្រមរបស់អង្គជំនុំជម្រះសាលាដំបងផ្តន្ទាទោសនួនជានិងឃ្យូសំផនដាក់ពន្ធនាគារអស់មួយជីវិតសំណុំរឿង002វគ្គ2ដែលជាសំណុំរឿងបន្តពីសំណុំរឿង002វគ្គ1មានបទចោទជារួមគឺឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងការរំលោភបំពានយ៉ាងធ្ងន់ធ្ងរទៅលើអនុសញ្ញាទីក្រុងហ្សឺណែវឆ្នាំ1949ព្រមទាំងឧក្រិដ្ឋកម្មប្រល័យពូជសាសន៍អង្គជំនុំជម្រះសាលាដំបងបានសម្រេចថា ទីតាំងឧក្រិដ្ឋកម្មនិងបទចោទសំខាន់ដទៃទៀតខាងក្រោមនេះគឺជាមូលដ្ឋាននៃការជំនុំជម្រះក្តីសំណុំរឿង002 វគ្គ 2 អំពើប្រល័យពូជសាសន៍ទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមការរៀបការដោយបង្ខំនិងការរំលោភសេពសន្តិវៈនៅទូទាំងប្រទេសការបោះសម្អាតផ្ទៃក្នុងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅមន្ទីរសន្តិសុខចំនួន 4 គឺមន្ទីរសន្តិសុខស21 ក្រាំងតាចាន់ អូកន្សែងនិងភ្នំក្រោលឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅការដ្ឋានចំនួន 3 គឺទំនប់1មករាទំនប់ត្រពាំងថ្មនិងការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅសហគមន៍5កក់ការធ្វើទុកបុកម្នេញខាងព្រះពុទ្ធសាសនាការធ្វើទុកបុកម្នេញមន្ត្រីសាធារណរដ្ឋខ្មែរកម្រិតត្រឹមសហគមន៍5កក់ការដ្ឋានទំនប់1មករាមន្ទីរសន្តិសុខស21និងមន្ទីរសន្តិសុខក្រាំងតាចាន់សវនកម្មលើសំណុំរឿង002 វគ្គ 2 បានចាប់ផ្ដើមដោយសេចក្តីថ្លែងបើករបស់សហភាពអាជ្ញាកាលពីថ្ងៃទី17 ខែតុលាឆ្នាំ2014
អំពើឃោរឃៅមកលើប្រជាជនកម្ពុជាមិនចេះចប់មិនចេះហើយនឹងបាច់មានទ្រង់ទ្រាយកាន់តែធំទៅមិនធ្លាប់មានពីមុនដែលបានបណ្ដាលឲ្យទឹកដីកម្ពុជាពោពេញទៅដោយរដូវសាក់សពនិងការបាត់បង់ជីវិតបាត់បង់បងប្អូនសាច់ញាតិនេះគឺជាកេរដំណែលដ៏សាហាវពិតដែលបានសល់ទុកដោយមេដឹកនាំបកកុម្មុយនីសកម្ពុជាដែលកំពុងអង្គុយនៅចំពោះមុខយើងទាំងអស់គ្នានៅថ្ងៃនេះដូច្នេះយើងសម្រាប់អ្នករាល់គ្នាដែលបានសួរថាតើហេតុអ្វីបានជាពួកយើងត្រូវការសាវនាការមួយទៀតនៅពេលដែលជនជាប់ចោទដែលមានវ័យចាស់ជរាបានទទួលការផ្ដន្ទាទោសអស់មួយជីវិតទៅហើយនោះចម្លើយគឺសាមញ្ញពួកយើងធ្វើនេះដោយសារប្រជាជនកម្ពុជារាប់លាននាក់ដែលបានស្លាប់ដោយសាររបបមួយនេះក្នុងកំឡុងពេល3ឆ្នាំ8ខែនិង20ថ្ងៃក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យមានតែពួកជ្រាំមានតែសក្តិវិនាសនិងទុកព្រួយមានតែការឈឺចាប់និងសក្តិស្លាប់
ខ្ញុំបានទទួលស្គាល់ថាមានជនរួមជាតិជាច្រើនមានការឈឺចាប់នៅក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យដែលបង្កឡើងដោយពួកបំផ្លាញស៊ីរួមទីក្នុងខ្ញុំសោកស្ដាយចំពោះទុក្ខលំបាកនោះហើយខ្ញុំសូមទទួលខុសត្រូវនៃសិលធម៌ចំពោះអំពើនេះដោយសារខ្ញុំជាមេដឹកនាំជាន់ខ្ពស់ម្នាក់នៃបកកុម្មុយនីសកម្ពុជា
នួនជាបានជម្រាបទៅចៅក្រមថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ធ្វើពហិការមិនចូលរួមជំនុំជម្រះក្តីរហូតដល់ពេលវេលាសំណើប្តឹងដិតចិត្តរបស់គាត់ទៅលើចៅក្រមសាលាដំបងពាក់ព័ន្ធទៅនឹងកំហុសឆ្គងមួយចំនួនត្រូវបានសម្រេចជាមុនសិននៅពេលក្រោយមកក្រុមចៅក្រមពិសេសមួយត្រូវបានបង្កើតឡើងនិងបានច្រានចោលសំណើប្តឹងដិតចិត្តរបស់នួនជាហើយមេធាវីការពារក្តីរបស់គាត់ក៏បានចូលរួមនៅក្នុងការកាត់ក្តីវិញ
ធ្វើរៀងមុខចោតតែនៅចំពោះមុខអង្គជំរះនេះ
ជនជាប់ចោតទី2គឺខៀវសំផតបានជម្រាបអង្គជំនុំជម្រះសាលាដំបងថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ចង់អារម្មណ៍តែទៅលើបណ្ដឹងសារទុកជាមុនសិនមុននឹងគាត់និងមេធាវីរបស់គាត់ចូលរួមនៅក្នុងការជំនុំជម្រះក្តីនៃសំណុំរឿង002 វគ្គ 2
អាការក្តីសំណុំរឿង002លើ01អស់លោកបានកាត់ទុកខ្ញុំដោយផ្អែកលើទម្រង់ផតានិងការស្មាននានាដែលខ្ញុំជំទាស់ហើយដោយប្រើមធ្យោបាយដែលខ្ញុំយល់ឃើញថាជាការរំលោភលើសិទ្ធិរបស់ខ្ញុំដែលខ្ញុំត្រូវបានទទួលការកាត់ក្តីដោយយុត្តិធម៌ហេតុនេះហើយបានជាខ្ញុំបានជម្រាបមេធាវីខ្ញុំឲ្យប្រឹងឧទ្ធរណ៍ដែលនៅក្នុងត្រាការនេះគេហៅថាបណ្ដឹងសារទុកសេចក្តីសំអាងហេតុនិងសេចក្តីសន្និដ្ឋានរបស់អស់លោកនៅក្នុងការកាត់ក្តីនេះបង្ហាញច្បាស់ជាមុនស្រេចទៅហើយអស់លោកនឹងសម្រេចយ៉ាងណានៅក្នុងការកាត់ក្តីសំណុំរឿង002លើ02ខាងមុខនេះ គ្មានអ្វីគួរឲ្យខ្ញុំស្រពេចស្រពិលទេបើអស់លោកនៅតែប្រើរបៀបគិតគូរដែលខ្ញុំជំទាស់ទៅចំពោះមុខតុលាការកំពូលតាក់ទងនឹងការចោទប្រកាន់ថាខ្ញុំបានចូលរួមប្រព្រឹត្តសហអក្រិតកម្មរួមខ្ញុំដឹងជាមុនស្រេចទៅហើយថាអស់លោកប្រកាសជានឹងផ្ដន្ទាទោសខ្ញុំទៀតក្នុងការកាត់ក្តីដែលអស់លោកកំពុងតែបើកនៅថ្ងៃនេះ
នៅអំឡុងពេលនៃសវនាការអង្គជំនុំជម្រះសាលាដំបងបានស្ដាប់ការបង្ហាញផុសតាងលើប្រធានបទស្ដីពីសហគមន៍ត្រាំកក់រួមទាំងមន្ទីរសន្តិសុខក្រាំងកាចាន់និងការប្រព្រឹត្តលើពុទ្ធសាសនិកការដ្ឋានទំនប់1មករាការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងការដ្ឋានទំនប់ត្រពាំងថ្មការប្រព្រឹត្តទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមមន្ទីរសន្តិសុខអូកន្សែងមន្ទីរសន្តិសុខភ្នំក្រោលនិងមន្ទីរសន្តិសុខស21និងការបោះសម្អាតផ្ទៃក្នុងការចេញបទបញ្ជាអំពីការរៀបអាពាហ៍ពិពាហ៍លក្ខណៈនៃចំនួនប្រដាប់អាវុធនិងជាចុងក្រោយអំពីទូនាទីរបស់ជនជាប់ចោទនៅថ្ងៃទី11ខែមករាឆ្នាំ2017អង្គជំនុំជម្រះសាលាដំបងបានបិទបញ្ចប់សវនាការលើកផុសតាងនៅក្នុងសំណុំរឿង002វគ្គ2ពាក់ព័ន្ធទៅនឹងបទចោទប្រកាន់ស្ដីអំពីឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិអំពើប្រល័យពូជសាសន៍និងការបំពានបំពានយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវប្រឆាំងទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផន
ប្រជាជនកម្ពុជាទូទាំងរបប
អង្គជំនុំជម្រះសាលាដំបងបានបើកសវនាការធ្វើសេចក្តីសន្និដ្ឋានផ្ទាល់មាត់បិទបញ្ចប់កិច្ចពិភាក្សាដេញដោលនៅខែមិថុនាឆ្នាំ2017
រដ្ឋវិញ្ញាម្នាក់បានផ្ដល់សេចក្តីកម្មអំពីជាសនកម្មដោយ
សូមជម្រាបថាអង្គជំនុំជម្រះបានធ្វើសវនាការរយៈពេល274ថ្ងៃនៅក្នុងសំណុំរឿង002វគ្គ2និងបានស្ដាប់សក្ខីកម្មសាក្សីចំនួន114នាក់ដើមបណ្ដឹងរដ្ឋប្រវេណីចំនួន63នាក់និងអ្នកជំនាញចំនួន8នាក់លើសពីនេះទៀតអង្គជំនុំជម្រះបានផ្ដល់ឱកាសឲ្យភាគីបង្ហាញផុសតាងជាឯកសារសំខាន់ពាក់ព័ន្ធទៅនឹងប្រធានបទសវនាការនីមួយៗនិងបានស្ដាប់ការបញ្ជាក់បន្ថែមរបស់សហមេធាវីនាំមុខតំណាងដើមបណ្ដឹងរដ្ឋប្រវេណីស្ដីពីការទាមទារសំណងនៅក្នុងអំឡុងពេលសវនាការនៅក្នុងសំណុំរឿង002វគ្គ2នេះមានសាធារណជនសរុបចំនួន 776,604 នាក់បានចូលរួមស្ដាប់ដោយផ្ទាល់នៅក្នុងសាលសវនាការរបស់អង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាអង្គជំនុំជម្រះសាលាដំបងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានប្រកាសសេចក្តីសម្អាងហេតុនិងផ្នែកនៃសេចក្តីសម្រេចនៃសាលក្រមនៅក្នុងសំណុំរឿង 002/02 ពាក់ព័ន្ធទៅនឹងជនជាប់ចោទនួនជានិងខៀវសំផនកាលពីថ្ងៃទី16ខែវិច្ឆិកាឆ្នាំ2018នៅក្នុងសាលសវនាការធំនៃអវតក
អង្គជំរះសាលាដំបងរកឃើញថាជនជាប់ចោទនួនជាមានបរិបទដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាចន្លោះថ្ងៃទី17ខែមេសាឆ្នាំ1975ដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើនេះនិងដោយលម្អិតនៅក្នុងសាលក្រមជាលិលាអក្សរតាមរយៈអំពើសកម្មនិងអកម្មចំពោះអកតកម្មទាំងឡាយដូចខាងក្រោមអកតកម្មប្រឆាំងនឹងមនុស្សជាតិតាមរយៈការធ្វើនុភាពការសម្លាប់រង្គាលការនិរទេសការធ្វើឲ្យទៅជាសេដ្ឋករការដាក់ក្នុងមន្ទីរឃុំឃាំងការធ្វើទុកបុកម្នេញដោយមូលហេតុនយោបាយការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសនានិងការធ្វើទុកបុកម្នេញដោយមូលហេតុភូមិសាស្ត្រនិងអំពើអនុធម៌ផ្សេងៗទៀតក្រុមទម្រង់ជាការប៉ះពាល់ដល់សេចក្តីថ្លៃថ្នូររបស់មនុស្សអំពើអមនុស្សធម៌ផ្សេងៗទៀតក្រុមទម្រង់ជាការបាត់ខ្លួនដោយបង្ខំអំពើអមនុស្សធម៌ផ្សេងៗទៀតក្រុមទម្រង់ជាការជំនះដោយបង្ខំនិងអំពើអមនុស្សធម៌ផ្សេងៗទៀតក្រុមទម្រង់ជាការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំនិងការរំលោភផ្លូវភេទនៅក្នុងបទបទនៃការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំអនុលោមតាមបទបញ្ញត្តិនៃវិធានមាត្រា5មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់ស្ដីពីការបង្កើតអវតកការបំពេញយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវតាមរយៈការធ្វើមនុស្សភាពដោយចេតនាការធ្វើទរណកម្មការធ្វើបាបដោយអព្យុធម៌ការបង្កដោយចេតនាឲ្យមានរបួសធ្ងន់ឬឲ្យមានការឈឺចាប់ដល់រាងកាយឬសុខភាពការដកហូតដោយចេតនាពីជ្រុយសឹកឬជនស៊ីវិល នៅសិទ្ធិទទួលបានការកាត់ទោសដោយយុត្តិធម៌និងទៀងទាត់និងការឃុំខ្លួនជនស៊ីវិលដែលខុសច្បាប់អនុលោមតាមមាត្រា 6 មាត្រា 29 ថ្មីនិងមាត្រា 39 ថ្មីនៃច្បាប់ស្តីពីការបង្កើតអវតកឧក្រិដ្ឋកម្មបល័យពិសាសតាមរយៈការធ្វើមនុស្សឃាតលើសមាជិកនៃក្រុមជនជាតិវៀតណាមនិងជនជាតិចាមអង្គជំនះសាលាដំបងរកឃើញថាជនជាប់ចោទគឺសំផនមានពិរុទ្ធដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាដោយចន្លោះពីថ្ងៃ 17 ខែមេសាឆ្នាំ 1975 រហូតដល់ថ្ងៃទី 6 ខែមករាឆ្នាំ 1979 ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើអង្គជំនះបានពិចារណាទៅលើភាពធ្ងន់ធ្ងរនៃអក្រិតកម្មរួមទាំងទំហំនិងភាពសាហាវព្រៃផ្សៃក៏ដូចជាចំនួននិងភាពទន់ខ្សោយរបស់ជនរងគ្រោះដែលជនជាប់ចោទត្រូវបានរកឃើញមានប្រសិទ្ធភាពរួមទាំងស្ថានទម្ងន់និងស្ថានដំណើរទោសនានាដែលពាក់ព័ន្ធអង្គជំរះសម្រាប់ផ្ដន្ទាទោសជនជាប់ចោទនួនជាដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាលើការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង 002/01 អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្ដន្ទាទោសទាំងពីរទៅជាការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយអង្គជំរះសម្រាប់ផ្ដន្ទាទោសជនជាប់ចោទគឺសំផនដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាទៅលើការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង 002/01 អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្ដន្ទាទោសទាំងពីរទៅជាការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយ
សាធារណជនប្រមាណជាជាង 700 នាក់រួមមានតំណាងរាជរដ្ឋាភិបាលកម្ពុជាតំណាងអង្គការសហប្រជាជាតិនិងមន្ត្រីអង្គទូតអង្គការសង្គមស៊ីវិលនានារួមនឹងសាធារណជននិងអ្នកសារព័ត៌មានជាតិនិងអន្តរជាតិបានចូលរួមស្ដាប់ការប្រកាសសារក្រមជាប្រវត្តិសាស្ត្រនេះយើងខ្ញុំសូមរំលឹកសាធារណជនថានៅក្នុងដំណាក់កាលនេះបទចោទប្រឆាំងទៅនឹងនួនជានិងឃ្យូសំផននៅក្នុងសំណុំរឿង 002/2 គ្រាន់តែជាការចោទប្រកាន់តែប៉ុណ្ណោះមិនទាន់មានការសម្រេចជាស្ថាពរនៅឡើយទេថាតើជនជាប់ចោទទាំងពីរមានទោសឬក៏គ្មានទោសជនជាប់ចោទទាំងពីរត្រូវបានសន្មតទុកជាមុនថាគ្មានទោសដរាបណាសាលដីកាស្ថាពរមិនទាន់ចូលជាធរមាននៅឡើយជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាដែលគេស្គាល់ថាសាលាដីខ្មែរក្រហមត្រូវបានបង្កើតឡើងដើម្បីឆ្លើយតបទៅនឹងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅចន្លោះថ្ងៃទី 17 ខែមេសាឆ្នាំ 1975 រហូតដល់ថ្ងៃទី 6 ខែមករាឆ្នាំ 1979 ជារយៈពេលដែលប៉ុល ពតកាន់កាប់អំណាចប្រជាជនយ៉ាងហោចណាស់ 1,700,000 នាក់ត្រូវបានជឿជាក់ថាត្រូវបានស្លាប់ដោយសារការធ្វើការងារហួសកម្លាំងការបង្អត់អាហារការធ្វើទារុណកម្មសម្លាប់និងលក្ខខណ្ឌរស់នៅដ៏អមនុស្សធម៌ដទៃទៀតសំណុំរឿង 002/2 គឺជាការជំនុំជម្រះដីទី2ប្រឆាំងទៅនឹងអតីតប្រមុខរដ្ឋខៀវសំផននិងអតីតអនុលេខាបកកុម្មុយនីសកម្ពុជាលោកនួនជាជនជាប់ចោទទាំងពីរត្រូវបានបញ្ជូនទៅជំនុំជម្រះដីកាលពីខែកញ្ញាឆ្នាំ 2010 ដោយសារទំហំនិងភាពស្មុគស្មាញនៃបទចោទនាពេលរស់រានមានជីវិតរបស់ជនជាប់ចោទឬក្នុងពេលដែលជនជាប់ចោទនៅអាចជំនុំជម្រះដីបានដែលការបញ្ជូនរឿងទៅជំនុំជម្រះត្រូវបានបែងចែកជាការជំនុំជម្រះដីចំនួន2ដែលហៅថាសំណុំរឿង 002/1 និងសំណុំរឿង 002/2 ការជំនុំជម្រះក្តីដំណាក់កាលទី1ផ្ដោតសំខាន់ទៅលើបទចោទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិដែលតាក់ទងទៅនឹងការជំនះដោយបង្ខំពីទីក្រុងភ្នំពេញកាលពីខែមេសាឆ្នាំ 1975 និងក្រោយមកគឺមានការជំនះពីតំបន់ដទៃទៀតក៏មានបទចោទតាក់ទងទៅនឹងការសម្លាប់អតីតទាហានសាធារណរដ្ឋខ្មែរនៅទួលពោធិ៍ជ្រៃនៅក្នុងស្រុកកណ្ដៀងខេត្តពោធិ៍សាត់ អង្គជំនុំជម្រះសាលាដំបូងនៃអង្គជំនុំជម្រះវិស្សម័យក្នុងតុលាការកម្ពុជាហៅកាត់ថា OWTK បានរកឃើញនួនជានិងឃីវសំផតមានពិរុទ្ធពីបទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងបានសម្រេចផ្តន្ទាទោសពួកគាត់ដាក់ពន្ធនាគារអស់មួយជីវិតកាលពីថ្ងៃទី7ខែសីហាឆ្នាំ2014
ទាំងការធ្វើមុខជាតិការធ្វើទុកបុកម្នេញ
សហព្រះរាជអាជ្ញាជនជាប់ចោទទាំងពីរបានប្តឹងសារទុកទៅកាន់អង្គជំនុំជម្រះតុលាការកំពូលហើយតុលាការកំពូលបានធ្វើសវនាការរួចហើយតាក់ទងទៅនឹងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង002/01ព្រមទាំងបានស្ដាប់សក្ខីកម្មរបស់ស្ដាប់សី3រូបកាលពីថ្ងៃទី2ទី3និងទី6ខែកក្កដាឆ្នាំ2015នៅថ្ងៃទី16 17 18ខែកក្កដាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលបានធ្វើសវនាការស្ដាប់សារណាផ្ទាល់មាត់លើបញ្ហានានាដែលបានលើកឡើងនៅក្នុងបណ្ដឹងសារទុកនៅក្នុងសំណុំរឿង02វគ្គ01នៅថ្ងៃទី23ខែវិច្ឆិកាឆ្នាំ2016អង្គជំនុំជម្រះតុលាការកំពូលនៃអង្គជំនុំជម្រះវិស្សម័យក្នុងតុលាការកម្ពុជាបានប្រកាសសាលដីការបស់ខ្លួនលើបណ្ដឹងសារទុកប្រឆាំងនឹងសាលក្រមនៅក្នុងសំណុំរឿង002វគ្គ1ដោយបានតម្កល់សាលក្រមរបស់អង្គជំនុំជម្រះសាលាដំបូងផ្តន្ទាទោសនួនជានិងឃីវសំផនដាក់ពន្ធនាគារអស់មួយជីវិតសំណុំរឿង002វគ្គ2ដែលជាសំណុំរឿងបន្តពីសំណុំរឿង002វគ្គ1មានបទចោទជារួមគឺឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងការរំលោភបំពានយ៉ាងធ្ងន់ធ្ងរទៅលើអនុសញ្ញាក្រុងហ្សឺណែវឆ្នាំ1949ព្រមទាំងឧក្រិដ្ឋកម្មប្រល័យពូជសាសន៍អង្គជំនុំជម្រះសាលាដំបូងបានសម្រេចថាទីតាំងឧក្រិដ្ឋកម្មនិងបទចោទសំខាន់ដទៃទៀតខាងក្រោមនេះគឺជាមូលដ្ឋាននៃការជំនុំជម្រះក្តីសំណុំរឿង002វគ្គ2អំពើប្រល័យពូជសាសន៍ទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមការរៀបការដោយបង្ខំនិងការរំលោភសេពសន្តិវៈនៅទូទាំងប្រទេសការបោះសម្អាតផ្ទៃក្នុងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅមន្ទីរសន្តិសុខចំនួន4គឺមន្ទីរសន្តិសុខស21ក្រាំងតាចាន់អូកន្សែងនិងភ្នំក្រោលឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅការដ្ឋានចំនួន3គឺទំនប់1មករាទំនប់ត្រពាំងថ្មនិងការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅសហគមន៍ត្រាំកក់ការធ្វើទុកបុកម្នេញខាងព្រះពុទ្ធសាសនាការធ្វើទុកបុកម្នេញមន្ត្រីសាធារណរដ្ឋខ្មែរកម្រិតត្រឹមសហគមន៍ត្រាំកក់ការដ្ឋានទំនប់1មករាមន្ទីរសន្តិសុខស21និងមន្ទីរសន្តិសុខក្រាំងតាចាន់សវនកម្មលើសំណុំរឿង002វគ្គ2បានចាប់ផ្ដើមដោយសេចក្តីថ្លែងបើករបស់សហព្រះអាជ្ញាកាលពីថ្ងៃទី17ខែតុលាឆ្នាំ2014
អំពើឃោរឃៅមកលើប្រជាជនកម្ពុជាមិនចេះចប់មិនចេះហើយនឹងបាច់មានទ្រង់ទ្រាយកាន់តែធំទៅមិនធ្លាប់មានពីមុនដែលបានបណ្ដាលឲ្យទឹកដីកម្ពុជាពោពេញទៅដោយរដូវសាកសពនិងការបាត់បង់ជីវិតបាត់បង់បងប្អូនសាច់ញាតិនេះគឺជាគេដំណើរដ៏សាហាវពិតដែលបានសល់ទុកឲ្យមេដឹកនាំបកកុម្មុយនីសកម្ពុជាដែលកំពុងអង្គុយនៅចំពោះមុខយើងទាំងអស់គ្នានៅថ្ងៃនេះដូច្នេះយើងសម្រាប់អ្នករាល់គ្នាដែលបានសួរថាតើហេតុអ្វីបានជាពួកយើងត្រូវការសវនាការមួយទៀតនៅពេលដែលជនជាប់ចោទដែលមានវ័យចាស់ជរាបានទទួលការផ្តន្ទាទោសអស់មួយជីវិតទៅហើយនោះចម្លើយគឺសាមញ្ញពួកយើងធ្វើនេះដោយសារប្រជាជនកម្ពុជារាប់លាននាក់ដែលបានស្លាប់ដោយសាររបបមួយនេះក្នុងកំឡុងពេល3ឆ្នាំ8ខែនិង20ថ្ងៃក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យមានតែពួកជ្រាំមានតែសក្តិវិនាសនិងទុកព្រួយមានតែការឈឺចាប់និងសក្តិស្លាប់
ខ្ញុំបានទទួលស្គាល់ថាមានជនរួមជាតិជាច្រើនមានការឈឺចាប់នៅក្នុងរបបកម្ពុជាប្រជាធិបតេយ្យដែលបង្កឡើងដោយពួកបំផ្លាញស៊ីរួមទីក្នុងខ្ញុំសោកស្ដាយចំពោះទុក្ខលំបាកនោះហើយខ្ញុំសូមទទួលខុសត្រូវនៃសិលធម៌ចំពោះអំពើនេះដោយសារខ្ញុំជាមេដឹកនាំជនគមម្នាក់នៃបកកុម្មុយនីសកម្ពុជា
នួនជាបានជម្រាបទៅចៅក្រមថាគាត់បានបង្កប់ឲ្យមេធាវីរបស់គាត់ធ្វើពហិការមិនចូលរួមជំនុំជម្រះក្តីរហូតដល់ពេលវេលាសំណើប្តឹងដិតចិត្តរបស់គាត់ទៅលើចៅក្រមសាលាដំបូងពាក់ព័ន្ធទៅនឹងកំហុសឆ្គងមួយចំនួនត្រូវបានសម្រេចជាមុនសិននៅពេលក្រោយមកក្រុមចៅក្រមពិសេសមួយត្រូវបានបង្កើតឡើងនិងបានច្រានចោលសំណើប្តឹងដិតចិត្តរបស់នួនជា ហើយមេធាវីការពារក្តីរបស់គាត់ក៏បានចូលរួមនៅក្នុងការកាត់ក្តីវិញ
គឺរៀបមុខបញ្ចុះតែនៅចំពោះមុខអង្គជំរះនេះ
ជនជាប់ចោទទី 2 គឺ Khieu សំផតបានជម្រាបអង្គជំនុំជម្រះសាលាដំបូងថាគាត់បានបង្គាប់ឲ្យមេធាវីរបស់គាត់ចង់អារម្មណ៍តែទៅលើបណ្ដឹងសារទុកជាមុនសិនមុននឹងគាត់និងមេធាវីរបស់គាត់ចូលរួមនៅក្នុងការជំនុំជម្រះក្តីនៃសំណុំរឿង 002 វគ្គ 2
កាត់ក្តីសំណុំរឿង 002 លើ 01 អស់លោកបានកាត់ទុកខ្ញុំដោយផ្អែកលើទម្រង់ផតានិងការស្មាននានាដែលខ្ញុំជំទាស់ហើយដោយប្រើមធ្យោបាយដែលខ្ញុំយល់ឃើញថាជាការរំលោភលើសិទ្ធិរបស់ខ្ញុំដែលខ្ញុំត្រូវមានត្រូវបានទទួលការកាត់ក្តីដោយយុត្តិធម៌ហេតុនេះហើយបានជាខ្ញុំបានជម្រាបមេធាវីខ្ញុំឲ្យប្រឹងឧទ្ធរណ៍ដែលនៅក្នុងតុលាការនេះគេហៅថាបណ្ដឹងសារទុកសេចក្តីសំអាងហេតុនិងសេចក្តីសន្និដ្ឋានរបស់អស់លោកនៅក្នុងការកាត់ក្តីនេះបង្ហាញច្បាស់ជាមុនស្រេចទៅហើយអស់លោកនឹងសម្រេចយ៉ាងណានៅក្នុងការកាត់ក្តីសំណុំរឿង 002 លើ 02 ខាងមុខនេះគ្មានអ្វីគួរឲ្យខ្ញុំស្រពេចស្រពិលទេបើអស់លោកនៅតែប្រើរបៀបគិតគូរដែលខ្ញុំជំទាស់ដោយចំពោះមុខតុលាការកំពូលតាក់ទងនឹងការចោទប្រកាន់ថាខ្ញុំបានចូលរួមប្រព្រឹត្តសហអក្រិតកម្មរួមខ្ញុំដឹងជាមុនស្រេចទៅហើយថាអស់លោកប្រកាសជានឹងផ្ដន្ទាទោសខ្ញុំទៀតក្នុងការកាត់ក្តីដែលអស់លោកកំពុងតែបើកនៅថ្ងៃនេះ
នៅអំឡុងពេលនៃសវនាការអង្គជំនុំជម្រះសាលាដំបូងបានស្ដាប់ការបង្ហាញផុសតាងលើប្រធានបទស្ដីពីសហគមន៍ត្រាំកក់រួមទាំងមន្ទីរសន្តិសុខខ្នាងតាច័ន្ទនិងការប្រព្រឹត្តលើពុទ្ធសាសនិកការដ្ឋានទំនុក1មករាការដ្ឋានសាងសង់ប្រលានយន្តហោះកំពង់ឆ្នាំងការដ្ឋានទំនុកត្រពាំងថ្មការប្រព្រឹត្តទៅលើជនជាតិចាមនិងជនជាតិវៀតណាមមន្ទីរសន្តិសុខអូកន្សែងមន្ទីរសន្តិសុខក្នុងក្រោលនិងមន្ទីរសន្តិសុខស21និងការបោះសម្អាតផ្ទៃក្នុងការចេញបទបញ្ជាអំពីការរៀបអាពាហ៍ពិពាហ៍លក្ខណៈនៃចំនួនប្រដាប់អាវុធនិងជាចុងក្រោយអំពីទូនាទីរបស់ជនជាប់ចោទនៅថ្ងៃទី 11 ខែមករាឆ្នាំ 2017 អង្គជំនុំជម្រះសាលាដំបូងបានបិទបញ្ចប់សវនាការលើកផុសតាងនៅក្នុងសំណុំរឿង 002 វគ្គ 2 ពាក់ព័ន្ធទៅនឹងបទចោទប្រកាន់ស្ដីអំពីឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិអំពើប្រល័យពូជសាសន៍និងការបំពានបំពានយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវប្រឆាំងទៅនឹងជនជាប់ចោទនួនជានិងKhieuសំផត
ប្រជាជនកម្ពុជាទូទាំងរបប
អង្គជំនុំជម្រះសាលាដំបូងបានបើកសវនាការធ្វើសេចក្តីសន្និដ្ឋានផ្ទាល់មាត់បិទបញ្ចប់កិច្ចពិភាក្សាដេញដោលនៅខែមិថុនាឆ្នាំ 2017
រដ្ឋវិនិម្នាក់បានផ្ដល់សេចក្តីកម្មអំពីជាសនកម្មដោយ
សូមជម្រាបថាអង្គជំនុំជម្រះបានធ្វើសវនាការរយៈពេល274ថ្ងៃនៅក្នុងសំណុំរឿង 002 វគ្គ 2 និងបានស្ដាប់សេចក្តីកម្មសាក្សីចំនួន 114 នាក់ដើមបណ្ដឹងរដ្ឋប្រវេណីចំនួន 63 នាក់និងអ្នកជំនាញចំនួន 8 នាក់លើសពីនេះទៀតអង្គជំនុំជម្រះបានផ្ដល់ឱកាសឲ្យភាគីបង្ហាញផុសតាងជាឯកសារសំខាន់ៗពាក់ព័ន្ធទៅនឹងប្រធានបទសវនាការនីមួយៗនិងបានស្ដាប់ការបញ្ជាក់បន្ថែមរបស់សហមេធាវីនាំមុខតំណាងដើមបណ្ដឹងរដ្ឋប្រវេណីស្ដីពីការទាមទារសំណងនៅក្នុងអំឡុងពេលសវនាការនៅក្នុងសំណុំរឿង 002 វគ្គ 2 នេះមានសាធារណជនសរុបចំនួន 776,604 នាក់បានចូលរួមស្ដាប់ដោយផ្ទាល់នៅក្នុងសារសវនាការរបស់អង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាអង្គជំនុំជម្រះសាលាដំបូងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាបានប្រកាសសេចក្តីសម្អាងហេតុនិងផ្នែកនៃសេចក្តីសម្រេចនៃសាលក្រមនៅក្នុងសំណុំរឿង 002/02 ពាក់ព័ន្ធទៅនឹងជនជាប់ចោទនួនជានិងKhieuសំផនកាលពីថ្ងៃទី 16 ខែវិច្ឆិកាឆ្នាំ 2018 នៅក្នុងសារសវនាការធំនៃអវតក
អង្គជំរះស្រាដំបងរកឃើញថាជនជាប់ចោតនួនជាមានបរិទ្ធដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាចន្លោះថ្ងៃទី17ខែមេសាឆ្នាំ1975ដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើនេះនិងដោយលម្អិតនៅក្នុងសារក្រមជាលាយលក្ខណ៍អក្សរតាមរយៈអំពើសកម្មនិងអកម្មចំពោះអកតកម្មទាំងឡាយដូចខាងក្រោមអកតកម្មប្រឆាំងនឹងមនុស្សជាតិតាមរយៈការធ្វើនុភាពការសម្លាប់រង្គាលការនិរទេសការធ្វើឲ្យទៅជាសតកការដាក់ក្នុងមន្ទីរឃុំឃាំងការធ្វើទុកបុកម្នេញដោយមូលហេតុនយោបាយការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសនានិងការធ្វើទុកបុកម្នេញដោយមូលហេតុសាសន៍និងអំពើអនុវត្តផ្សេងៗទៀតក្រុមទម្រង់ជាការប៉ះពាល់ដល់សេចក្តីថ្លៃថ្នូររបស់មនុស្សអំពើអនុវត្តផ្សេងៗទៀតក្រុមទម្រង់ជាការបាត់ខ្លួនដោយបង្ខំអំពើអនុវត្តផ្សេងៗទៀតក្រុមទម្រង់ជាការជំនះដោយបង្ខំនិងអំពើអនុវត្តផ្សេងៗទៀតក្រុមទម្រង់ជាការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំនិងការរំលោភផ្លូវភេទនៅក្នុងបទបទនៃការរៀបអាពាហ៍ពិពាហ៍ដោយបង្ខំអនុលោមតាមបទបញ្ញត្តិនៃវិធានមាត្រា5មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់នៃពីការបង្កើតអវតកការបំពេញយ៉ាងធ្ងន់ធ្ងរលើអនុសញ្ញាទីក្រុងហ្សឺណែវតាមរយៈការធ្វើមនុស្សភាពដោយចេតនាការធ្វើទរណកម្មការធ្វើបាបដោយអវិធម៌ការបង្កដោយចេតនាឲ្យមានរបួសធ្ងន់ឬឲ្យមានការឈឺចាប់ដល់រាងកាយឬសុខភាពការដកហូតដោយចេតនាពីជ្រើសឹកឬជនស៊ីវិលនៅសិទ្ធិទទួលបានការកាត់ទោសដោយយុត្តិធម៌និងទៀងទាត់និងការឃុំខ្លួនជនស៊ីវិលដែលខុសច្បាប់អនុលោមតាមមាត្រា6មាត្រា29ថ្មីនិងមាត្រា39ថ្មីនៃច្បាប់ស្តីពីការបង្កើតអវតកឧក្រិដ្ឋកម្មបល័យពិសាសតាមរយៈការធ្វើមនុស្សភាពលើសមាជិកនៃក្រុមជនជាតិវៀតណាមនិងជនជាតិចាមអង្គជំនះសាលាដំបងរកឃើញថាជនជាប់ចោទគឺសំផនមានពិរុទ្ធដែលបានប្រព្រឹត្តនៅលើទឹកដីនៃប្រទេសកម្ពុជាដោយចន្លោះពីថ្ងៃ17ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ដោយបានរៀបរាប់ដោយសង្ខេបខាងលើអង្គជំនះបានពិចារណាទៅលើភាពធ្ងន់ធ្ងរនៃអកតកម្មរួមទាំងទំហំនិងភាពសាហាវព្រៃផ្សៃក៏ដូចជាចំនួននិងភាពទន់ខ្សោយរបស់ជនរងគ្រោះដែលជនជាប់ចោទត្រូវបានរកឃើញមានប្រសិទ្ធភាពរួមទាំងស្ថានទម្ងន់និងស្ថានតម្រូវទោសនានាដែលពាក់ព័ន្ធអង្គជំរះសម្រាប់ផ្ដន្ទាទោសជនជាប់ចោទនួនជាដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាលើការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង002/01អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្ដន្ទាទោសទាំងពីរទៅជាការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយអង្គជំរះសម្រាប់ផ្ដន្ទាទោសជនជាប់ចោទគឺសំផនដាក់ពន្ធនាគារអស់មួយជីវិតដោយពិចារណាទៅលើការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតចំពោះគាត់នៅក្នុងសំណុំរឿង002/01អង្គជំរះសម្រាប់រួមបញ្ចូលគ្នានៅការផ្ដន្ទាទោសទាំងពីរទៅជាការផ្ដន្ទាទោសដាក់ពន្ធនាគារអស់មួយជីវិតតែមួយ
សាធារណជនប្រមាណជាជាង700នាក់រួមមានតំណាងរាជរដ្ឋាភិបាលកម្ពុជាតំណាងអង្គការសហប្រជាជាតិនិងមន្ត្រីអង្គទូតអង្គការសង្គមស៊ីវិលនានារួមនឹងសាធារណជននិងអ្នកសារព័ត៌មានជាតិនិងអន្តរជាតិបានចូលរួមស្ដាប់ការប្រកាសសារក្រមជាប្រវត្តិសាស្ត្រនេះយើងខ្ញុំសូមរំលឹកសាធារណជនថានៅក្នុងដំណាក់កាលនេះបទចោទប្រឆាំងទៅនឹងនួនជានិងឃ្យូសំផននៅក្នុងសំណុំរឿង002/2គ្រាន់តែជាការចោទប្រកាន់តែប៉ុណ្ណោះមិនទាន់មានការសម្រេចជាស្ថាពរនៅឡើយទេថាតើជនជាប់ចោទទាំងពីរមានទោសឬក៏គ្មានទោសជនជាប់ចោទទាំងពីរត្រូវបានសន្មតទុកជាមុនថាគ្មានទោសដរាបណាសាលដីកាស្ថាពរមិនទាន់ចូលជាធរមាននៅឡើយ អង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាដែលគេស្គាល់ថាសាលាដីខ្មែរក្រហមត្រូវបានបង្កើតឡើងដើម្បីឆ្លើយតបទៅនឹងឧក្រិដ្ឋកម្មដែលបានប្រព្រឹត្តនៅចន្លោះថ្ងៃទី17ខែមេសាឆ្នាំ1975រហូតដល់ថ្ងៃទី6ខែមករាឆ្នាំ1979ជារយៈពេលដែលប៉ុល ពតកាន់កាប់អំណាចប្រជាជនយ៉ាងហោចណាស់1.7 លាននាក់ត្រូវបានជឿជាក់ថាត្រូវបានស្លាប់ដោយសារការធ្វើការងារហួសកម្លាំងការបង្អត់អាហារការធ្វើទារុណកម្មសម្លាប់និងលក្ខខណ្ឌរស់នៅដ៏អមនុស្សធម៌ដទៃទៀតសំណុំរឿង002 វគ្គ 2 គឺជាការជំនុំជម្រះដីទី2ប្រឆាំងទៅនឹងអតីតប្រមុខរដ្ឋខៀវសំផននិងអតីតអនុលេខាបកកុម្មុយនីសកម្ពុជាលោកនួនជាជនជាប់ចោទទាំងពីរត្រូវបានបញ្ជូនទៅជំនុំជម្រះក្តីកាលពីខែកញ្ញាឆ្នាំ2010ដោយសារទំហំនិងភាពស្មុគស្មាញនៃបទចោទនាពេលរស់រានមានជីវិតរបស់ជនជាប់ចោទឬក្នុងពេលដែលជនជាប់ចោទនៅអាចជំនុំជម្រះក្តីបានដែលការបញ្ជូនរឿងទៅជំនុំជម្រះត្រូវបានបែងចែកជាការជំនុំជម្រះក្តីចំនួន2ដែលហៅថាសំណុំរឿង002 វគ្គទី1និងសំណុំរឿង002 វគ្គទី2ការជំនុំជម្រះក្តីដំណាក់កាលទី1ផ្ដោតសំខាន់ទៅលើបទចោទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិដែលតាក់ទងទៅនឹងការជំនះដោយបង្ខំពីទីក្រុងភ្នំពេញកាលពីខែមេសាឆ្នាំ1975និងក្រោយមកគឺមានការជំនះពីតំបន់ដទៃទៀតក៏មានបទចោទតាក់ទងទៅនឹងការសម្លាប់អតីតទាហានសាធារណរដ្ឋខ្មែរនៅទួលពោធិ៍ជ្រៃនៅក្នុងស្រុកកណ្ដៀងខេត្តពោធិ៍សាត់អង្គជំនុំជម្រះសាលាដំបូងនៃអង្គជំនុំជម្រះវិសាមញ្ញក្នុងតុលាការកម្ពុជាហៅកាត់ថាអវតកបានរកឃើញនួនជានិងខៀវសំផនមានពិរុទ្ធពីបទឧក្រិដ្ឋកម្មប្រឆាំងនឹងមនុស្សជាតិនិងបានសម្រេចផ្តន្ទាទោសពួកគាត់ដាក់ពន្ធនាគារអស់មួយជីវិតកាលពីថ្ងៃទី7ខែសីហាឆ្នាំ2014ទាំងការធ្វើមុខភាពការធ្វើទុកបុកម្នេញសហព្រះរាជអាជ្ញាជនជាប់ចោទទាំងពីរបានប្តឹងសារទុកទៅកាន់អង្គជំនុំជម្រះតុលាការកំពូលហើយតុលាការកំពូលបានធ្វើសវនាការរួចហើយតាក់ទងទៅនឹងបណ្ដឹងសារទុកនៅសូមអញ្ជើញក្រោកឈរ
សូមអញ្ជើញអង្គុយ
President, please be seated. The chamber is now back in session. And Graffier, can you report the attendance, please? Graffier, Mr. President, Your Honors, all parties are present. Thank you. I would like now to hand the floor to the co-prosecutor to make submissions. The floor is yours. Thank you.
Good afternoon, Mr. President, Your Honours and parties. I'd first like to address the defence's contentions this morning regarding the trial chamber's saisine for killings of Vietnamese. The scope of case 2 is defined by the closing order, which it is for the trial chamber to interpret. The co-prosecutor's submissions during trial are not determinative of that interpretation. As we set out in detail in our brief in response to Ground 60, the trial chamber properly determined its geographic saisine to include killings of Vietnamese nationwide. As appellant concedes, the closing order, in its section on factual findings on the crimes, extensively detailed killings outside Prey Veng and Svai Rieng. It also found that Vietnamese had been killed in other crime sites within the scope of Case 2, such as S21, O Can Seng, and Krang Chishan. The specific sections characterizing genocide, murder, and extermination refer to the treatment of the Vietnamese as a whole and without limitation. In those same sections, the co-investigating judges refer expressly to widespread killings outside the East Zone. The trial chamber's severance decision and annex then also defined the scope of the genocide, murder, and extermination charges in Case 2.2 by reference to the treatment of the Vietnamese without limitation, and referred to all paragraphs in the closing order establishing killings outside Prey Veng and Svai Rieng. I'd now like to move on to address the alleged errors in the trial chamber's articulation of the elements of murder and persecution as crimes against humanity, as well as appellant's claim that the principle of legality was breached by his convictions for other inhumane acts through forced marriage and rape within those forced marriages. I'd first like to make two general remarks. Murder, persecution, and other inhumane acts were all at issue in Case 1 and Case 2.1. This chamber has already conducted an extensive survey of the pre-1975 law and jurisprudence to arrive at detailed and considered findings on their elements. It did so having reviewed and rejected many of the arguments that appellant now raises, and nothing in this appeal gives reason to reverse those decisions. Second, many of appellant's arguments regarding the status of the law in 1975 confuse the facts of specific cases with elements of crimes. Simply because a more stringent actus reus or mens rea existed in the facts of some of those cases does not make that the legal test. Where there exists sufficient evidence of courts accepting a lower threshold, and especially in the absence of any contrary jurisprudence, customary law is settled. Turning first to murder committed with a dolus eventualis mens rea, and specifically appellant's allegation that this crime did not form part of customary international law in 1975. As your honours pointed out, its customary status, accessibility, and foreseeability were conclusively settled by this chamber in Case 2.1. This chamber demonstrated that in the medical case, the US tribunal at Nuremberg convicted on the basis of a dolus eventualis mens rea. Appellant has provided no case law in which an accused was acquitted because of this mens rea, and we can also confirm that we know of none. As such, customary law was settled. There was therefore no requirement for the trial chamber or this chamber to establish a general principle of domestic law, since there was no lacuna in customary international law. However, as an extra safeguard, both chambers confirmed their conclusion that direct intent is not required. That conclusion is consistent with national legal systems. After the trial chamber added jurisdictions to this chamber's already extensive findings, it confirmed that the evidence was so prolific that a general principle in fact existed. In our brief, we provided yet more examples. There is no doubt that as at 1975, almost uniformly, states accepted a definition of unlawful killing that included knowingly and willingly engaging in conduct likely to cause death. And contrary to appellant's contentions, the trial chamber correctly applied the dolus eventualis mens rea. It simply expressed its findings in a number of different but equally correct ways. It held that the perpetrators acted with the knowledge that conditions would likely lead to deaths, in the acceptance of the possibility of this fatal consequence, or with manifest indifference to human life. These articulations appear in the judgment both conjunctively and disjunctively, and the Supreme Court chamber has already confirmed that each one individually satisfies the mens rea. In reality, each necessitates the existence of the other. For example, if you act in the knowledge of the likelihood of death, then you have accepted the risk. Similarly, to accept the risk of the possibility of a fatal consequence, you must know about that possibility first. I now turn to appellant's claim that the actus reus for murder was not satisfied because the trial chamber allegedly based its findings on culpable omissions without identifying a duty to act. To be clear, what the chamber actually found was that the actus reus was fulfilled by the imposition of conditions at the work sites and cooperatives that caused the victim's death, and by the absence of appropriate measures to change or alleviate those conditions. So, what the appellant characterises as an omission, the absence of appropriate measures to change or alleviate the conditions that the DK authorities themselves imposed, is not an omission at all. It's simply another way of saying that the authorities continued to impose life-threatening conditions, i.e., they continued their positive acts. In any case, even on his own argument, appellant fails. Given the direct perpetrators were the very people who imposed the conditions, it's clear that they were in a position to change or alleviate them. And thus, as the IC2Y appeals chamber in Celavici explained, they had a duty to do so. Moving now to persecution. I'll look first at the actus reus, and specifically appellant's challenges to the trial chamber's findings concerning the Buddhists, Cham and Vietnamese based on so-called indirect discrimination. This describes a situation where a policy or law applies to everyone, but adversely affects a group that share a protected characteristic. Appellant incorrectly alleges that this does not constitute discrimination in fact, because CPK policies applied to every Cambodian citizen, and the concept of indirect discrimination did not exist in law in 1975. This chamber has already demonstrated that appellant's position is flawed. In the Case 1 appeal judgment, it surveyed the pre-1975 law extensively and held that an act or omission discriminates in fact where there are actual discriminatory consequences for members of a group, or where the victim is targeted because of his membership of a group. By his argument, appellant distorts the essence of what the crime of persecution is fundamentally about. Persecution is about being harassed, oppressed, or otherwise made to suffer because of who you are, because you belong to a particular group. So if a victim endures discrimination because he's Buddhist or Cham, it's irrelevant that all religion was outlawed by the CPK. If the Cham were forced to eat pork or otherwise face starvation, they are suffering a special harm not experienced by the general Khmer population, specifically because of their religion. What matters is the effect of the policy, not its wording. And this understanding of discrimination existed well before 1975, as demonstrated by the conventions and jurisprudence cited by the civil parties in their brief. It's noteworthy that no less than 3 advisory opinions from the Permanent Court of International Justice in 1923, 1932, and 1935 concluded that in order to be effective, the prohibition against discrimination has to ensure the absence of discrimination in fact as well as in law. They explained that equal treatment of groups whose situations and requirements are different can result in inequality in fact. Turning now to the mens rea and appellant's ground 94. Nothing in the law of this tribunal, any of the post-World War II jurisprudence, or indeed the ad hoc tribunals, supports appellant's position that the mens rea of persecution required more than an intent to discriminate on one of the defined grounds. It certainly did not require an objective to remove persons from Cambodian society or from humanity. Again, this chamber confirmed this in case 1. And again, appellant confuses facts and law. Persecution can, and often does, escalate over time, resulting in the intent to remove individuals from society. On the facts of many cases at all the international tribunals, this is precisely what happened. But that doesn't make it part of the legal test. This morning, Defence Counsel referred extensively to the Nazis' discrimination of the Jews. Post-World War II tribunals often found that Jews had been persecuted through acts that did not demonstrate any intention to remove them from society or to exterminate them. And we described some examples in our brief. And specifically, in their analysis entitled Persecution of the Jews, the International Military Tribunal at Nuremberg explained the distinction and the escalation very clearly, and I quote, "With the seizure of power," and that was in 1933, "the persecution of the Jews was intensified. A series of discriminatory laws was passed, which limited the offices and professions permitted to Jews. And restrictions were placed on their family life and their rights of citizenship. By the autumn of 1938, the Nazi policy towards the Jews had reached the stage where it was directed towards the complete exclusion of Jews from German life." Finally, other inhumane acts. I'll dispense very quickly with appellant's contention in ground 97 that the crime is neither accessible nor foreseeable unless the underlying act has been criminalised by international or national laws. Not only has this been debated and debunked by every ECCC chamber and the ad hoc tribunals, but appellant himself makes sufficient admissions to demonstrate that it was both accessible and foreseeable that he could be convicted of other inhumane acts in 1975. He accepts that the residual other inhumane acts category was a crime in 1975, and that its content would be ascertained using the Eastum generis rule. Put another way, he knew that he could be held criminally responsible for conduct that was both inhumane and of a similar nature and gravity to the listed crimes against humanity. I'll address ground 98 equally briefly. In the Case 2-1 appeal judgment, the Supreme Court chamber introduced what it called a formal international unlawfulness test as an extra safeguard to ensure compliance with the principle of legality. This chamber explained that this requires relating other inhumane acts to conduct infringing basic rights appertaining to human beings, as identified under international legal instruments. And that is exactly what the trial chamber did. What this chamber did not require was for each exact factual scenario to have been predicted and prohibited in international instruments, as the appellant alleges. Not only is there no legal difference between rights and prohibitions in human rights law, but to do what appellant is asking would defeat the very purpose of other inhumane acts as a residual category. I now have a few remarks about appellant's challenges to the trial chamber's findings that the DK forced marriages and forced consummations constituted other inhumane acts. These involve mixed questions of fact and law. I'll just address the legal aspects of appellant's submissions raised in grounds 160, 171 and 172, and my colleague Ruth Mary Hackler will discuss the facts. Appellant misunderstands the law on other inhumane acts. As I said, to adhere to the principle of legality, the trial chamber was only required to find, and did find, that the conduct was of a similar nature and gravity as the list of crimes against humanity and violated the victim's basic human rights. Forced marriage undoubtedly violates human rights that were already set out in international instruments before 1975. The trial chamber chose the example of the most fundamental, the 1948 Universal Declaration of Human Rights. Appellant is wrong to claim that this wouldn't suffice on its own, but it doesn't need to. He pretends that a wealth of human rights conventions endorsing the freedom to marry simply don't exist. A more exhaustive list is in our response, but I'd like to just give you a couple of examples. Cambodia acceded to the Supplementary Convention on the Abolition of Slavery in June 1957. At Article 1, the parties agreed to outlaw practices, including those whereby a woman, without the right to refuse, is promised or given in marriage on payment of consideration. Then in 1962, the Convention on Consent to Marriage, Minimum Age for Marriage, and Registration of Marriages confirmed that no marriage should be legally entered into without the full and free consent of both parties. As to the second requirement, whether forced marriage is of the same nature and gravity as the enumerated crimes against humanity, Ms. Hackler will address you on the forced marriage practice in the DK. I'll just make two brief points. First, by reference to judgments from the Special Court of Sierra Leone and the ICC, the trial chamber showed that other tribunals have formed the view that in principle, forcing individuals to marry is of the same nature and gravity. This was confirmed again in the recent ICC trial judgments in Ongwen. Second, I would like to dispel some myths put forward by the appellant regarding patterns of domestic criminalization of forced marriage by 1975. Aside from the fact that domestic criminalization is not part of the legal test for other inhumane acts, his assertions are factually inaccurate. He paints a Eurocentric picture of forced marriage criminalization beginning in the 21st century. To build on this characterization, he asserts that Asian, and particularly ASEAN countries, which have various types of arranged marriage practice, accepted forced marriage as a cultural norm. By doing so, he grossly distorts the true global picture, which was in fact rapidly recognizing that the criminality of forced marriage was in place well before the DK regime. In our response, we cited 7 jurisdictions that had criminalized forced marriage as such by or during the DK period. With the benefit of further research, we can now add the Bahamas, Cyprus, Malaysia, and the US state of Oklahoma to that list. We explained that 20 more framed criminalization by reference to abduction or detention for the purpose of marriage. We can now add England, New Zealand, Samoa, the Australian states of Tasmania and South Australia, Kiribati, Brunei, the US states of Nevada and California, and the Cook Islands. What's more, it was precisely those countries with traditions of arranged marriage that led the charge. Appellant invited you to put ASEAN countries under the microscope, and we welcome that invitation. Out of the 10 ASEAN countries, the majority had criminalized conduct constituting forced marriage by 1975. My final remarks concern appellant's position that conviction for other inhumane acts through forced consummations was not foreseeable in 1975. Where the victims were female, the trial chamber found that these acts constituted rape. Now, as we're in the realm of other inhumane acts, the chamber did not need to adhere to a legal definition of rape, but as a descriptive term, rape is of course correct. Again, the trial chamber simply needed to find that the forced consummations A, violated a basic right, and B, reached the required gravity threshold. We acknowledge that the trial chamber omitted to articulate the first requirement, but submit that it did so because the answer is so obvious. In fact, at every other modern tribunal, and indeed in Control Council Law Number 10, rape is an enumerated crime against humanity. I refer your honours to our response for further references to international law condemning rape. I should be able to stop there, since the position is so clear. But appellant argues that non-consensual intercourse within the confines of marriage was perfectly acceptable in 1975. In doing so, he invites you to find that he could not possibly have foreseen criminal conviction for forcing thousands among Cambodia's population to marry against their will and then compelling them into sexual intercourse, often with a stranger and often monitored by militia, on fear of severe punishment, including death. His position is untenable. Rapes within the legitimate consensual marriage, whilst themselves foreseeably criminal, are a far cry from the situation we have here. First, there could not possibly be any presumed consent in these circumstances. The man was not the rapist. He was another victim forced by the CPK to inflict intercourse upon the woman to produce children for the regime. In fact, there's no fundamental difference between CPK policy and the enforced prostitution of both parties. The prohibition on enforced prostitution, upholding the right not to be forced into sexual intercourse without free and full consent, was expressly laid out in several international conventions by 1975 and has since been confirmed in the statutes and jurisprudence of the ICTY, the ICC, and the SCSL. Second, the only reason the so-called marriages existed was because they were forced upon the victims in the hours and days preceding the rapes. A defendant cannot use his own criminal act to legitimize another crime. In recognition of this, both the SCSL and the ICC in Ongwen have entered criminal convictions for sexual violence in the context of forced marriages. In fact, as we explained with detailed citations in our response, it was a general principle of law and wholly foreseeable in 1975 that a forced marriage was not a legal marriage and could not possibly provide a technical loophole for the DK regime's heinous campaign of sexual violence. I shall now pass the floor to my colleague Nisha Patel.
Good afternoon, Mr. President, Your Honors. The appellant's convictions for 8 crimes against humanity are each based on several instances that occurred throughout the DK. We address his challenges to the crimes in detail in sections 7C, D, and E of our written response. Today, I will discuss some of the appellant's erroneous challenges in regard to enslavement, murder, and persecution of the new people. Then, my colleagues will speak on the treatment of targeted groups and the regulation of marriage. Turning first to enslavement, civilians were exploited for the CPK's benefit, not only at cooperatives and work sites, but also during their unlawful detention at security centers. People were reduced to mere commodities as they were forced to work pursuant to a regulated schedule in a climate of fear and control. The appellant's ground 133 fails to show that there was insufficient evidence to establish enslavement at Phnom Kraul Security Center. He ignores evidence at K-17 and Phnom Kraul Prison because he assumes his ground 48 on Sezin will be upheld. Regarding K-11, this morning he advanced a new argument on appeal that the trial chamber erroneously found Kul Nem was detained at K-11. His mere disagreement with how the trial chamber interpreted Kul Nem's testimony in paragraph 3093 of the judgment, and his disregard of other evidence before the trial chamber regarding what K11 was used for demonstrates no error. In paragraph 3029 of the judgment, the trial chamber explained that K11 was a temporary detention and re-education facility. K11 prisoners were from Division 920 of the CPK's military, including Kul Nem, and this is paragraph 3063 of the judgment. Kul Nem told the trial chamber that people in his division were being accused of being enemies of the CPK. He said he was sent to K11 as a punishment. In relation to the same ground, the appellant's complaint in his appeal brief is also made with regards to the trial chamber's use of Mul's WRI. Your honors have held that the right to examine a witness is not absolute. WRIs can be used for evidence, including where, as here, the declarant is deceased. The evidence concerns the crime base rather than the appellant's acts and conduct, and it corroborates live testimony. Moreover, contrary to the appellant's assertion, WRIs are not of inherently low probative value. They have been obtained by impartial co-investigating judges with appropriate safeguards to ensure reliability. I next turn to murder with dolus eventualis at the cooperatives and work sites. The crime was based on evidence that enslaved civilians in a coercive environment were forced to achieve unreasonable work quotas by undertaking arduous manual labor, day and night, without adequate rest, food, and medical treatment. These dire working and living conditions had an individual and cumulative impact, resulting in deaths from sickness, malnourishment, exhaustion, and/or work injuries. In grounds 101, 116, and 117, the appellant's piecemeal reading of the trial judgment fails to demonstrate insufficient evidence of murder with dolus eventualis at the tram cooperatives and 1st January Dam work site. For example, evidence that at least 6 to 10 workers died from conditions at 1st January Dam is supported by evidence discussed in paragraphs 1535, 1626, and 1627 of the trial judgment, not only paragraph 1629 as he contends. Similarly, the direct perpetrator's mens rea for those deaths is discussed in at least 10 paragraphs of the judgment, not just the 2 that he identifies in his appeal. These paragraphs thoroughly demonstrate that the perpetrators observed and received information on both the dire conditions and their consequences on the workers, yet they accepted the risk of deaths when they maintained those conditions and instructed laborers to adhere to CPK work plans. In grounds 102, 113, 117, and 123, the appellant misreads the trial chamber's findings for all the cooperatives and work sites, claiming the chamber never identified when the mens rea of the direct perpetrators was formed. Throughout each site's period of operation, dire conditions were imposed and maintained. The moment the direct perpetrators imposed those conditions, they knew deaths were likely. And when the deaths did occur, they continued to maintain dire conditions, demonstrating their acceptance of the likelihood of deaths. Any external factors that the appellant raises as contributors to those conditions are irrelevant because the mens rea existed in relation to their voluntary criminal acts. In ground 132, the appellant shows no error in the trial chamber using SOC L's WRI together with other relevant evidence to find a prisoner was murdered with dolus eventualis at Phnom Kraal Security Center. Sufficient counterbalancing factors were in place for the trial chamber to fairly and properly assess the reliability of the evidence that SOC L gave before he died and could testify. First, the evidence was taken in proper form by the OCIJ and it was under oath and audio recorded. Second, his evidence on the conditions at the security center was corroborated by 4 live testimonies and other OCIJ interviews. And third, the appellant was given the opportunity to challenge those conditions at trial, which he does not dispute. Based on a holistic evaluation of the evidence, the appellant fails to show it was unreasonable to find that a prisoner had died from dire conditions. In any event, if the trial chamber erred in finding the crime proven, the error would not invalidate the appellant's conviction for murder. His conviction is based on several murders throughout the DK, not only the murder at Phnom Kraal. Finally, I turn to the persecution on political grounds of the New People at the Tramcot Cooperatives, 1st January Dam, and Trapang Tama Dam. In grounds 107, 114, and 118, the appellant would like your honors to believe that the New People could not be discriminated in fact because they were treated the same as the rest of the enslaved population. He further trivializes the discriminatory acts against the New People at each site by disregarding a broader persecutory policy towards them, which the trial chamber found was in line with the CPK's policy on the treatment of real or perceived enemies of the regime. That persecutory policy implemented a classification system that made the New People politically and economically inferior to people from the poor and lower middle peasant classes who had politically clean biographies. The latter became known as the base people and were given full rights, which allowed them to hold positions of power or oversight at cooperatives and work sites. Another aspect of this persecutory policy involved CPK instructions to refashion, arrest, and smash the New People. Accordingly, the New People experienced a range of discriminatory acts. At the Tramcot Cooperatives, this included being screened, segregated from the base people, made to work harder, and given less food than others. At 1st January Dam, it included being monitored by the militia, susceptible to accusations of wrongdoing, arrested, and never seen again. At Trapang Tama Dam, students and intellectuals were targeted for arrest and execution, and these acts were carried out. In sum, regardless of how others were treated, the New People were subjected to targeted acts because they were New People, whom the CPK perceived to be enemies, and therefore were discriminated in fact. This concludes my submissions, and I will now give the floor to my colleague, Mr. De Wild. Thank you, Your Honors.
Monsieur le Président.
Mr. President, the honorable judges, concerning the treatment of specific groups. In the 11 minutes that I have, I will raise the questions raised by this chamber in its report and discuss other essential questions and respond to the arguments of the defense as they were presented this morning. The defense did not really respond to your written question concerning the torture of the sham detainees in Khieu. The trial chamber correctly concluded in 3317 and 18 that torture existed given the specific description given by Ipsam concerning the manner in which the Ipsam had been beaten repeatedly in order to obtain information concerning the fact that they belonged to the Cham group. In what way is the chamber right, and is the defense not in fact working on the basis of an error of fact? There is international jurisprudence that a chamber may indeed rely on a single witness to establish fact. Also in 1380, it was shown that the methodology that was followed was to follow meticulously the various elements that were brought up by a single person. Thirdly, the testimony of Itsen is partially corroborated by those of two Cham, Maxor and Nodsates, who were also asked whether they were Cham or Khmer in the same center, triage center. Also, the appellant simply repeated its challenging of the credibility of Ixen. The chamber rejected this in a motivated fashion in its judgment, paragraph 3280. Finally, the defense wrongly claims that the testimony is contradictory because he said on the one hand that the members of his group had been beaten to determine whether they were Muslim, and on the other hand that the torturers already knew that they were Cham. As a matter of fact, it's more than probable that the authors of the torture already knew that they were Cham, since according to what Ixen said during the hearing, this group of persons had been taken in Cham villages of Famville and Soy, and once they came to Chia, they were treated and called liars and beaten even more so when some of them replied that they were Khmer. The fact for the perpetrators to beat them deliberately in order to obtain confirmation that they were Cham is not in of itself contradictory and is not sufficient to establish an error of fact. Above and beyond this question of torture as practiced in the security center of Tria, the main underlying argument of the appellant is that the trial chamber should not have concluded to the existence of a policy of the CPK involving the perpetration of crimes intrinsically linked to the common project. Concerning the real or hypothetical enemies, amongst them the Cham, but also former leaders of the Khmer Republic and Buddhist leaders and others. However, the 45 grounds for appeal that have been brought to us will fail because the appellant has not assessed fully and thoroughly the terms, and because he has either superficially or wrongly interpreted the order, or that these grounds of appeal contained errors or misrepresentation. As for the chamber sufficiently motivated the fact that the CPK created a criminal policy targeted at the Cham, implying measures that placed this group in jeopardy. It has also concluded that the party systematically attempted to assimilate the Cham to the Khmer by imposing the suppression of Cham cultural and religious practices throughout the entire country. The chamber also felt that, or concluded rather, that at the end of 1975 they were forcibly transferred in order to separate and disperse them, and that later on they were systematically arrested, detained, and exterminated en masse simply for being Cham. The appellant abstained from considering the totality of the evidence. For instance, he ignored contemporaneous official documents, including Telegram 15 sent by Sokbim to Pol Pot on 30 November 75 after the Chan Rebellion, and showing that the policy against the Cham was established by the party's center. The appellant also ignored the depositions of numerous witnesses and civil parties, excluded the testimony or distorted the testimony and the use made by the Chamber of Pranyut, who was the former secretary of the Kompong Chem district in Sector 41. The testimony of Prakyut is an essential element because it affirmed, along with other district secretaries, including that of Kwan Mia, had received from the sector leadership of the zone the requirement to establish lists and prepare certain groups for execution, and she admitted that she had organized such regroupings and killings on these orders. And she stated, and I quote, "The order that I received was clear. It consisted in executing all the Cham," end quote. As for the Vietnamese, the chamber rightly concluded that the CPK leadership had evolved a criminal central policy targeting them for prejudicial treatment and opposition to the common project. And the chamber concluded it was not a coincidence that the Vietnamese were treated as the hereditary enemies throughout the entire country, and that they were identified by way of lists, biographies, and denunciations prior to their systematic deportation or arrest and execution. The chamber relied, amongst other things, on the rules of the Democratic Kampuchea to identify the Vietnamese group as being distinctive and protected, and by establishing that the executions of Vietnamese were in effect attributable to the CPK leadership. The appellant made use of a partial approach, forgetting the hateful speeches saying that they refer to the entire population of Vietnam and not only to Vietnamese military in armed conflict. On 15 April 1978, Khieu Samphan publicly called for the need to make aggressive enemies of all kinds disappear throughout the country, and more specifically the Vietnamese ones, in order to, and we quote, protect the Cambodian race. Concerning genocide by murder, my colleague Rain Wordsworth said that the charges contain sufficient elements for the trial chamber to reasonably consider that this extended to the entire national territory of the country, and not only Prince Sang and Sang Ring. And it is not correct to affirm that the assertion of the chamber is based exclusively on the testimony of Sin Chem, which concerns only 4 families. And the crime of genocide by murder also concerns for hundreds of Vietnamese killed in S-21 and in Kon Sum. And the chamber also established sufficiently that the crime of genocide was established and implemented as part of the national policy of the party in various other parts in the country on the basis of recurrent and systematic measures. And the best illustration that genocide and persecutions exercise against civilian and non-combatant Vietnamese, and that civilians, including children and the elderly, who represented no threat whatsoever to the regime, were being treated as enemies and executed like all other Vietnamese in S-21 at sea and elsewhere in the country, including Bat Sat in the northern zone. The appellant also omitted large excerpts of Mit Vern's testimony, who affirmed during the hearing that all Vietnamese, whatever their status or their age, were considered to be enemies, and that, and I quote, we have received instruction that the Vietnamese had to be crushed because they had not returned to their countries. So I'll go a bit beyond my time, but I would like to come back to Sin Chem's testimony, which the defense tried to attack this morning, and in its Appeal 152. It pretends not to see the entire testimony as well as the fate reserved for all Vietnamese in the context of a central policy which aimed to kill them in Cambodia. Though it is correct that Sin Chem did not directly witness the execution of the 4 families in question, including newborns, nevertheless there are specific elements which leave no doubt that these families were indeed killed. And I will take the liberty of repeating our response to the appeal of the defense on this point, paragraph 598. Let us judge the following elements. Sin Chem knew these families prior to 1975. She had lived near them and worked with them. More important, she saw these Vietnamese with their hands tied behind their backs. The persons who witnessed the arrest also reported the fact that they had disappeared and been executed. The head of the municipality himself said that the wives and the children of mixed marriages were taken away and killed. Sin Chem saw the bodies of a family, including children, in a rice paddy, and she was told that they had been killed the night before. And Sin Chem was also aware of the fact that Vietnamese from other villages were being executed. The chamber therefore reasonably considered that given the context and the accuracy of the testimony, the only reasonable conclusion was that the members of these 4 families had indeed been killed. To conclude on the grounds for appeal, they must fail because they demonstrate no error of fact or law. I now give the floor to my colleague Rosemary Backward, who will need 11 minutes to speak to you about forced marriage and rape. Thank you for your attention.
Today, I'll focus on 2 of the issues mentioned in Your Honor's report. First, I'll discuss the appellant's claim that there was no policy to force people to marry and consummate their marriages. Then I'll turn to his dispute with the trial chamber's finding that during the DK regime, consent to marry was absent. These and his specific evidentiary challenges are also addressed in Section 7D of our written response, as well as in the civil party's written submission. None of Khieu Samphan's arguments establish any error that would warrant intervention. Before I go further, it's important to note that in her submissions this morning, defense counsel misstated the intent element for the other inhumane acts test, saying it required an intent to cause serious suffering. That's not the test this chamber articulated in paragraph 580 of the Case 2-1 appeal judgment. That standard requires that the act must have been performed intentionally, and it must have caused, but not intended, serious suffering or a serious attack on human dignity. This misapprehension of the standard seems to have influenced some of appellant's national policy arguments. As Your Honors know, during the DK regime, CPK officials exercised absolute and total control over every aspect of people's lives. Nothing was off limits, including their most intimate acts. The policy that regulated marriage had 2 components. The first dictated whether, when, and whom people married. The second coerced them to have sexual intercourse with their new spouse. Just like with other CPK policies, any refusal or opposition to either component could be met with harsh consequences. As a result, most people didn't dare to object. The finding that forced marriages and forced sexual intercourse within those marriages were part of an intentional CPK policy was based on extensive evidence, not on a selective and biased assessment as the appellant alleges. As the civil parties noted yesterday, the judgment shows the chamber carefully considered potentially exculpatory arguments and testimony. But these were outweighed by evidence that the highest levels of the party intentionally created the policy, issued instructions down the chain of command, and the lower levels carried them out, all to support the rapid implementation of the socialist revolution. The strongest piece of evidence showing that the policy emanated from the upper echelon was E3/775. This was the family building policy document that was so important it was published twice in the party's Revolutionary Youth magazine. The document emphasized that in terms of choosing a spouse, Ankar's decisions prevailed over personal choice. I quote, "In the matter of building a family, no matter the outcome of the organization's and the collective's assessments and decisions, they must be absolutely respected. Do not have hard feeling. Do not be disappointed. This is because only the organization and the collective are able to make a thorough assessment from every aspect," end quote. Speeches and statements from senior leaders also confirmed that marriage and the consummation of marriage would facilitate the party's goals. In one speech, Pol Pot said that to effectively defend and build the country by leaps and bounds, the current population of nearly 8 million people was far too small to achieve the country's full potential. That required more than 20 million people. He then announced, "Therefore, our aim is to increase the population as quickly as we can." Also advocating for a rapid increase in population were Khieu Samphan, Yang Suri, and the party's propaganda magazines. Now, the appellant doesn't dispute these statements. Instead, he argues that the CPK wanted to increase the population by improving people's living conditions, and marriages were arranged for the needs of the people. Now, the chamber considered these arguments, but they were debunked by a wide range of evidence showing that marriages were organized for the benefit of the revolution, not the people. Witness Chuan Ti testified that Pol Pot told cadres at a meeting in Kampong Chhnang that weddings should be organized since they needed the population. Civil Party Chia Deep also gave evidence of a meeting in which the appellant instructed the ministries to arrange marriages for all male and female youths so they could produce children and there would be more forces to defend the country. Instructions regarding the policy were systematically disseminated to the lower levels for implementation. At least 7 former Khmer Rouge cadres gave evidence that cadres across the country were informed in meetings and training sessions of the upper echelon's marriage directives. Nationwide, men and women were matched and forced to marry in collective ceremonies. Of course, forcing them to marry was only one component of the policy. Numerous civil parties and witnesses gave evidence that at the wedding ceremonies, presiding officials conveyed to the couples that they were expected to have sex to produce children for Angkar. To ensure that they did, militiamen monitored the newlyweds and reported to their superiors about the couple's nighttime activities. More than 20 witnesses and civil parties were cited on this issue in judgment paragraphs 3641 through 3646. When authorities discovered a couple hadn't had sex, various consequences followed. These included physical intervention, summoning and threatening the couples with death, sending them for re-education, and even disappearance. The appellant alleges that any marriages or consummations that were forced were the result of cadres who failed to correctly apply the party line, not a result of national policy. But forced marriages and forced sexual intercourse took place throughout the regime. Now, the chamber noted there were some variations in the details of implementation, but practices across the country were so fundamentally similar, they couldn't be explained as coincidence or as the result of rogue officials. They could only be explained as part of a systematic, centralized policy from the highest echelon. In light of all these considerations, the trial chamber's finding that there was a CPK policy that forced people to marry and consummate their marriages to produce children for Ankar was reasonable and should be affirmed. Turning to the issue of consent, appellant wrongly argues that marriages weren't forced because consent was a marriage principle adopted by the CPK. Legally and factually, this doesn't withstand scrutiny. Legally, a consensual decision is a decision made without force, threat of force, or taking advantage of a coercive environment. Consent imports a notion of personal autonomy. When someone in a coercive environment doesn't voice refusal because they fear violence or detention, it cannot be interpreted as genuine consent. Factually, although the trial chamber found that consent was in fact part of the party's marriage principles, it also found that in practice, the pervasively coercive environment of democratic Kampuchea rendered genuine consent impossible. Any attempt to conflate marriage practices before and during the regime disregards the incessant threat of violence and actual punishments meted out to those who refused to marry. People couldn't freely object because they justifiably feared being labeled an enemy and the severe consequences that could follow. As for the consent that couples were required to express at wedding ceremonies, that was an empty formality. To survive, couples didn't have to mean it. They just had to say it. That's not genuine consent. Even in cases where cadres or soldiers were allowed to request marriage to a woman of their choosing, Ankar's decisions took precedence. The men still had no control over whether to marry, and if the proposal about who to marry was consistent with the collective interest, Ankar approved it. But
ខាងហបរិយាចិត្តចប់នៅហើយលឺហត់អស់5-7 នាទីហើយ
Okay. When the proposed wife was approved, she still had no say in the matter and risked harsh consequences if she refused. In short, none of the appellant's arguments show any error that would warrant overturning the finding that genuine consent was absent in marriages during the DK period. Thank you, Your Honors. I'll now yield the floor to the civil parties.
I
would like to inform the parties, please respect the time allocation. You can probably exceed a little bit of the time allocation, otherwise we will cut you off. And now I'd like to hand the floor to the legal lawyers to make your submissions. Thank you.
Good afternoon, Mr. President. Good afternoon, Your Honours, and good afternoon again to the parties. We will divide our time in this afternoon's session. Pik Ang will address issues concerning the regulation of marriage. I had intended first to respond to some points which were raised by counsel for the defence before the lunch break, concerning in particular the scope of the case regarding the treatment of the Vietnamese, persecution and genocide, but those matters have been covered so comprehensively by the Office of the Co-Prosecutors, and I don't want to duplicate their submissions. So I'm going to say simply that we agree with the points that have been made on those issues, although of course we also stand by our written submissions in our response brief. I'm going to focus on 3 topics in the time that I will take this afternoon. Firstly, some general points concerning factual grounds of appeal raised by the defence. Secondly, the legal framework for the crime against humanity of other inhumane acts. And thirdly, how that framework applies to conduct involving enforced disappearances. I'd like to emphasise, as others have already done, that focusing on these topics doesn't imply that we diminish the importance of other arguments in our response brief. There are so many crimes covered by this case, and of course all of those crimes are very important to the civil parties who experienced them. But since our time is limited today, we will need to focus on just a few issues, and therefore we've chosen some which we believe is particularly important to clarify or highlight. So considering first the question of the defence's factual grounds of appeal. There are very many of these in the defence's appeal brief, and of course each of them will ultimately have to turn on its own merits. But there are some common weaknesses which can be identified again and again throughout the factual grounds. The key one is that very often the factual grounds do not appear to address the correct standard of review on appeal. It often appears to us as though the defence is simply arguing the merits of the evidence, attempting to demonstrate a reasonable doubt. But clearly we are no longer at trial, and therefore that is no longer the appropriate standard. To succeed on a factual ground on appeal, the appellant must show that the finding is one which no reasonable trier of fact could have reached. That standard is a high one, and it's a standard which Khieu Samphan himself cites in paragraph 22 of his appeal brief. But despite that, he frequently seems to revert to simply disagreeing with the trial chamber's conclusions, but without demonstrating that those conclusions are unreasonable. That failing is compounded by a second one. Many of the defence's factual grounds are premised on a misunderstanding of the applicable rules of evidence. And both of these failings are clearly demonstrated in the defence submissions about the killing of Vietnamese people. The consistent evidence throughout this case was that in various places, Vietnamese people were identified and separated from Khmer people, that they were taken away, and that they were never seen again. On the basis of that evidence, Khieu Samphan was convicted of the crimes against humanity of murder, extermination, and genocide. The defence attempts to attack the evidence about these events as being hearsay. And we heard this argument made again today. But those arguments from the defence misconstrue the concept of hearsay and its relevance. I'll give it as an example the testimony of civil party Prak Duan, who we've dealt with in our response brief at paragraphs 301 to 303. He described the process by which all of the mixed Vietnamese Khmer families in his location were identified and then made to march. He described the point at which the Vietnamese members of the group were separated, including his wife, mother-in-law, and child. And he described the fact that none of those persons were ever seen again. Now, on the question of whether those Vietnamese people were killed, it is true that it is hearsay when Prac Duan testified that his unit chief had told him that the Vietnamese people had been smashed. But the rest of his evidence was not hearsay. He testified about his own personal observations of his family members being identified as Vietnamese, taken away, and never seen again. In any event, Your Honours, while hearsay may be treated more cautiously than other evidence, there is no prohibition on its use in international trials. The defence position, taken to its logical conclusion, seems to be that where killings are alleged, a trial chamber requires eyewitness evidence in order to conclude that those killings occurred. That position is at odds with common sense. Where mass killings are organised in this way, there are often no survivors who can testify about their experiences. In this case, only one Vietnamese civil party was able to give that kind of evidence. Civil party Chung Yang Chet, who's discussed at trial judgment paragraphs 3468 to 3469, was taken from Da village along with his family and all the other Vietnamese people there. They were tied up and they were made to walk to a location in a forest. And one by one, they were hit with an axe and pushed into a pit. By chance, Chung Yang Chet did not die. And only as a result of that, he was able to give eyewitness evidence of his experience. But his evidence also helps to make clear exactly why this kind of evidence is so rare. Where killings are committed in this way, there would usually be no surviving eyewitnesses other than those persons who committed the killings. Demanding an eyewitness account would also run counter to international case law, such as that which was referred to by the trial chamber in paragraph 628 of the trial judgment. The ICTY trial chamber in Kerneyelach and the ICTY appeals chamber in Kinvoka and in Ptolemia ruled that in order for a trial chamber to find beyond reasonable doubt that persons had been killed, it is not necessary to have identified a corpse, and nor is it necessary to have an eyewitness to the killings. Citations to those cases are in our table of authorities. The ICTY chambers in those decisions said that inferences could be drawn, for example, from the following types of evidence: patterns of mistreatment, the disappearance of other individuals, the length of time which has elapsed since persons disappeared, and the fact that those persons had not been in contact with people they would have been expected to contact, such as their family members. Those are precisely the kinds of evidence that the trial chamber had before it regarding the killings of the Vietnamese. I've mentioned Prac Duan already. Another example is civil party Uch San Lai. He's discussed in our response brief at paragraphs 304 to 307. He described how he was sent away to pick bamboo along with other men from his village who were also married to Vietnamese women. When they returned, the men, they were told by the cooperative chief that their family members were gone and that they had performed a great service to Angkar by cleansing themselves and ridding themselves of rotten flesh. Uchsan Lai saw other people in his cooperative wearing his family's clothes, and he never saw his wife and children again. Now, yes, this evidence can be described as circumstantial. It is true that nobody gave evidence of seeing those killings occur. But the only reasonable inference available to the trial chamber was that those Vietnamese people had been killed. The defence has raised no possible basis for contending that the trial chamber's conclusions were unreasonable. Now, I've been speaking until now about the defence challenges concerning the killing of Vietnamese people, but the same kinds of problems arise throughout Khieu Samphan's factual grounds of appeal. Evidence is attacked on an unconvincing basis, and the defence asks for findings to be overturned simply because it disagrees with them, but without coming close to demonstrating that those findings are unreasonable. We saw a further example of that this morning concerning civil party Khul Nem, and I want to agree with what my colleague from the OCP said on that. Again, it was a question of a factual finding made by the trial chamber that this civil party had been detained at K11. The trial judgment sets out the trial chamber's reasons for that finding at paragraph 3093, and the trial chamber explained its reasons for finding that Khul Nem was forced to engage in hard labour at paragraph 3104. Now, the defence may disagree with those findings, but they are clear, they are reasoned, and they were open to the trial chamber on the evidence before it. They are not unreasonable. We ask the chamber, we ask your honours, to apply the standard of review on appeal rigorously. Factual findings must stand unless it can be shown that no reasonable tribunal could have reached them. And I want to move on now to some observations regarding the legal framework applicable to the crime against humanity of other inhumane acts. Before making our submissions on disappearance and the regulation of marriage, it's important to be clear about what the legal framework is of this crime. And our key point is this one. The crime against humanity of other inhumane acts has three specific elements. They're set out in paragraph 580 of the Case 2-1 appeal judgment, and we've referred to them at paragraph 520 of our response brief. The elements are these. Firstly, a gravity element, an act or omission of similar seriousness to other crimes against humanity which existed at the relevant time. Secondly, a suffering element. The act or omission caused serious mental or physical suffering or injury, or constituted a serious attack on human dignity. Thirdly, the mens rea requirement. The act or omission was performed intentionally. I'm reiterating these elements as simple as they may seem because confusion has repeatedly crept in regarding this crime. And that's because instead of simply applying these three elements, there has sometimes been a tendency to want to look at subcategories of conduct and treat them as a substitute for the three elements I've just identified. I'm going to call that the subcategories approach. That approach centres around the idea that the elements to be looked at are not the elements of other inhumane acts per se, but rather a defined subcategory of conduct such as enforced disappearances, forcible transfer, or forced marriage. We can see this approach sometimes reflected in parts of the defence appeal brief, and I'm going to come back to that. But I want to remark firstly that we can also see this approach in some places in the trial chamber's judgment. For example, in paragraph 727, setting out the legal framework, the trial chamber said that it would refer to constituent elements of the conduct in question. And in paragraph 754, it goes on to set out the so-called elements of the crime of the conduct of enforced disappearances, listing them as firstly a deprivation of liberty, secondly a refusal to disclose information, and thirdly involvement of the state. And then throughout the judgment, when analysing disappearances, the trial chamber repeatedly applied those three elements: deprivation of liberty, refusal to disclose information, involvement of the state. It did that, for example, at paragraphs 1200 to 1203, 1425 to 1426, 1840 to 1843. Now, for the most part, this does not constitute an appealable error. And that's because the trial chamber went on to additionally apply the correct three elements of other inhumane acts, satisfying itself that they were made out. So there was no impact on the outcome. The one exception to that is the subject of the prosecution appeal concerning forced sexual intercourse experienced by men, which I won't touch on today. But the broader principles are relevant to all of the conduct which was charged as an other inhumane act. When the trial chamber used the subcategories approach in case 2.1, Your Honours ruled that that approach was incorrect. At paragraph 589, the appeal judgment explains that the only issue of relevance is whether the conduct in question actually fulfilled the definition of other inhumane acts. Now, to clarify 2 points. Firstly, we don't say that it's impermissible to use a shorthand to refer to the conduct we're speaking about. When we speak about other inhumane acts through forced marriage or through enforced disappearances, we're using a generic term to summarise a whole range of conduct. And that's permissible. The phrase is only a convenient shorthand. It is not itself a legal characterisation with elements which need to be met. Secondly, we don't say that it is never relevant to look at other crimes against humanity when analysing the elements of other inhumane acts, or that it is never relevant to look at what other courts have said about the suffering caused by certain types of conduct. This can be done, but ultimately these are only analytical tools to assist in analysing the evidence with a view to answering the three fundamental questions about the elements. Was the conduct grave enough? Was the conduct such as to cause serious suffering? Was the conduct intentional? The elements remain the same: gravity, suffering, intention. And with that in mind, I want to turn to my final topic, which is the conduct referred to throughout this case as enforced disappearances. And in line with the submissions I've just made, I want to emphasise that I use that term enforced disappearances as a shorthand for the conduct in question, and that we need to bear in mind, of course, that this conduct was charged as the crime against humanity of other inhumane acts. In several places in his appeal brief, Samphan challenges the trial chamber's findings regarding enforced disappearances, but seems to do so based on a misunderstanding of the relevant elements of the crimes as they were charged. In fact, because the conduct was charged as other inhumane acts, the question at trial was whether the conduct met the three elements: gravity, suffering, intention. And when we're speaking of the suffering element in relation to disappearances. It's important to note that this is not only the suffering of the person who was disappeared. The trial chamber explained this clearly in its findings concerning Phnom Krau's security centre at paragraph 3164 of the trial judgment. Inmates were subjected not only to the unexplained disappearances of their fellow prisoners, but were subjected to an environment of uncertainty and fear of themselves being removed from the security centre to a destination and fate unknown. As to those family members, friends, acquaintances, and fellow inmates of those who were abducted, it is clear that no closure or definitive explanation was afforded to them in the nearly 40 years following their disappearances, leaving them to speculate about their ultimate fates or to conclude on the basis of limited information and common narratives that these people had been sent to their deaths. The suffering of those who remained but observed the people around them disappearing was also experienced at work sites and cooperatives. Civil party Yem Kani testified about seeing her mother and the rest of her family members taken away from Tramcop cooperatives on a truck, along with many others, never to be seen again. She testified about her suffering, quote, "I did not know what happened to them or what their fate was, whether they were sick or they were sent somewhere. Because of that, I became ill," end quote. That's at E1/287.1 after 1549. So an important part of the suffering caused by this conduct is the suffering experienced by family, by community members, by fellow prisoners who were left not knowing what had happened to the disappeared persons. Now, I mention this because it's very clear from this that in order for Khieu Samphan to be convicted, there was no need for the fate of these disappeared individuals to be proved. We did not need to know for certain whether they were killed or whether perhaps they were detained, forcibly moved, and subsequently died. That is irrelevant to the elements of the offence which is charged. In fact, to the contrary, part of the suffering caused arose precisely because the fate of these individuals was not known. Despite this, Khieu Samphan attacks some of his convictions concerning disappearances on the basis that the fate of the disappeared people was not proved. For example, in ground 135, at paragraph 888 of the appeal brief, he challenges his conviction regarding disappearances from Phnom Krau's security centre on the basis that evidence given by former prisoners about the possible fate of other prisoners who had disappeared was hearsay. Aside from again being a misapplication of the concept of hearsay, the argument misses the point. The trial chamber was not making a finding about the fate of those disappeared people. The trial chamber was able to make findings about the three elements of other inhumane acts without knowing the fate of the disappeared individuals. The evidence of the other prisoners was enough to demonstrate the gravity of the conduct, the terror which those other prisoners experienced as a result of the disappearances, and therefore their suffering. Khieu Samphan repeats this error in ground 111 at paragraph 756. There he argues that the trial chamber could not convict Khieu Samphan in respect of Vietnamese people disappeared from Tram Coc district, and he points to the trial chamber's conclusion that Vietnamese people were, quote, deported and or disappeared. That's in paragraph 1201 of the trial judgment. The argument seems to be that the use of the and or shows that the fate of these individuals was not known beyond a reasonable doubt. We say again, their fate did not need to be proved. And in ground 127, at paragraphs 837 to 840, Khieu Samphan falls into the subcategories error. There he argues that those who had disappeared from their communities in Tram Kok could not later be disappeared from Krang To Chan Security Centre. He says that the crime of enforced disappearances is a continuing crime which cannot be committed twice in respect of a single person. But that conclusion is based on applying the elements of a standalone crime of enforced disappearances, which did not exist in 1975, and in respect of which Khieu Samphan was not charged or convicted. So once again, it's also necessary to recall that disappearances caused suffering not only to the person disappeared, but also to those around them who were terrorized as a result. It was entirely possible for this to occur first for family and community in the Tram Kok cooperatives, and then later for fellow prisoners at Krang To Chan. The common error in all of these grounds is a failure to define the crime correctly by the elements of other inhumane acts: gravity, suffering, intention. Where those elements are applied correctly, there is no doubt that the crime of other inhumane acts was made out in respect of disappearances for large numbers of people from Tram Kok District, Phnom Krau Security Centre and Krang To Chan Security Centre, as well as from other locations. And Khieu Samphan's convictions for those crimes should be upheld. That concludes my submissions, and I'll pass the floor to Pik Ang, who will be addressing the regulation of marriage.
President, we should take a short break to allow the technical team to change the DVD first. President, you may now resume. Pik Ang, President, Your Honors, representatives of the OCP, representatives of the defense team, of the accused, rather, civil parties and the public. I am Pik Ang. I would like to submit to the court concerning what has been raised by the defense team, that the court did not correctly consider the forced marriage. I would like to raise 3 points. Number one, about legality. Number two, about the consent. And number three, about the severity of the act and also the suffering of the victims and the civil parties. The defense team for Khieu Samphan mentioned that it is not the crime, and we cannot distinguish between the forced marriage and rape in it. And since there is no rape within the family, that is why forced marriage does not exist. I would like to indicate that the law of the Cambodia before the Democratic Cambodia, particularly the Penal Code of 1956, stipulates this particular issue. And it also states that it is rape. Article 443 states about this issue, and there is no exception between for wives and husband, and there is nowhere it mentioned on the issue. Article 443 mentioned that anyone, it means that anyone who rape another person shall be punishable. There is no exception here. For the issue that whether or not there was a law stating about the rape by the spouse, the defense raised a number of legal issues, and the co-prosecutor has mentioned already. To save the time, I will not repeat what has been mentioned by the co-prosecutor already. Another one is about the arranged marriage, and the marriage arranged by the Democratic Cambodia was the same. On this particular point, the defense, the defense raised that the arranged marriage was not a crime, because in the past, parents arranged marriage for their children, and Angkar was replacing the parent roles. I would like to indicate that I would like to mention the legal framework of Cambodia, particularly the civil law. Article 124 mentions the definition of marriage. It is the solemn declaration that the partner would live together. That is the agreement between the man and woman to live together. There is nowhere in the civil law states about there shall be the consent and agreement by the parents, or the parents cannot force the children to get married. But there is exception for the minors. That the minors shall have the agreement and consent from the parents. As I have stated, there's nowhere in the civil law stating about the consent by the parents. There's one more point the defense mentioned about the fact that it is the arranged marriage is the Cambodian culture, and the Angkar played the role as the parents. This is not acceptable. We cannot compare between the culture and the arranged marriage. For the word culture, it is not the culture or tradition to force the children to get married. It was simply just the practice, rare practice in the past before the Democratic Cambodia, and we cannot consider that this is the culture of Cambodia, that parents can force children to get married. And in addition to this, so what is the difference between the culture and forced marriage? in Cambodian culture, parents are the guardian taking care of children. They love children. And parents usually take care of the happiness of the children. When there was forced rape or in the marriage, the parents would not be happy, and marriage is the value for Cambodian people. The women and men usually they want to have the marriage celebrated officially and in a good way by their families. It is not the marriage, the forced marriage that they want. So marriage is also to show the dignity for the families. After taking control of the country, Angka robbed the property, belongings, and houses. And also, Angka robbed the guardian's power and authority. In addition to that, Angka required the couple to consummate their marriages, and if the female did not agree, Angka forced the males to rape the women, and if there was objection, disappearance or death would happen. And militiamen went to eavesdrop and to listen secretly during the night time after marriages. So this is not the culture. This kind of culture does not exist in Cambodia. The defense team mentioned as well that there is no evidence showing the disagreements of the couples. I would like to bring to your honor attention a number of points. As we could see, a climate of fear was created during the regime. There was no consent agreement, but only a climate of fear, and the couple forced themselves to get married and also to live as husband and wife. I would like to bring an example to your attention, Chum Samun. Chum Samun mentions that she was threatened. She was threatened that if she did not agree to marry, she would not have any man for her life partner. And if Angka saw her smiling at someone, she would be killed. For Pripsakuan mentioned that if anyone fails to obey Angka order, they would be killed like animals. She was threatened that she would either be put into prison or be killed. This is mentioned in E1/48/7.1. Likewise, civil party GDF mentioned that after a few times of objection, refusal, she was sent to work elsewhere, and she realized that she could no longer refuse to get married. For Momwon, civil party Momwon spoke of being raped by a group of cadres after she refused to marry. A few days after she was raped, she agreed to get married, and she said, I had to get married because I was born in Sweden, and I was threatened that if I would speak out, I would be killed. So, in order to survive, for the sake of my children, I had to marry, despite my fears. For Gideon mentioned that she had sexual intercourse with her husband because she was afraid of committing moral misconduct. This is mentioned in E1/466.1. She indicated that she was monitored and she was afraid both of her husband and the militiaman. She added that people disappeared because they committed moral offenses. I have never heard of the word moral misconduct, and for those who committing misconduct, then they would be disappeared. And regarding the statement testimony of Kazumi Nagagawa testified that people were aware that refusal may have resulted in their deaths. Therefore, many people did not dare to refuse. This is mentioned in E1/472.1. Your Honors, TC found that the overwhelming majority of the evidence shows that people could not refuse to marry without suffering consequences. Because people were afraid, because everywhere in democratic Cambodia had the same threatening climate. For the question whether the forced marriage is related to severity of crime, the defense mentioned that it was not about the severity of the crime. And I would like to submit to the courts that this is the crimes against humanity under the Inhumane Act. I would like to mention the testimony 9. He stated that he was worried because of the because he was threatened to get married. He could not eat, and he stated that he agrees to get married because he wanted to survive and to see the world. This is the severity that we could not accept. The civil party Khieu Thierry also testified that she was so terrified when speaking to the one who came to ask her about the marriage. She was shy and she was ashamed to speak about the sexual intercourse. This indicates the feelings, the sufferings of the victim who were forced to get married. The civil party Suspal mentioned about her suffering as well. She had the fiancé, and he has the fiancé and wanted to get married with his fiancé. He had suffering because he could not get married with his fiancé. Civil party Prasokuan mentioned that I was forced to get married and forced to have sexual intercourse that I did not agree. I had pain and suffering in my heart, and I have physical pain as well. The civil party asked why Angka arranged us to get married, and why Angka required us to get married to those whom we did not love. Pan Sokchan was forced to get married even before she reached puberty. And after the marriage, she was tied to a pole and to allow her husband to rape her. She was so painful. At the time, she did not reach puberty yet, and she was raped. She had a bleeding after she was raped for a period of 1 month. Mr. President, I would like to ask for 3 more minutes if you are allowed. President, yes, please. Thank you very much, Mr. President. For other issues, the defense mentioned that the trial chamber did not thoroughly consider the suffering of the civil party. I would like to submit to your honors that the defense team might have seen only the partial evidence or the partial testimony of the civil party. The defense should have looked all the context or the testimony of the civil party. Civil party no one. For civil party no one, the defense said that she or he had no significant suffering because of the marriage. The defense team may have overlooked the testimony and may ignored what was said by civil party Mom 1. Mom 1 stated that she was ashamed because of her marriage. She was so afraid that she would be killed if she refused to marry. For civil party Va Lam Hon, in the written record of the interview, the civil party stated that she would be killed by the authority or the cadre. That is why she agreed, she forced herself to get married and forced herself to live with the husband. Likewise, civil party Ms. Saran, in the document E3/9 736, she stated about her suffering. For Mike Gruen also stated about the suffering, the forced marriage, that the marriage that he or she was forced to marry at the time. Your Honors, the assertion of the defense teams that the chamber fails to consider the elements of forced marriage is not reasonable. It is the error by the defense team, and the defense team did not thoroughly consider all the issue. And there are established elements as mentioned by the co-prosecutor, and I would like to submit to the chamber that it is also stated in the legal framework of Cambodia. Forced marriage has the prejudice against the victims. It has impacted on the victims' rights, and it should be considered as the crimes against humanity in the form of inhuman acts. Thank you very much, Mr. President. President, because we are now reaching the break time, I would like to call for the break, and we will come back at 50 past 3.
សូមជើញក្រោកឈរ
President, please be seated. Now I'd like to invite judges on the bench to put questions to a party. If you have any, the floor is opened.
I have to think about how I'm going to phrase this question. It's directed to all of you, really, because Ms. Gise mentioned it, and then all of you addressed it in some way, but it's a concept that I never thought of. Forgive me if I don't repeat it as eloquently as you did, but my understanding is that you said something that certainly attracted my attention, and that is that when a court is considering whether certain conduct reaches the gravity of crimes, of other crimes against humanity, other inhumane acts, that when you're doing that, when a court is doing that, that the court has to also consider the principle of legality. Now, each of you touched on that a little bit, but I really would like you to help me on that, and then perhaps if the other parties want to come in. Is that what you were saying, that it isn't enough to look at the gravity of the crimes and the suffering and to see if it measures up to other identified crimes against humanity, but you also have to consider the principles of legality, because after all, the court is considering the offense in 2021, whereas the conduct occurred in the 1970s. Did I make myself in any way clear?
Madame le juge Clark, vous n'aviez pas indiqué.
Your Honor, you did not specify which party should be the first to respond to your question. However, since we were the first to raise this issue, so as I said at length today, we do say that the principle of legality must also be considered in the context of the residual categories of other inhumane acts. It's an important aspect. The principle of legality concerns, in fact, all the crimes, all the types of crimes that are relevant to Trial 2.2, where Khieu Samphan is appealing today. The principle of legality is one that he emphasizes, especially because we must refer to the system of law applicable at the time of the facts for which he is being prosecuted. Thank you.
Good afternoon, Your Honour. Yes, I mean, we agree, obviously, that the principle of legality applies to all the crimes under consideration. As far as other inhumane acts specifically is concerned, I think we submit that the questions to whether it was criminal in and of itself in 1975 is not in dispute. So far as the underlying acts are concerned, as we mentioned in our brief and has been said today, they themselves do not have to have been criminalized. And if I can refer you to your statement from the Case 2-1 appeal judgment, you said that the principle of legality as a whole, so including foreseeability and accessibility, would be respected if the specific conduct which is found to constitute other inhumane acts violates a basic right of the victims and is of a similar nature and gravity to the other enumerated crimes against humanity. So you mentioned gravity in your question. In assessing gravity, you are taking part in the legality assessment we submit.
Khieu, does anybody else?
Your Honour, I'm not certain there's very much I can add to what's already been said by my colleague from the OCP. We agree with the approach, and it's set out in our brief at paragraphs 520 and following, that the correct approach is the one that was set out by Your Honours in the Case 2-1 appeals judgment. And really the essence of that approach is to say that the concept of legality is built into the elements of crimes against humanity, other inhumane acts. And particularly the first element requires that an assessment is made as to whether the conduct we're looking at is similar in its nature and its seriousness to other crimes against humanity which existed at the relevant time. So by going through that process and dealing with that element, the requirement to protect potential accused persons in respect of crimes which are foreseeable, that's already built into the elements of the offence.
Thank you. And I have a question relating to marriage. In the appeal brief by the Defense Counsel, they have made a number of submissions in relation to marriages, and they claimed that the marriage that took place during the Democratic Cambodia regime was on a voluntary basis. It was not coercive, and that it was the principle of the Communist Party of Cambodia. And now I'd like to get a further clarification from the defense on the principle of a voluntary basis, as what kind of condition that this principle was applied and from when. I have heard the submissions by the co-prosecutors as well as from the lead co-lawyers for civil parties that they rejected this principle on the voluntary basis. So based on the argument raised by the defense, can you mention as when that principle was put in implementation, that both parties, before they got married, did they have a chance to do so voluntarily? This is because the parties themselves mentioned that they did not even know the other side for their marriage. So how could this principle be applied when they mentioned it? Thank you.
Monsieur le juge.
Your Honor, I shall give you a two-pronged answer. First of all, on the question of the policy, the principle is that we don't speak of a policy regarding marriages, but regulations. That is what we clarified in our appeals brief. We mentioned a number of texts from the CPK period. Amongst these, you have the 12 moral principles which predate the DK period, and these were the principles that were inculcated into members of the CPK, and this included the principle of consent of both the possible spouses before marriage. This principle was mentioned by several Kader witnesses. The chamber decided that this principle of consent was not real. The principles, as mentioned in the revolutionary flag, were not based on fact, yet they were consistently mentioned by cadres or non-cader witnesses, saying that this principle was very often mentioned in witness testimony on the marriage issue and outside the marriage issue. They were solemn commitments in collective ceremonies where the future spouses would take each other in matrimony and would love each other, and to make this commitment before the whole community. So that's on the issue of regulation of matrimony, of marriage. Now, on the other issue, did people know each other or not? Well, there was a whole very varied gamut of experience. We have never said that there were no cases of marriages that were not wanted by the people concerned. Some people mentioned their personal experience in this respect. The real question is, was there a policy of the CPK to organize forced marriages? And it seems that no, it was not part of the regulation. Now, based on the different witnesses heard by the chamber, I cannot from memory tell you about all these witnesses, but I can mention the different paragraphs starting from 392 on these issues, saying that there were encounters that could be organized between people of the same age group. There were witnesses who explained that there were groups of women, groups of men in the cooperatives, and so meetings for them were organized so that they could meet and get acquainted. There was a variety of types of experience, and amongst that great variety, we find an element that is important. Indeed, it is that diverse variety of experience from one place to another, from one group of people to another, that shows that there was no unified policy for forced marriage. There was a regulation that was enforced in different ways across the country. It's important to stress this. And another important point in our appeals brief is that in paragraph 1296 to and the following ones, we tried to produce some kind of statistics to understand when we are looking at the evidence strictly related to only forced marriage. You have witnesses who come up and say that yes, they were forced to get married, and sometimes it was done with great violence. And I can take an example that was mentioned earlier by the prosecution and the civil parties in reference to the case of Monbun, the civil party, I think that's the one I have in mind, who says that she was raped by a caterer because she was refusing to get married. For us, that is the quintessential example that shows that there was an absolute violation of the marriage regulations that required consent of the two parties, and whereby also rape was absolutely prohibited and very much frowned upon by the Khmer Rouge. I would like to recall in this connection that when we discuss in our brief the regulations on marriage, the issue of surveillance that was mentioned by certain witnesses and civil parties, explaining that it was not an order from the leaders to do so. On the contrary, it was frowned upon and it could be sanctioned. There was the testimony of Duik, who said that one particular caterer, Tang, who was thereafter arrested, had tried to go and watch a couple and was therefore punished. So that's an example that enables us to look at this in perspective and to show that there's a whole diversity of experience. What the Chamber considered to be a policy is in fact what we consider to be a shift from the regulation on marriages. Thank you.
But
President, if there are no more questions and other parties do not wish to add further, I would like now to adjourn the hearing, and we will resume tomorrow at 9 a.m. The security guard are instructed to bring the accused back to the detention facility and bring him back at 8:45. Co-prosecutor, do you need to answer the question in addition to what you have just stated?
Thank you, Your Honor. Yes. We'd just like to add, there's no requirement that experiences must be perfectly uniform for the trial chamber to conclude that conduct meeting the elements of the crime remains criminal. In addition to that, as we know, a lot of the Khmer Rouge propaganda, they would say one thing, that we're going to honor the principles of having courts that try people and observe the rule of law. But what actually happened in practice was very different. So you could have something on paper, but in practice that wasn't followed through. Thank you, Your Honors.
Mr. President, please allow me to add and respond to what the defense team mentioned about Mom Wan. Mom Wan was raped by one individual. It was stated that 5 people raped her. Actually, she was punished by raping And the militiaman punished Mom Went because of her refusal by raping her, and she refused to get married, and afterwards she was raped. President, what about other parties? Do you wish to add anything else? Mr. President, number one, I would like to note what has been mentioned by my colleague concerning the forced marriage. A forced marriage is part of a crime falling within the category of other inhumane acts. In relation to the policy of the Democratic Cambodia, forced marriage is a kind of punishment for those who violated the order. I can say rape is one type of the punishment. The Democratic Cambodia did not support the category to commit the rape, and I believe that the chamber has made clear already about this matter. And as for the regulation, the practices were not the same in different regions, and also against the couples, as mentioned by my colleague. So, different practices, it has nothing to do with what is in the paper and the real practices. I believe this happened in all societies. So what is written in the paper, there may be differences between the practices and what is stated in the paper. As we can see, in the past, the practices was different from the present time. In the past, the exchange of information was in difficult situation, and it is different it is different now. For now, we have Telegram, we have the system for our communication. So what is important, we need to consider the policy in principle. If the policy prohibits all not to commit the bad acts, that is the policy itself that we need to consider for the practices of individual that concern those individuals themselves. So it will be the responsibility of the cadres in charge. Anti-Gisnes, my colleague, mentioned already about the issue of bunk, and the chamber may be aware well of this matter. Thank you very much, Mr. President. President, now the chamber adjourned the hearing for today, and we will resume at 9 a.m. tomorrow. The security guards are instructed to bring the accused back to the detention facility, and please bring him back to the courtroom at 8:45 a.m. The court is now adjourned.